Your Lordship, thank you. Order. Your Lordship has been pleased to pass this order.
Yes. What do you want?
I want that this matter be listed. Be listed in June 20.
All right, hand over the slip.
Yes.
Inclusions, motions, please hand over the slip.
As a contested application.
Contested, Mr. Mohito, please wait. Contested.
Oh, then motion.
No, it's directed to be appear as contested application. Contested application for the present I am not accept because
My Lord, might have your Lordship indulgence.
yeah, appreciate.
My Lord.
Only one thing. Extension of interim order. Please hand over the slip indicating when it is expiring. Please wait. Applications. Enlistment. Please hand over the slip. Upgradations. Please hand over the slip from the monthly list. Motions only. Mr. Kormakar, it's difficult. Please hand over the slip. I will consider.
Upgradation, my Lord.
Upgradation motions. Please hand over the slip from the monthly list.
My kindly.
Please indicate the urgency, Mr. Chattopadhyay.
Kindly consider, my Lord, because my Lord, I'm unfortunate husband.
Yes, yes, I will go through those slips. Yes. What do you want? Upgradation? Yes. No, it is appearing. Then don't mention. Mr. Mukherjee, further upgradation, further fixing is not possible. No, no, you have said that it has been upgraded in the supplementary list.
Upgradation.
So you want upgradation? Upgradation, I have said hand over the slip. Yes. Yes. Yes, hand over the slip. Yes. Contested, Mr. Mohito, please wait. Let me see the motions you have seen. Yes.
Inclusion. Motion inclusion.
Inclusions, motions, I have said hand over the slip. Please hand over the slip. Motions.
I have to mention one. Lordship, for release, Mr. Shaunak Bhattacharya is appearing on the other side.
For releasing.
One for correction. Or correction of order.
To be mentioned.
May I be permitted to mention one for inclusion this contempt application?
Contempt application. I have said applications. Please hand over the slip.
Lordship, may I be permitted to mention? Lordship, on direction of the Honorable Lordship, copy is served and the contested new motion. Nobody has
contested application. Please wait.
Lordship, kindly consider under
please
the
wait. Contested application. Please wait. Upgradations. Please hand over the slip. Indicate the urgency. That's it's not possible in that way. Please indicate the urgency. Please hand over the slip. I will consider. Today it cannot be taken up.
Lordship, inclusion of a hearing matter, my lord. Inclusion.
What is the urgency, Mr. Sir? Section 24 alimony. Transfer. I do not have determination, I think. All right, hand over the slip.
Lordship,
oh. Why tomorrow? All right.
Lordship, a hearing matter, my lord.
When it is going to expire? Please ascertain that. Yes.
I give to mention, for observation, item number 72 and 78 of the Lordship.
Yes, 70.
72 and 78, your Lordship.
Yes, what do you want?
I want upgradation, your Lordship.
72 and 78. It's appearing in the supplementary list, no further upgradation.
Matters have not been taken up, your Lordship.
Please wait. Yes.
Hearing matter may it be taken up at the earliest, Lordship. The arbitration proceedings, Lordship, the witness action is.
It's appearing in the supplementary list.
For the hearing, the matter is not appearing. The
contested application.
Lordship, no affidavit has been filed, Lordship. The hearing.
Affidavits are not filed. What is the direction to appear under contested application? Please wait.
Lordship kindly allows it. Tomorrow they will be mentioning for extension of interim order. May I be permitted?
You appear tomorrow, then I will consider. Yes. Suit is not maintainable. Expeditious, no urgency. Yes. Next. Yes, Mr. Chaudhary.
My lord, under compelling circumstances, I am troubling your lordship. I understand my junior had mentioned it twice. But tomorrow is the arbitration. The learned arbitrator had, my lord, rejected an application for amendment of statement of claim where, my lord, the bank guarantee in question, my lord, turned out to be fraudulent. And it was rejected on the ground that the arbitrator does
It's
not.
appearing in the list.
No, my lord, it's not appearing, my lord. We were enjoying, I won't say an interim order, but an understanding that the arbitrator will not take it up. My lord, tomorrow is the date. My lord, we had mentioned it before when my lord was not there, my lord. The learned judge was pleased to record they would seek adjournment, and my lord, so far it was going on. But tomorrow, my lord, it has been fixed.
It's
my lord.
appearing in the monthly list. No, it's not
No, no,
appearing.
no.
All right, hand over the slip. Yes, Mr.
Move it, anytime convenient to your lordship, post
So
of
that's-
this.
What's the urgency, Mr. Vadajaji?
Possession will be taken, on the 13th, despite there being a complete.
Possession under what?
Surfacing position. Surfacing position. Now, there is a second.
RPC proceedings, DRT is there.
I will satisfy your lordship, there is a coordinate benches order, which obliges the DRT to look into the matter, after first taking into.
When is the date of taking possession?
13th. May
13th.
13th on 12th, any time convenient to the.
12th করে দিন।
Lordship,
Yes.
Lordship, during urgency of the CO application, the other side has taken an advantage and paying adverse order against me in the subordinate court below. And
You have mentioned just now.
I have just mentioned it's a contested application, Lordship. to do
Contested, I
what,
have
sir?
told you, please wait, sir. If all of you want contested, I do not have any difficulty. The motions cannot be taken up. For me personally, I do not have any difficulty. Unnecessarily adding the list will not help you. Please see the motions, the number of motions, and it's been mentioned for upgradation.
If salary
It is
attachment is they have paid for my salary attachment, and the maintenance order was passed on the frivolous and false submission, false
All right, hand
statement.
over the slip. Yes.
Item number 54 of the.
Upgradation. No, that cannot be done. If you want upgradation, please hand over the slip.
Trial court is.
Please, sir, please hand over the slip. Indicate the urgency.
Very much.
Please indicate the urgency. Hand over the slip. I have to look into that. All the slips. Yes, Mr. Chakur.
Pilot has heard it. It was returnable as motion on 10th July. It could not be taken up, my lord. 12th is the date for deciding their 7th application. My lord. If this could be taken up, my lord,
It's appearing in the list.
monthly list, my lord. 170.
So please, for upgradation, you want upgradation. Please indicate the urgency. Hand over the slip.
My lord, may I have your lordship's leave, my lord, to mention one matter. When lordship was sitting with Justice Shivagnaman, lordship was pleased to hear one matter relating to the custodial death of 4 persons in Baruipur Correctional Home. Like we have filed a.
Now it has to be assigned.
No, it has been assigned.
It has been assigned.
Been assigned to the division bench presided over by your lordship. My lord, I have annexed the assignment order as well as I have annexed the judgment. Grateful, ma'am.
Application with the order 1 would then dismiss my right to file written statement forfeited only on the ground there was no authority appended to the application.
What do you want?
Well, its next date is 20th of August.
It's appearing in the monthly list.
Well, I have filed it, well, they were
When have you filed?
last time.
What is the date mentioned in the presentation slip?
Well, it's tomorrow. I want.
Then it will appear tomorrow, Mr. Datto. If it does not appear tomorrow, please mention. You don't have to give the slip. If it does not appear tomorrow, please mention. Because my direction is that on the date mentioned in the presentation form, it has to appear. If it does not appear, please mention.
Of it being called, my lord, may I have the liberty to trouble your lordship because 20th of August is the date. My lord, it's
If it is not taken up, you can mention prior to rising of the court. Till that time, please wait if it is not taken up.
Lordship, may I have your liberty to mention an application for extension of interim order?
Applications I have said, please hand over the slip.
Extension of
Non-prosecution, hand over the slip to be mentioned.
My lords, may
You
I
have
be
mentioned for non-prosecution.
may I be permitted to mention an assigned matter which was heard by your lordship, my lord,
Hand
and
over the
avoid
slip.
challenging, my lord, the Madhya Pradesh.
Hand over the slip. Upgradation, I have said, please hand over the slip, indicate the urgency. You did not
May I
mention.
permitted to mention 3
He's
and I apologize. Lord.
Yes, Mr. Rai.
This is the matter where lordship through the Nanded district judge, a record was called for, my lord found that his honor, my lord asked me to give me the certified copy was given,
Yes,
then my lord fixed a date.
yes.
That still it is appearing on the 225. It is appearing in the complaint list. I cannot.
It's appearing in the combined list.
Always my lord appearing in the complaint list. Wait, 3 dates are.
All right, indicate that, hand over the slip.
Yes. Last occasion I handed over, the same thing is happening, my lord. Logically, see,
It's not appearing in the supplementary list.
no,
When did you hand over the slip?
last occasion. before
Last
that,
Monday.
I always,
দেখুন তো, এটা
see, my lord's order.
all matters, Mr. Rai, last Monday which has been mentioned, please see, ask your clerk.
Party lordship file, see.
All the slips have been attended. Please ask your clerk whether there is any endorsement in the mentioning slip.
It was
Last
specifically-
Monday,
My lordship
hand over the slip, I will look into it. Yes, hand over the slip.
Should I mention upgradation or not?
Yes. You have to mention upgradation, otherwise, because it's from the monthly list.
Another thing that I am submitting that motions, if the motions are taken up in a particular day, then matter can be released. Motion, combined list.
All are motions.
Combined list motion, my lord. I suppose that there is no indication of taking up combined list motion.
Yes, yes.
No particular date is.
Not particular. After this is because
Then
sub-
matters are not reaching, my lord. Matters are.
Sir, Rai, what can be done? You are mentioning from the monthly list upgradation. Those matters are also appearing.
Because of the thing, my lord, this particularly.
No, I do not have any difficulty. If you say no upgradation, I will, after the daily list, I will proceed serially from the monthly list. I also do not have any problem.
Two dates were my lord fixed. That this date matter will be taken up. Then when the matter comes, matter is not reached, it goes to the combined list. Then I am to again mention, keeping on mentioning.
No, if all of you want that combined monthly list, I will fix some date. I can fix the date. There is,
Matters are taken up. If motion is fixed on a combined list, then my matter may.
all right, I will consider that. I will also consider that. Please indicate for upgradation. I will consider that. I will keep in mind. Yes. Yes.
Lordship, 3 assigned matter arose out of a same suit. One is Order 6, Rule 17 in
Hand over
connection
the
with
slip.
Lordship,
Yes.
14th of this month is fixed before the learned court.
That it's difficult to please hand over the slip. I will consider.
I have filed my 7, 1 and 7 to within time.
What do you want?
Upgradation. My lord, the code.
Upgradation, sir,
difference is
please,
like,
I
I have also mentioned the last Monday also. Because my the
Please
code-
hand over the slip. Yes.
Item number 2154 of your lordship's monthly list, expeditious disposal motion slip.
Yes.
Kindly take it up, it has been pending for a month.
Expeditious disposal is also urgency.
The matter has been pending for 7 years.
Maybe. Maybe that cannot be an urgency. Yes.
I filed it a month back, but it has not been taken.
Yes, yes.
Lordship could kindly list in the
Matters are pending for more than a month. I think some are more than a year.
expeditious disposal, well, that is why I was.
Expeditious hearing, there is no urgency.
May I
Yes.
Lordship, item number
mention item number 797 to combined list? The matter.
Upgradation. Please hand over the slip.
For this matter is fixed for.
I will consider that. Please hand over the slip. Mention the urgency. Yes, Mr. Dutta.
Please this matter on 20th July.
Yes.
Updated motion. Copy of the order.
Please, all right. Yes. Upgradation. Please hand over the slip, indicate the urgency. Please put it down. I will not able to remember. Please put it down in the slip. And
This week, my lord, the appeal is not being proceeded with and the.
please indicate that, hand over the slip.
I'm
Sir, I am assuring you that I am going through each and every mentioning slip. But it's difficult to remember what you are mentioning. Please indicate that in the slip.
Item number 1100.
Upgradation.
No, sir. Fix the, it is very urgency, lower court.
You want upgradation to be taken up?
No.
What do you want?
It is urgency.
Matter is listed.
Right. Hand over the slip, indicate the urgency. Yes. All right.
My lord, a substitution petition has been rejected. My lord, the suit will await.
What do you want, sir?
My lord,
Upgradation.
My lord, new motion, however, it has been.
Please hand over the slip, indicate the urgency.
Lord, item number 452, my lord, since December, my lord, the execution proceedings has been stayed, my lord.
All right. Hand over the slip.
I am good.
Just kindly to mention this matter to file without a certified copy, my lord.
What is the urgency?
The entire file has been from my order 7 rule 11 petition has been rejected. The plaintiff is spacey from their own pleading. They will be.
All right. Fine. You have the server copy.
Your Lordship, may I be permitted to mention, I'm praying for upgradation.
Hand over the slip.
Your Lordship, I leave to mention, my lord, I am mentioning upon notice, my lord, for listing the matter, my lord.
My lord, your lordship directed me to appear on Monday. My lord, I have already handed over the slip. My lord, kindly, my lord, consider it. 24th August is the date for my lord commercial court. Kindly consider.
My lord, may
Please hand over the slip.
Your Lordship may be permitted to mention for inclusion in the daily list. It has been running in the monthly list, and that is after 500.
Hand over the slip. Hand over the slip.
may be permitted to mention one.
Yes, God.
What do you want? Upgradation.
Upgradation item number.
All right, hand over the
This is a copy of the order of stay also.
All right, please hand over the slip.
May I be permitted to mention item number 118 of your lordship list. On the next day, before court below is ordered on.
Hand over the slip. Yes.
Grateful early disposal.
Hand over the slip.
My lord, executive court fixed a order on 11.
All right, hand over the slip. Yes.
Lordship, may I permit me one matter for upgradation?
Hand over the slip. Yes. Call the list.
Grateful, Lordship.
Yes. Whereas the same appears as title suit number. Yes. Yes.
Interim order was till my lord 31st July, my lord.
Yes. What is the impugned order?
My lord, impute order, my lord. I am the legal heirs of the my lord defendant number 1, my lord. The my lord file an application under order 1 rule 10(2), my lord. That was my lord rejected, my lord. Against that we prefer this application.
You have filed an application under order 1 rule 10(2).
My lord.
What is the suit for?
Suit for eviction, my lord.
Suit for eviction.
Yes, my lord.
Who are you?
I am the legal heirs of the defendant number 1, my lord. Initially, my lord, but they defendant number 1 died 13/8/2028, my lord, 2018. And my lord, the plaintiffs also filed an application under order 22 rule 4 sub rule 4, and that was my lord allowed behind back the my lord the legal heirs of the my lord defendant number 1, my lord. Thereafter, my lord, they filed an application under order 1 rule 10(2), my lord. That is rejected, my lord. Against that, my lord. Initially, the matter was appeared before your lordship, my lord, on 17th June 2025. Lordship, after hearing, my lord, directed to serve the copy. I have served affidavit service, my lord, filed. And my lord, interim order granted, my lord. Lastly, the matter was appear, my lord, before.
Where is the order passed under order 22 rule 4 sub rule 4? Have you annexed that?
Application, my lord, page 23. And order, my lord. Thereafter, my lord. Page 23, my lord, kindly. This application. Then, my lord, page 27. Page 27, my lord.
27.
27, my lord. Order. Copy have been served, my lord.
Yes.
According to lordship direction.
Where is the original plaint?
Plaint, my lord. Page 13, my lord. Page 13.
Who is the defendant number 2? Who is the defendant number 2? What is the relation between you and the defendant number 2? Order 22 rule for sub rule 4 was allowed. The original tenant did not,
Behind back the my lord.
not behind back. He did not appear. He did not file the written statement. That's exactly the provision under Order 22 rule for sub rule 4. That has been allowed if the original tenant defendant does not apply.
My lord, the
So on the face of this, how can you be added as a party?
my lord, defendant number 1 tied. in
Mr.
the-
Das, what is the reasoning? Let me see.
My lord, kindly see my application, my lord. Page 29.
Rightly,
My lord, page 29.
rightly rejected.
Page 29, my lord. My lord, kindly.
Yes,
My lord, page
rightly rejected.
my
And
lord,
more so, it was sublet. It was sublet to the defendant number 2. Defendant number 2 is also not contesting.
my lord, page number
Mr.
29.
Das, if
For
the
a moment.
original, have you considered the provisions of Order 22 rule for sub rule 4? Have you considered that? If you want, I can give you time, but no extension because I will dispose it off here and now. No extension of it
Let the matter fix tomorrow.
tomorrow. All right, please come tomorrow.
Tomorrow.
Please consider the provisions. কিছু করার দরকার নেই, not today করে রেখে দিন। Yes. Next. আচ্ছা একটা লাইন লিখে দিন on the
So I'm for the opposite party.
yes. Yes, yes.
Lordship, kindly praying for a short Passover.
Why short password? Mr. Korbakar was here
Uh,
heavily pressing for upgradation of a matter. Where has he gone now?
He's stuck in court number 37, Your Lordship, item number 1 and 2.
Passover. Yes. Next.
For the petitioner, my lord.
Yes.
Same order expiring today, my
My
lord.
lord, I am for opposite party number and opposite party. Led by Mr. Costa Bakshi. Regarding extension, he has no objection.
The matter, my lord, senior citizen tribunal order. I'm challenging the appellate tribunal's order of senior citizen act. My lord, the order was passed ex parte, my lord. Before the SDO, a detailed order was passed, my lord. The impugned order is at page, my lord.
What was the nature of the interim order?
My lord, the nature of the interim order passed on 9th February, my lord. It was let the senior citizen be, they are staying together, my lord. The parents are staying with the petitioner, my lord. And in the meantime, maintenance at Lord, paragraph number 5 and may I hand over the order of
The interim order is extended till the end of the month. Supplement.
May it please your lordship, my lord, my application for expeditious disposal. The second occasion, my lord, I am compelled to come up before your lordship. Ejectment suit, my lord, of 2016.
Defendant wants expeditious hearing of a suit.
I am the plaintiff, my lord. 7172 pending since 2017. Your lordship kindly comes to page 76.
7172 pending since 2017.
Yes, now my lord comes to page 76. My lord, it gets more interesting. we had come up before your lordships, and my lord, the coordinate bench on 30th of March had been pleased to pass an order. My lord, takes page 77, para 4. That is the operative part. Justice Rai directed that the 7172 and the order 1 rule 10, which has been filed by the subsequent purchaser, be disposed of within 1 month.
Yes.
My lord, has that page 77?
Yes. Then what happened?
Then, my lord, we go before the learned court below, and my lord, kindly sees the order impugned.
25th of August, it is fixed.
Yes, my lord. It is fixed, my lord, on 25th of August for filing documents. And my lord, I am not the applicant who has filed that application. That has been filed by the subsequent purchaser. I am the plaintiff. Nothing on the 7172.
This application under Article 2.
Be disposed of within 1 year.
Let these applications be first disposed of. Yes.
But I appear for the husband, father, opposite party.
The order impugned, my lord, June 16, 2026.
Yes. 16th of June 2026. Yes.
Yes. May I read? May I read, my lord?
What is the nature of the order? What is
Nature of the order, my lord, the mother, my lord, that 2013.
You are for the mother?
Yes, plaintiff. Now, my lord, 2013 marriage was solemnized. 2017.
What is the
impugned order, my lord, that I have said in the application was filed by the father in active application that the school, my lord, where my child used to study, my lord, that is in Srirampur, where, my lord, my husband and I used to, my lord, stay there. Now, my lord, after that, I am a teacher, my lord. I am imparting education in the Techno India University, Newtown, Salt Lake. Now I took a particular flat on rent. Now I am suffering from certain ailments, my lord, which includes a renal kidney disease. Now I said that there is a school, my lord, I named it, that is, my lord, stone's throw from my residence. So that, my lord, the convenience of a mother, my lord, that is also there. The initially court, my lord.
What is the age of the child and which class he is studying?
9 years, almost going to be 9 years. She was born in 2017.
Which class?
She's now studying in class 3, na? 3.
8 is 3.
Class 3.
3. Yes. Now what do you want?
Now, my lord, initially, my lord, there was an interrogatory. We objected to that. The court had granted injunction. Mr. Mukherjee, my learned esteemed senior friend's client, my lord, was passed with a favorable order. Thereafter, my lord, the same court suddenly thought that the matter should be dealt with by the district court where the original matrimonial suit filed. They challenging that order. My learned senior friend's client, my lord, filed a revisional application. This honorable court remanded the matter back and to direct the parties to the learned judge to decide afresh, my lord. As a result whereof the application, my lord, that was filed, my lord, page 143, 46, my lord, that particular, the list which includes, my lord, his choice, my lord, that has been adhered to, not mine. The court, my lord, what is the
Will you
reasoning?
challenge again?
I challenge again. I said, my lord, that
Mr. Bose, you and Mr. Mukherjee, you fight it out. Please don't disturb the child.
I can
Both of you fight with the fight against each other, but don't disturb the child.
No disturb the
Sir,
child.
I tell you, Lordship, Lord, what has
Only one
happened.
indulgence, my lord, what my learned senior friend will say.
He will choose certain schools. He will choose certain
Milord,
schools.
Milord, it is not a question of ego. I tell you, Lordship.
Yes, it's a question of ego, Mr. Bas.
Only one indulgence, Milord. Initially, Milord, there was a situation, Milord, like this when Milord court had interfered in a different matter, Milord. Kindly see that I said that Milord, my workplace is Salt Lake. So my in-laws' house, Milord, Srirampur.
Where the child was residing prior to your shifting to Salt Lake.
Srirampur.
Both of them, husband and wife.
Now, Milord,
Still.
No.
Still.
No, Milord,
Yes.
still there is a flat. I said, Milord, in my apartment. I did not conceal. But today, Milord, I took a particular flat on rent.
That's for your convenience.
No, Milord, but question is, Milord.
That's for your convenience,
Milord,
Mr. Bose. You can take flats anywhere,
but
according to your choice. Don't disturb the child.
Question here is, Milord, suppose, Milord, for my sake, Milord, I have to, and Milord, I said, Milord, I am entangled with certain ailments. Now, Milord, which is genuine, not, Milord, controverted. The
child is staying with whom?
Mother. I left the matrimonial home, Milord, 12th August 2024. 12th September 2024, I filed this suit. Now, Milord.
Now it's the which school the child will study.
Only, Milord.
Mr. Mukherjee, any consensus can be arrived at?
I tell you, Lordship. But both
Because,
of them, the husband and wife.
Mukherjee, both of you have to be concerned with the education.
That is
Education has to be
exactly
the
what
best
my application was for.
best possible education in a best school, maybe within a certain commutable distance, reasonable commutable distance, so that the child, because both of you have to consider the welfare of the child.
I'll just note. But the husband and the wife, they reside in the same condominium. My client resides in an apartment, and Lord, the wife has Lord another apartment in the same condominium. So Lord, it so happens, Lord, the child, Lord, comes to my client's Lord apartment each and every day. Because they reside in the same Lord, the condominium, but different apartment. Now, Lord, now mother says that I'm suffering from chronic kidney disease, and also that I teach in a techno institution. I want to shift by taking rent a particular flat which is nearer to my institution. It was her case that I want to take the child along with me to my rented accommodation and admit her in a different school, Aditya Academy. Now, Lord, my client said that, see, there is already an order for visitation. My child comes to me, I have a consortium of my child each day. She studies in a particular school as of today, which has up to class 8. I wanted to, Lord, admit her in a school which is, Lord, a reputed school there, and I have given the choice in an application. My Lord?
In Srirampur.
In Srirampur. In Srirampur. There are 5 options, Lord, I had given to the mother. Mother was not sticking to her, Lord, the contention that, no, I want to take the child out of that particular apartment, stay with me, and I will admit her in the Aditya Academy. When I took out an application, on my application, which is at page 103, I gave the court 3 options. Lord, on that particular application, Lord, the impugned order was passed, Lord, rejecting my learned friend's contention about taking away the child outside the jurisdiction of the court and admitting her in, Lord, that Aditya Academy. This is the long and short of, Lord, this particular matter. Now, Lord, as of today, Lord, the child is there, Lord, at Srirampur and studying. Mother wants to uproot her and take her, Lord, to the rented flat, along with, Lord, admit her in a different school. Lord, whether that is conducive for the child, Lord, that is for my lords to consider. But as of today, Lord, I say that she is quite comfortable in the present school. Her, Lord, the immediate family members are there in the vicinity.
You have submitted that its school is still class 8. That,
no, in there, Lord, the present school where she is residing is, Lord, studying is, Lord, up to class 8. So now I have given other schools in the vicinity, Chaitanya Techno School and Lord Vivekananda Academy and Lord Narayana School at Rishram, Lord, all this in the vicinity. And I asked for that if the mother allows, I can admit. In fact, I have not already paid and not admitted her in
Mother
the
does not want any maintenance from my learned senior friends.
But I'm not talking about
Mr.
maintenance.
Bose,
She is
it's not a
earning
question
well.
of
Lord, I have all
maintenance.
respect for her.
It's a question now the child is presently having the company of both the parents.
Yes, and as a
So
family
you
member.
cannot disturb that arrangement.
And the
I'm not.
grandmother.
I'm
Please
not.
do one thing. You can stay at Salt Lake. So let the child come to the father. You come, take the child, stay for the night there, and again return. So you are trying to disturb the present arrangement of visitation.
On instruction, I can say, Lord,
Sir, Bose, please don't do this
kindly.
because there is a the child is. being
I bow
custody
down.
of the father and the
Milord, I
mother.
bow down to my lord's observation.
an instruction, Lord. I can even extend, Lord, to my wife, Lord, a car, Lord, for commuting to the school and coming back. I'm her workplace and coming back.
Milord,
Mr. Bose, that's the.
I tell you.
Goes in a chartered bus
Milord,
to our workplace.
I tell you.
I can provide, Lord, on instruction, I say.
Milord, Mr. Mukherjee,
Mr.
Mr.
Bose, that
Mukherjee's
is-
client's inherent generosity, Milord, is a blessing in this legal battle. But kindly have the charity to consider one thing. A person who categorically stated, not disputed by my learned senior friend's client, that she is entangled with a kidney disease for which she needs a continuous treatment. Mr. Mukherjee's, Milord, benevolence to provide a car, Milord, will not shorten
where
the
are you
journey.
being treated, Mr. Bose?
Milord, this is
Where are you being treated?
Kolkata. In Kolkata. In Kolkata. In Kolkata, my husband cognizant, in Salt Lake. Every day he comes. Mother's, Milord, touch. Mother's, Milord, that mother's, Milord, the care, supervision at this age, Milord, of a girl child.
Father supervision is also necessary. Mr. Bose, it cannot be one-sided.
No, I'm not saying.
Don't try to impress that it's only the mother supervision.
No, I'm not.
Father
I'm not.
supervision is
I'm
equally
not.
important.
I'm not. I say only that before comes to a discussion, Milord, child's welfare, Milord, is a paramount consideration.
Yes.
My lord is absolutely, I bow down.
So presently,
Before your lordship,
Mr. Bose, I'm telling you,
Mr. Mukherjee,
this child, I must say, is fortunate that he is having the company of both the
Correct.
mother and the father.
And even the grandmothers are
Times
there,
in
both the
this
sides
type of,
grandmothers.
in this type of disputes, rarely the child has the company
yes,
of
yes,
both.
absolutely, Milord. Your
So
lordship,
please,
Milord.
Mr. Bose, I'm requesting you, please don't disturb
No, I
this
am not
present
disturbing. Milord,
system.
only, Milord, I request
Please
you.
think of that. Please take instructions.
Yes, I'm grateful.
Please hear me. Mr. Bose, please take instructions as to how in a better school can be done, keeping the present arrangement.
Milord,
Please,
only,
both
Milord,
of you
yes.
take instructions for the welfare of the child.
Right.
Please take
Milord, before
instructions
that,
as to,
yes, absolutely.
because Mr. Mukherjee has given some suggestions. If you have some contra suggestions with regard to that, but don't disturb the present situation of
only,
the.
Milord, I
You can
request
take
that-
instructions and come back for this.
Yes. Milord, only one indulgence, that even in addition to what has fallen from my lord, kindly, Milord, in a camera, kindly, Milord, or Milord, in a lordship's chamber, kindly, Milord, talk to the child.
Mr. Bose, both of you are the best persons. Both of you can sit
Milord,
together with your clients.
Milord,
No
only-
difficulty.
No, only, Milord.
Mr. Bose, I'm telling you, if both of you cannot decide, settle this, the courts cannot. And if you want any mediator, I can appoint any of the trained
When
mediators.
Mr. Mukherjee is here,
But Mr. Mukherjee is appearing for a
I am
client.
appearing for.
He is appearing for a
interest
client
look at.
for
Milord,
mediator. Both of you can mediate.
I repose
No
my
problem.
trust, Milord, in his wisdom.
Mr.
Milord,
No, Mr.
only
Bose,
Milord.
please, both of you sit together.
No, I'm
with your
talking, mediate
respective,
করতে বলছি।
both of you sit together. If she has some problem, if you have some contra suggestions,
Milord,
Mr.
in
Mukherjee
one
has
matter,
given
Milord,
one suggestion.
Milord, in one matter, this honorable court, Milord, had, Milord, interacted with the child. Only, Milord, for a moment. Milord, we will sit together.
Yes, you sit together. If you do, if both of you don't
kindly,
find
Milord,
that it can be,
kindly keep
because
it in
it's a
mind.
small issue.
Only
Mr.
10 years, small issue.
It's a small issue. So both of you decide
Milord,
to
only-
a school and you are also having an apartment there. Why are you trying to disturb this
Milord,
present?
I tell you, Lordship, Milord, I will talk to my client and Milord, within a week, in this week, Milord.
I'm keeping it.
I will, Milord. I
I'm
will
keeping
talk
it in the next week.
next
Please sit together with your respective clients. And if you have any suggestions, you please give it to Mr. Mukherjee so that he can also consider.
Yes.
But don't disturb the present situation of the company that the child is presently getting.
We will sit together.
Please sit together, because I must say here in this case, the child is having the, as Mr. and you are also not disputing that for some hours every day, He is pending with the father.
Those are all on record, my lord. I can show before your lordship.
So I do not have that instruction. Since Mr. Mukherjee, my learned senior friend, says so.
He is saying that all are on
Yes, he is
record.
saying that. I do not have that instruction.
Your advocate on record must be having
These
this
are all on
instruction.
record.
They reside in the same flat. First, second floor, third.
Yes, yes.
Yes.
So,
I'm told, my lord, nowadays, my lord, he works from home, my lord, majority of the time, the father. That's all also on record.
so do one thing, you can stay there, keep the child with the father. Weekends you take it. Weekends you take him to your apartment at Newtown. I think that's
I bow
better,
down to
Mr. Bose.
my lord.
Both of
I
you,
bow down.
Mr. Mukherjee will allow the son to stay weekends with you.
Yes.
Don't disturb the present situation. I think that's better. You can
Yes.
you can perform your duties in a much better way. He's see, he has
বলছি জজ সাহেব এটা বলছি এরকম পরের সপ্তাহে থাক
what Mr. Mukherjee has said, that he has made this arrangement. He is working from home most of the times to see the child.
Possibly, Millard, there is a gap between this between the
And
Millard
after all,
actual-
there is so far as the child is concerned, you both of you fight between each other. There's no difficulty on that. But so far as the child is concerned, he's having the company. He's having no problem with the father also.
Even the mother's mother also stay in that apartment. Therefore,
Yes.
my lord, she is, my lord,
Yes,
basically.
many a times, Millard, today, Millard, nowadays, I and my daughter, Millard, both are residing, Millard, in Damdam, a rented house.
That might be
Millard,
for
forget-
some
Millard, let us-
days, because
Millard,
this
Millard,
was the
let us-
situation,
let us-
and your mother is also residing there in the same apartment.
Millard,
You also come frequently to see your mother, Mr. Bose. I think.
Millard, take it up the next Monday. I will.
Yes. After some argument, the learned
request of my learned senior brother.
let it appear, then if it is taken up on him.
I should.
So Bose is a busy counsel. What can be done? He can make arrangements. Yes. Yes, next.
Great. I'm sorry.
This matter, my lord, your lordship. Madam, my client,
opposing party.
my client, my client filed an application for grant of probate in the court below before the district delegate. In that proceedings, the opposite party, the predecessor of the opposite party, entered appearance. And my lord, prayed for time to file written objection. Now, subsequently, unfortunately, that lady died.
There is?
Unfortunately, that lady died.
Which lady?
The person who want to file objection, she died.
She died.
Now, my lord, I filed an application under Order 20 Rule 4 Sub Rule 5, permitting me not to, my lord, take steps for substitution. That application was fixed for hearing. By this time, the legal heirs has already entered appearance. My application has been allowed.
Expunging.
Order 20 Rule 4 Sub Rule 5. Now, my lord, next date has been fixed. Court said that they have already entered appearance. You have not taken steps. In spite of my appearance, court dismissed the matter for default. I filed an application for 151 of the Code of Civil Procedure for recalling of that order to show that it is a court's mistake. Now, my lord, that put up application has not been taken up. 2 times I moved.
I'm directing that too.
Your lordship has already directed. Your lordship, kindly see the lordship.
Then what happened?
Then, my lord, on last Friday, a put up has been made. Court said I will consider. By this time, what happened, my lord?
Contempt is to be done.
My lord, no order has been passed. Court said I will consider.
Show cause.
Yes, yes, Mr. Mukherjee.
Now, thereafter, what happened, my lord? Now, my lord, before that, my lord, I filed the suit in 2020. I filed the application for probate in 2020. Now, my lord, before that, 1 year. Sorry, 2019. Now,
2019. You filed the probate application was 2019. Yes,
2018, they filed a suit for eviction.
prior.
I filed an application for stay. But
Oh, the way you have started, I thought it's a different matter. Yes, now two way of approaching. Now what happened? State rejected.
No,
Show cause was
what happened, Malad? Court
they rejected.
No, court said that there is no proceedings. There is no probate proceeding, because that is dismissed for default. Although, Malad, before hearing.
What is the order on the stay application? Rejected.
Rejected because.
I've told you are saying no, it has not been rejected.
Yes,
I'm asking you stay application rejected, you are saying no.
No, I'm not saying that, because what is the record? I cannot go beyond that. Now, this is the judgment, Malad, because in one hand, Malad, court is not, on the last occasion, Lordship asked me to bring some judgment, Malad. I tried my level best. This is my first judgment, Malad, reported in 2013 Supreme Court cases, Calcutta, Malad 1967. But second, Malad, I'm
Doctrine of estoppel, Mr. Mukherjee,
Malad,
will not apply. May not apply here. Yes, Mr. Mukherjee, please, which paragraph? Name.
But the learned senior counsel who appeared, he has Malad, but if Lordship see.
Learned senior counsel. I do not find any senior counsel to have appeared there.
If your Lordship see, Malad, from next page, the submission has
Please give me a minute.
from the super recovery of position.
Yes.
But second, I will deny my letter. 2005 volume 12 Supreme Court cases were in one volume judgment, but page 503 Malad. In the same volume, Malad, another judgment.
Oh, this is by Justice Umapal. Yes, and the other judgment.
Now, kindly see the impugned order. Impugned order, court has not gone into the merits. Court simply said, but kindly see once, Malad.
You are referring to which judgment? 512, 503.
I'm relying 512, Malad, 505 and 503.
Yes, yes. First, which you are replacing?
503.
503, yes.
Malad, here, Malad, I'll take that. But this is Malad, Justice Pal's judgment regarding Malad transfer. But Malad, if your Lordship consider the three judges bench judgment, Although this is in respect of the clubbing of the suit, my lord. Wait, division টা বাদ দিই। কবে এটা হয়েছে?
Yes.
Before that, kindly see, kindly beside, my kindly, my lord, consider the impugned order. Impugned order, my lord, was passed on 24 2026. Now, my lord, my application was dismissed for default. I filed 3 put-up petition. I filed 151. Then filed 3 put-up petition. Court said I will consider. Now, my lord,
What is the stage of the eviction suit?
my it was evidence has been closed. Next date.
But
evidence-
final
Both
argument
parties
is,
evidence closed.
but final agreement is in process.
No, Dada,
Final.
Arguments are in process.
no, evidence has been closed. Next date has been given for argument.
No, no, arguments are in process. I've seen the orders. এই তো order আছে দেখ।
So repairing application was also filed. That was allowed in your favor. You cannot challenge that.
We are restricted to the.
Yes, it was 23rd of July for arguments as last chance.
Yes.
Now, my lord, kindly see, my lord, 20 argument, my first time it will start.
As last chance.
No, on
23rd of
the
July.
last day we prayed for adjournment. That in one hand the landed district delegate is not granting time, not allowing my put-up petition. Kindly give us some time so that we can move before the Honorable High Court. Thereafter, I move before your Lordship's court. Your Lordship directed to file an application for expeditious disposal. I filed Friday. Court said I will consider. Now, no order has yet been passed. Now, kindly see the impugned order. I will show from the impugned order how this is wrong. But in my honor, if your Lordship kindly see 20th April 2026.
20th of April.
Yes.
20th of April.
April. Order number 43.
Oh, yes.
Now, my lord, kindly see, once my 151 application was filed on 9.
What is the nature of the eviction suit?
But they say that, my lord, after the death of the person who was the owner of the suit, they are the legal heirs. Therefore, they became the owner of the property. Now, on the strength of the same, they filed the suit for eviction.
So they are claiming title by virtue of inheritance.
Inheritance. Now, I said that before the death of that.
You are also claiming through that common person.
Common person. I said,
by virtue of this will.
By virtue of my case is that they never looked after the person used to.
What is the relation between both of you?
But my relation, if they don't have kindly see their suit for eviction plaint.
No, I am asking you, what is the relation between both of you?
According to
he is claiming inheritance, so
through maternal uncle.
My maternal uncle.
আমি সেটাই বলছি দাদা, তোমার কথাই বলছি। And my case is that.
Yes, and your case is that
the person used to reside with me. I'm showing to your Lordship. They never took any care. The person has executed the will. There are 2 attesting witnesses. Everything is there. Now, if I show to your Lordship the impugned order once, my impugned order was passed on 20th April. Now, my application, the probate case was dismissed in March 2020.
You have a copy of the will, Mr. Mukherjee.
At that moment, the probate proceeding entire file is with them. Last time, your Lordship asked me to bring some judgment, if your Lordship asks me, I will definitely.
No.
Now, kindly see once.
Please give me a minute. Please give me a minute.
রিপোর্টটা ফাইল করতে হবে। A court ought to have adjourned. I'm sorry.
Your counterclaim is there in the suit for eviction.
Yes.
Counterclaim for
But I became the owner by
virtue of the will.
but kindly see the improved order. Kindly.
So the counterclaim has to be detached from the eviction suit, Mr. Mukherjee. Because unless you prove the get the probate, you cannot succeed in the suit.
But kindly see the improved order once.
What do you want? You want that to be detached?
Because if I put this way,
How will you succeed in that counterclaim, Mr. Mukherjee?
why I'm telling, because my probate suit was in the peremptory court. Now, my lord, what happened, my lord? That when there is no fault on my part, the court dismissed my probate application, dismissed for default in March 26. April, my lord, after some days I after some days I filed 151, 2 times put up petition. Court said I will consider. I don't know why, what mistake has been committed by my client in the court below. Court is not fixing a date when it has been specifically pointed out that the mistake on the part of the record or mistake on the part of the, I should not mention the word, the learned judge has not considered the earlier order. Now kindly see once, when the order was passed, at that point of time 151 was pending. Court said only reason is that the probate suit has been dismissed for default, therefore section 10 is rejected, without considering the fact, without considering my submission that already 151 is pending. Already 151 is pending. Now today, let's suppose today, after your lordship's order, I don't know what will happen today or tomorrow in the court before the district delegate. If the landed district delegate allow my application 151, then my lord, the probate suit will be decided within certain time. Then suppose, my lord, just today, if the eviction suit and my counterclaim be hard, kindly consider they file written statement against my counterclaim. Now for the time being, subject to correction, your lordship has already passed an order that the 150, I file a put-up petition, court will consider. I don't know what order will be passed. But my, for the limited period, if your lordship say, the argument be concluded. But my, give some protection so that in the meantime, if I lose, if my 151 goes, everything will go. Kindly consider that.
You file the section 10. My lord, firstly, my lord, one factual discrepancy perhaps.
Yes.
Yes.
My lord, firstly, my lord, one discrepancy in fact. My lord, the probate proceeding, my lord, was not simpliciter dismissed. They did not appear. Show cause was given. My lord, was given. They had filed show cause also. Thereafter, they also did not appear. And then it was dismissed. My lord, when the section 151 was filed thereafter, for recall of that order, 151 was pending. My lord, section 10 was filed. Now, section 10, your lordship knows very well, my lord, it is the prior suit, not the prior suit, but the subsequent suit has to be stayed. Here it's a probate proceeding. A probate proceeding and the eviction suit completely different from each other. They have again filed a counterclaim to that effect. One is whether the will is viable or not, or whether tenable, and the other part is, my lord, eviction title, of title. Now, my lord, after the probate proceeding goes and the section 10 remains, my lord, unless and until the probate proceeding is revived, my lord, the section 10 cannot survive. The main reason is, in spite of having given repeated opportunities for them to appear.
No, that's on merits of that application under section 151.
Yes.
But what happens if that revives?
Well, they can.
Let us assume that it revives, because we
I am
have to,
assuming that.
for the present,
I
we
am
have to
assuming
consider
that. Yes,
both.
I am assuming that.
Yes.
It's not barred by res judicata.
Yes, so if it is, it
They can file
revives,
this-
what happens? And in the meantime, the eviction suit is decreed. What happens then?
Well, they have two options. One, they, after your lordship's order today, the section, they can file a section 10 again. There is no embargo to that.
No, if they do not get that opportunity prior to that, let us assume the
Very
eviction
well.
order is
Very well.
passed.
They have the opportunity, my lord, to file an application for recalling of the decree, of a stay of the decree.
In view of what? In view of subsequent events having occurred? Subsequent events.
They have to prefer an appeal. There is no scope of stay. How the stay, under what provision stay will be granted? Under what provision stay will be granted of that degree?
Well,
under what provision? If a decree is passed, how can a stay be granted?
47. Subsequent event, which will affect the title of the property of the directly, they can ask for a stay. And
We considered this judgment with Mr. Mukherjee as relied upon.
Firstly, my lord, your lordship would see the 2005 judge, my lord, 2005 judgment.
2005 of the Supreme Court. No, I'm not on that. Please
My lord, the
take the
2013
judgment.
Yes, yes. But the 2013 judgment on the facts itself is different. The probate proceeding was pending.
Yes, but
it was
this,
pending.
yes. So now
Your lordship,
the application is
and
has
it was
been there.
passed under section 43 of the Karnataka Rent Act.
No,
There is a
no,
specific provision.
That is not. That was the decision which I relied,
Yes, now
which
you're-
was relied upon.
Yes, now you're
It's not that, but here,
the second last paragraph,
yes,
the facts of the present case are completely different.
Yes.
However, this court finds
Yes.
that the decision of the probate proceedings has some impact on the determination of the suit for recovery of possession. But that itself should not preclude the court from proceeding further with the suit, but the final decision should be stayed till disposal of the probate
yes,
proceedings.
arguments over if the final decision is stayed.
The probate proceed করুক না। Proceed করুক।
No. Here it has been said the
decree will not be given.
yes, decree in the eviction suit will not be
not be
given.
passed. Will not
Yes,
be passed.
arguments, everything will be closed.
Can be completed.
What do you say to this? And another thing is that arguments technically should not proceed, because if the arguments, because what happens on that, something has to be argued. So, if that is stayed at this stage, what do you say to this?
উনি কি করছে? হয়ে যেত তো, হয়ে যাচ্ছে তো, the decree শুধু দেবে। But your lordship can do one thing, I believe. Well, the 151 proceeding, well, that is in a miss case. Well,
That is a different in the probate proceedings.
well, in the probate proceeding, an application, my lord, cannot stay a eviction suit. Cannot stay an eviction suit.
Only one thing, no.
And a prior
Ground is, yes, there are two options. One is what you are saying is right. At this point of time, there is no probate proceeding pending. So
And a
that's
prior
one way of
suit
looking at it.
prior suit
That's
cannot
one way of looking at it. But please consider the consequences if that is allowed. If that is allowed, in the meantime, the decree is passed.
There is a legal provision also, but the section 10 is for the subsequent suit.
If the section 10 does not apply, 151 can also apply. 151 can also apply. So there is no bar in 151 apply.
The argument has been basically on that
Section 10, that's too much technical. So if there are decisions, if technically section 10 does not apply, 151 can be applied, and that's the inherent powers.
Yes.
Court can at any point of time exercise that.
the 151 is pending.
That's 151 is in that.
Yes.
151 for stay in this. What do you say to that?
They have not filed anything. But it section 10
On this application, there are decisions galore. In an application, in section 10 also, the court can.
If the two issues are has some impact on the other suit.
So that is why this judgment of 2013, it says it has some effect. Please consider the probate is allowed. Then you do not have any right. Then your eviction suit has to be dismissed. So you cannot get a decree. So that's the ultimate thing.
Well, I just
If you want, you can consider these judgments. I can keep it tomorrow.
well, there are two judgments of our High Court. Well,
You have brought.
Yes, I have got.
Yes. What does it say?
Well, it says, well, 227 identical, well, section 10 for eviction suit and the probate proceeding.
Yes.
Which says it does not, section 10, well, in a 227, when a section 10 is rejected, these are two completely different proceedings. The dismissal of the section 10 was correctly done. Here, one copy.
No. Right.
My lord, the other one, Lordship, another my lord, similar one. Stay was rejected in a partition was stay. দিলে ওরা কি করে ডিসিং করবে And also, my lord, there is another partner where it takes into consideration 2005-12 SCC 505, paragraph 4, 5, and 6. One second, what a distinguished. There is one more suggestion, my lord, which suddenly fell from you. My lord, even if a decree is passed, I have to go up in execution. There they have remedy. Straightway.
When do you want? All right. All right. Pass over. Yes, next. Great. Yes. Only on those, no fresh argument, only reply to those judgments. Yes, next. Password. Yes, next.
Eight, my lord, I am only praying a day's accommodation, my lord.
Why?
Mrs. Dipanita Ganguly is appearing, my lord. She has not come, my lord, due to her personal difficulty, my lord. Only 1 day's accommodation, my lord. But she is advocate on record, my lord. I'm not briefed in this matter, my lord. I'm just praying 1 day's accommodation, my lord. Only 1 day's accommodation, my lord. But she has not come, my lord, due to her personal difficulty, my lord. Only 1 day's accommodation, my lord.
How 227 in the civil revisional jurisdiction is maintainable, challenging an order of the judicial magistrate.
In this matter, my lord, only 1 day's accommodation, my lord. My lord, only 1 day, my lord.
And accommodation. Yes. Please go through that judgments. Yes.
Item number 9, I am for the opposite party, my lord.
Yes, who is appearing for the petitioner?
I have been served by, I had a filed a caveat, my lord, so I was served. Well, the application, my lord, was to file some document we have already filed. The honorable court below had recorded that.
None appears for the Yes.
In this matter, I am for the petition. The plaintiff petitioner filed a suit for declaration that the deed executed by the father in favor of his brother, lordship, the signature is false and fabricated. Now, lordship, in their suit, lordship, an application for handwriting expert was filed, but the learned trial court, lordship, rejected the application on the ground that I am wanting to drag the suit. In the body of the plaintiff, lordship, if your lordship kindly comes to lordship page 17, lordship, page 8, lordship, I have stated that my father purchased the property 1978 and brother subsequently.
Where is your cross-examination?
Cross-examination, lordship, I have not annexed, but lordship, the application should be treated made on this.
In the cross-examination, Mr. Shanal, you have admitted that
In that, lordship, cross-examination it should not be on the basis of.
if the execution is not disputed, there is no
No execution, lordship, I am
maybe, but in the cross-examination, you have admitted.
Lordship, only it was lordship mistake on the part of lordship the plaintiff, lordship, during the chief.
This application under.
I have
Thank
stated,
you.
I have stated, lordship, that the
Maybe
signature
this application under Article 220.
Page 17, lordship, of the plaintiff. Plaintiff, lordship, kindly comes to lordship page 17, lordship. I am
releasing this matter, directing this matter to be placed before Justice Rai.
So I am paying lordship. Kindly consider, lordship, whether the handwriting expert, lordship, application for handwriting expert, it can.
I'm releasing this. I'm requesting the Honorable Acting Chief Justice to place it before Justice Rai. This application under Article 220.
So the partition suit, preliminary degree was passed. Subsequently, on the basis of the prayer made by the victim, a paper that rule commissioner was appointed, and he submitted a report. And on the basis of the report, a formal degree has been found.
From that,
Formal degree,
final degree passed.
final degree, only degree has been passed, but no adjudication has been made.
What adjudication is required?
On the basis of
Commissioner's report accepted.
commissioner is accepted without giving any opportunity of being heard. I mean, the defendant, without giving any opportunity.
Where is the final degree?
Final degree, my lord, final degree, as final degree. Yes, sir. My lord, what has happened then after that it has been put into execution. The degree has been put into execution. And
then the final degree has been passed. If you have to challenge the final degree.
Challenge that, but after having been allegedly registered,
When the final degree was passed?
final degree was passed on 24th April 2025.
You have not yet filed any appeal.
No appeal has been preferred. No, only. Although having been allegedly registered by the as per the belief report, I mean, the degree holder has taken out an application under Order 2197. And that application has not been registered as a miscase in terms of the civil rules and orders. And without adjudication of the miscase, because we have.
What adjudication is necessary?
So far as.
What adjudication is necessary?
But the only thing is that.
No, I'm asking you what adjudication is necessary.
No final order has been passed, but before that the police order has been made. No.
All right, police will not go. Please hand over the possession.
No, my lord, kindly have a look.
Police will not go. Police will not go. According to you, there was no resistance.
It has not yet been completed.
What proceedings? What is necessary?
2197. They asked.
I'm asking you what adjudication is necessary in Order 21 Rule 97.
Because I have not given an opportunity to file my objection against the commissioner report.
That cannot be decided here.
I raised objection in this proceeding.
For that, you have to challenge the degree.
No, that is not. But so far as this proceeding, so far 2197 proceeding is yet to be decided. Kindly have a look to the impugned order. Kindly have a look to the impugned order.
Yes. Yes.
Thank you.
Yes.
My application for stay is also pending.
Stay of what? Stay of what?
So far as my objection against the commission.
Sir, you have not challenged the degree. Where you have paid for stay?
Already, I'm going to prefer an appeal.
Go prefer an appeal, then it will be considered.
At this stage,
It's time barred.
My lord, at this stage, my lord, kindly consider this aspect. If this degree is executed.
So till now there is no appeal in the eye of law.
Yes, there
the
is
appeal
no
has also
position, but
appeal has also become time barred.
No, time barred, that is section 5 or.
So do that. Nobody is stopping you.
No, only thing is that
nobody is stopping you.
What I want to converse before your lordship, that so far as my stay application, because I have raised objection also. I have raised objection against this application under Order 20 or Rule 97.
What is your objection? Please show me.
Kindly have a look to my objection.
Yes.
That is 54.
Yes.
I have a 81.
81, yes.
81, page 81.
You have challenged the report. That cannot be gone into at this stage. That can't be. That is to be in the appeal.
But your lordship is absolutely correct. But so far as the adjudication, I mean, what I'm on, order 2297. My first point, it has been not registered as miscase. I could have understood.
That's a technicality. That's a technicality.
No, I could have understood that it has been filed only under order 208 of civil rules and order. I can understand. But so far as 2197, it is the substantial proceeding, and that is to be adjudicated upon.
What is to be adjudicated
So far
at
my
the instance of the judgment data, sir?
So far my objection is concerned, so far the
This objection I can record, I can take your objection into consideration and can dispose of. Then you will be finding it difficult in the appeal court.
But only thing
That much I can tell you.
Kindly have a look to once again. Kindly look to the impugn order.
Yes.
Here it was fixed on 3rd August to submit the report, but unfortunately the police has not submitted the report till this date, and as a result, the next date has been fixed on 11th August to ask the police officer to show cause and to be present personally before that. Till now, no proceeding is yet to be decided. I mean, this application is yet to be decided. It has not been disposed of. But only thing is that in the meantime, if my application, kindly look at that, my application for stay is to be taken into consideration thereafter. Kindly have a look to the impugn order. So kindly, a direction may be given to the trial court to consider my stay application before taking up.
So there is nothing in the stay application. You have challenged the commissioner's report. How can that be considered here?
But so far as 2197, kindly appreciate
2197,
2197.
sir, 2197.
Yes.
What is the scope of an adjudication at the instance of the judgment debtor? Please apprise me on that.
But
You are a judgment debtor.
No, even then, it is I mean, it is.
Sir, you are not. You are refusing to.
It is logical correlation. I mean, logical conclusion. There
That's
must
the
be
logical conclusion.
But
Police help. That's the logical conclusion. There was resistance. Police help. What more? And if you say you have not resisted, I record that. I direct you to give possession. Police will not go.
The resistance is concerned, it is simply on the basis of the, I mean, belief report. But there is no.
Are you disputing that?
No, kindly consider this aspect.
I record that, and I record your submission that you will be giving possession. Police will not go.
2197.
If you are not accepting that, it shows that you have resisted. Sir, if you are not accepting that, it shows that you have resisted.
No,
Otherwise, you have accepted. Yes, I have not resisted. I can give.
I have not registered. Actually, I have not registered.
So give back, give possession, execution of this.
Let this proceeding be disposed of 2197.
That will be disposed of by this.
No, whatever. In the midst of this proceeding, a direction has been given to the police officer.
Sir, what is to be adjudicated? I'm asking you. Please apprise me on that. What will be adjudicated in that proceedings? What will be adjudicated? What issue will be adjudicated there?
The only issue is that the commissioner report, where the commissioner
Sir,
report.
Can that be decided here? I'm asking you. When a final decree has been passed, you have not challenged that. Can that be decided here? If you want that, I can record whether that can be decided here or not. That is what I'm not going into that. If you harp on that, then I have to record that.
So far, my client is concerned that because due to his brain hemorrhage, and he has been suffering for a long time. This is a dispute between the sister and brother. The married sister has instituted the partition suit against the brother and the mother.
That's a different thing altogether. I cannot go into that.
If
you want time, I can adjourn this, but I cannot stay this. If you want to prefer an appeal, if you want,
yes,
I can adjourn.
The memo of appeal is ready, but so far the continuation of delay, I will take out the section 5 application.
But no stay, I can adjourn it on your prayer. That much I can do. But
kindly write that so far my stay application is concerned. That is to be taken into consideration.
Sir, what is there in the stay application?
That is pending. That is pending before the trial court, before the executing court. Kindly have a look to the impugn order.
The learned advocate appearing for the petition Well, yes.
May I will also mention item number 3, pass to one. Give lordship the new
3. Who is your other side?
Rahul Kormumar.
Where is he? He's a busy. He appears at the time when for mentioning for upgradation. Thereafter, he is very busy. Yes, Mr. Chatterjee, call your friend.
My lords, I
Tell him that Mr. Mukherjee, senior Mr. Mukherjee is waiting for him.
My lords, I sincerely apologize. Sorry. My lords,
Yes.
item 9 has been dismissed for default. I was just about to enter.
Yes. Item number
9, my lords.
9.
Yes.
In 9, someone appeared. Please,
Mr.
please
Chaudhary,
bring him.
I
Otherwise,
asked him, he is saying I'll not.
then it cannot be done. If you can bring him, I can restore because he was present here. In his absence, I cannot restore. Yes. Expeditious disposal of. What is the stage?
This has not yet been completed. Because my lord,
Notice of appeal has not yet been served. Then how can it be expedited? This application under Article 227.
one thing. My lord, the original defendant was commissioner party. After he was the one single appellant party, sole appellant. After his death, my lord, he has 7 4 sons and 3 daughters. Only one son has been implicated himself as the appellant, and the others have been implicated as the respondent. Only those respondent, 2 of them had not been married, they are not receiving the sum of marriage, they are not appearing. For this reason, the appeal is going adjourning from 14.
What can I do? You have to take steps there. You have to take steps in the appeal.
No time frame is required, not time, just the execution order.
Thank you.
I can apply for other mode of service, but I have to.
Thank you. This application under Article
not concession, not, but Seventh-day Adventist is not. After that, I tried not.
I broke my head to get that judgment. ACC online, I am not so much tech savvy.
Seventh-day Adventist you have
Yeah,
not got.
I've got it. I've got it.
That is why I
not
told you
record
on
my-
the,
do not record
no,
my
no.
The complete bloody. I felt
This
it was
goes-
a waste of.
No, what is the facts?
So the facts is not that suit was filed, Order 9, Rule 13 allowed, a date was fixed for appearance. Within 1 month from that appearance, 7172 filed, but unfortunately, just
The amount was not filed.
3 to 4 days thereafter, not the amount was.
So according to you, the application was filed within time, but the amount was deposited subsequently. But now,
Devashish Pal, things were right because after that the application was there, so the proviso not that has also been
Now,
clarified.
the Seventh-day Adventist has put an end to everything. That has put an end
because
to
there in Devashish Pal paragraph 17, there was some confusion created.
And that is specifically dealt with there. But I tried to, but then I felt it will be a waste.
So
of
Mukherjee tried to take advantage of that paragraph 17 in that one of the matters in which he, but I held against him. Thankfully, 7-day Adventist is has protected.
that killed a lot of litigation. That killed a lot of litigation. Killed a lot of litigation.
This application under this application under in court fees, come. Yes, I will consider. Next, you're dismissed. Next. Call the next matter.
Item number 7, my lord, pass over. my lord.
Item number 14. Yes, call them.
Other side is here, my 7 pass over.
Yes, 13. Yes.
7 both side, Mr. Basu is the busiest council, man. Kindly visualize.
I have heard him. You come at 1:15. Yes. Give reply to those. Come at 1:15. Yes.
This matter, before he starts, my lord,
All matters are yours, Mr. Mukherjee.
53 that is already running in the list. It's from the same one. 58 is already running in the list. My lord.
58.
Item number 58. That is the Mr. Kormakar was appearing. That a building tribunal matter, my lord. He's enjoying a stay.
I told me that যেটা তুই 53 ওরা এবার মামলা
I was filed a civil division application.
মানে তোকে সাপোর্ট করছে এবারে
না সাপোর্ট করছি
আবার
সাপোর্ট
ও সেটা but this matter can be why I'm telling
this matter is coming up for the first time. It's I have also challenged the same order of the building tribunal.
Same order?
Yes.
Now initially we are the sufferer. Initially
who are you? You are the complainant.
Corporation.
Oh, corporation is the sufferer.
Well, I am the complainant.
Because now initially Mr. Kormakar
Sir, Mukherjee, you have invited this. What were we doing with the construction was being put up?
Well, the first time in 2022 when I filed a writ petition, when the building came up to four floors, they were saying there is no illegality by a report. Well, at that point, the illegality was there. The next time when I filed a writ petition, they said yes. From
Yes,
the ground.
yes, Mr. Mukherjee, why same?
What happened initially? Mr. Kormakar filed an revisional application challenging the order of the Municipal Building Tribunal. In the Municipal Building Tribunal, tribunal said that the special officer building ought not pass the order and directed the order of demolition.
Special officer building directed demolition.
Special officer regularize the same. Special officer building.
Yes, challenge that.
Why he will challenge? My special officer, they are
how they are related?
Well,
I
am the complainant.
Oh, you are the complainant.
I am the complainant. He is the PR. Mr. Kormakar's client is the PR. Well, I have filed the complaint. It was taken up by the special officer building. Well, I was not giving a chance of audience. Well, it was ordered in favor of Mr. Kormakar's client. Well, I challenge. I assailed that order before the building tribunal. Building tribunal says demolish it entirely.
So how are you aggrieved?
Yes, sir, I say because
that is why I could not understand.
That's why I want to say something for a lordship.
Well, I'll say why. The disketch plan that has been prepared, it shows only half of the construction. The half of the illegalities. The rest half is not. The rest half is shown it's legal. That's the difficulty. It's the portion which I'm complaining. When I got the disketch plan, well, I saw that these if the plot was of 1 cut of 2 chataks, it has been shown in the disketch plan as 1 cut of 10 chataks. Well, there is a discrepancy between the sanction plan and the disketch plan. The disketch plan is prepared. I don't know how.
So you are challenging the disketch plan.
The entire proceedings is going. Entire proceeding has to be taken up afresh. That was the point before the building tribunal. That is what
so he is also saying that I am setting aside that directing the building tribunal to
what Mr. Kormakar is saying. Mr. Kormakar is saying. Only set aside the order of the building tribunal.
That's why initially I asked. That's why I asked initially Mr. Ganguly. Now you are supporting Mr. Kormakar. He said no. You are now asking for setting aside that order.
He is wanting demolition of 25 square feet. Well, I am saying it is 100 square feet of demolition that is required. If it is not in the disketch, well, how will the corporation demolish? But tomorrow the corporation I cannot demolish.
Disketch plan is there.
Defective, entirely defective disketch plan. Well, I can show. I have attached.
I think it's better if it goes to the.
What I have prayed below, the entire disketch plan, as well as the order of the SOB, as well as the order of the building tribunal should go. The disketch plan is defective.
Then it is to start from the SOB stage.
Yes, that is what I wanted.
What is?
Before the SOB, the disketch plan was before the SOB. The disketch plan is defective. Well, it's prepared only to support Mr. Kormakar's client.
May I say one?
Well, I'll show. Will I have an
No, Mr. Mukherjee, only one thing.
Special officer building order has already been set aside by the Municipal Building Tribunal. Now, my lord.
But the building tribunal has directed demolition on that disketch plan. Has to be. Otherwise,
the person responsible
for the disketch plan. Now he is challenging disketch plan. He is also challenging disketch plan.
I'm challenging the order of the building tribunal.
You are saying that the disketch plan was
considered.
Disketch plan is okay.
Ultimately.
So you demolish the balance portion as per the disketch plan.
See, I have an order of.
Set aside.
I'm entitled to regularization.
Where? At what stage?
But if according to him, it should be before the special officer building. But what he has paid for in the revision, although I have not been served, if you let see the revisional application,
Tribunal.
tribunal. Kindly see the,
But did you raise this point
Yes,
that
before the tribunal it was there. Before the tribunal it was there.
please show me where your submission was recorded?
yes,
এই ওই অন্য আইটেমটা বার করুন 58 apart from these three there is no other party.
No, no, no. Only us.
You three are parties.
Yes, only us.
বার করুন 58 টা. Yes, please show me where it
from
records.
grounds of appeal, your lordship will find. Because I am reading from the previous revision application, grounds of appeal, the respondent number 4 passed the impugn order without giving opportunity to the appellant complainant for hearing on the date of hearing such and such. Then the respondent number 4 never gave opportunity to the appellant to go through the sketch
So
plan.
that is another thing. That is
He raised this point before the building tribunal. There is a memo.
Claim is defective in as much as it does not indicate north of the said plan.
There's more. There's
no ground
But,
number ground number 3.
Ground number 3.
Yes, ground number 3 says this sketch plan does not indicate north, south, east, west.
This case also is defective. I can show me that I've annexed.
But you have not raised that point.
Yes, sir. I've raised the point.
Oh, boundary.
Yes.
Boundary has been increased.
Yes, sir. The boundary, the entire plot has been shown to be bigger. That is why there is no illegality shown on the northern side.
I don't know. Only thing in respect of this matter, my name and I is Sushmita Chatterjee.
আসুন both matters disposed of. আর আশাআশি একদম রাখবেন, কেন disposed of, আগেরটা can disposed of. Matter 15 না 14? Yes.
Matter, my lord, where I have filed an application for partition suit and injunction. My lord, I obtained a status quo order in the court below. My lord, that has been set aside by filing a miss appeal in the court below, where the valuation of the suit, my lord, will find from page 14 is 3,54,000. Page 14, my lord, and this is the valuation of the suit.
Page
14. There is a annexure plate. Range starts from 13. The valuation statement is made at page 14. But I am the appellant.
So you have filed before the wrong forum.
No, appellant is a defendant. I obtained the order of injunction.
Why did you not point out to the court
My lord, I have
that it
pointed
lacks
out-
jurisdiction?
I have pointed out.
Can you blow hot and cold?
I have
You took a chance there.
No, no,
After
my lord.
having the order goes against you, you have come up.
Not that, my lord. They have stated, my lord, they have not considered. My lord, this is filed before the district judge. The district judge, my lord, have assigned it before the additional district judge. So, my lord,
Should have pointed out that
We
the
have
district
not-
judge also do not have jurisdiction. taking steps for making any construction. So this will not affect you.
My lord, I will come back, my lord, immediately I will serve.
So I think it will not affect you, this order of injunction. Yes.
And the wife in a matrimonial suit filed an application under section 24 in the Marriage Act. But
You are the wife.
I'm the wife.
You want enhancement.
Inadequate maintenance has been awarded, my lord. Inadequate, my lord, amount has been awarded.
What is the adequate amount according to you?
My lord, he earns 1.5 lakhs per month. My lord, 12,000 has been awarded.
1.5 lakhs is your expenses.
No.
Have you given the details of your expenses?
5 lakhs per month, my lord. He is,
Yes,
my
yes,
lord,
yes. Have you given the
earning.
details of your expenses? On which account, how much?
1.5 is his earning, my lord. 12,000 is awarded.
I'm asking you, what is your claim?
My lord, in the application, my lord, it is claimed, my lord, much higher.
How much?
My lord, in the application, it is stated, my lord, he earns rupees 5 lakhs.
What is your
And
claim?
my claim was 1,50,000.
That is what I'm telling you. Have you given the breakup? What are your expenses of 1,50,000?
In the affidavit of assets, my lord, I have stated.
Breakup on which account? How much?
Breakup, my lord, I have not stated.
So you are incurring that expenses of 1,50,000 per month?
No.
You are not
why, my lord,
incurring.
that is why, my lord, I have prayed for, my lord.
How much you are incurring now?
Nothing, my lord.
You are not incurring anything. How are you
Lord,
making your both ends meet now?
Now, my lord, at the charity of my parent, my lord. At the charity of my parents, my lord.
How much you are getting? Charity of your, so you can make your both ends meet, and to other necessities, how much amount?
My lord, in the affidavit of assets, my lord, it was stated as 25,000.
25,000. So now you have been
I have been awarded rupees 12,000 per month.
12,000.
12,000 per month. But he has not produced any document to show his actual income.
Where are you staying?
At my paternal house. Paternal house.
You are staying at your paternal house.
But,
please see page 3 of the impugned order. Moreover, he is repaying the loan obtained by him to purchase the flat in which the petitioner is now residing. Petitioner may be the wife in the application in the miscellaneous case.
he has purchased the flat in which, my lord,
petitioner means wife is staying. You are not staying in the flat purchased by the husband.
No, there is no such, my lord, pleadings.
I record that. You will vacate that flat.
No,
if you
there
are
is
not
no
residing.
pleadings in my part, my lord, in my application.
No, I am recording. Have you taken instructions that you are not residing in that flat? Then I will record your submission. I will direct you to vacate that flat if you are residing there.
Since, my lord, it has not pleaded in the application, my lord, I cannot.
No, I am asking you. Have you taken instructions? Because this is the finding of the learned trial judge.
I have not taken instruction, but I have
Take
found
instructions, come back.
Might.
Then if you are not residing, if you are residing, then 10,000 plus 20,000 is 30,000. 12 plus 10 is 22,000. You have claimed 25,000. It's more or less the same amount. And if you say that you are not residing, you have to vacate that flat. I will enhance the element.
Then, my lord, let me take.
You cannot enjoy both.
Let me take instruction. Let me take instruction, my lord. Since there is no, my lord, averment in the pleading, but I cannot go beyond that.
Tomorrow, after some argument, the learned advocate appearing for the
My lord, suit for ejectment.
Yes.
I have filed, my lord, 7-1 and 7-2 immediately after appearance of the suit. And my lord, that was accepted. In the meantime, my lord, an application was filed by the defendant on the death of
7172 rejected.
on the ground, my lord, on this death of the sole plaintiff, immediately after my appearance, my lord, the suit was abated. My lord, originally we have appeared and filed applications under section 7172. My lord, in the meantime, my lord, the suit abated.
No, 7172 you filed, so
Ah.
you are complying with those. You are
71
depositing.
I am complying.
71
At
you are
that time, my lord, at this juncture,
plaintiff died,
plaintiff died.
suit abated.
Suit abated.
Then
Then, my lord, they
abatement set aside.
abatement set aside.
Then
In the interim period, I have not deposited because there was no landlord.
no, interim period meaning thereby when it was recorded as abated and they setting aside abatement.
After setting aside abatement, my lord, that we have, my lord, again made an application that this period we cannot deposit, my lord, under section. The court held that even if, my lord, in the death of the case was pending for substitution, I will have to deposit. And my lord, my applications under section 151 for deposit during the interim period, that was rejected.
Show me where is that recording that the suit abated and it was set aside,
My
abatement
lord,
was set aside.
kindly look into, my lord, the order sheet.
Yes.
First of, my lord, the order, my lord, 13th March 2026. Kindly turn to, my lord, the ordering portion, the petitions along with applications, Limitation Act, and same is hereby consent, but with cost of to be let the heirs of Bella Sur be substituted in her place as per the schedule.
The question that arises for consideration is
But for the petition.
before your lordship, a suit for eviction of a license. The stage is that, my lord, I filed an application under Order 6 Rule 17 for elucidation of the foundational fact made in my written statement.
Suit for eviction of?
A licensee. In my written statement, I have said that there is an agreement for sale being entered into by the defendant and the plaintiff, and that they are there.
So there's a counterclaim.
Counterclaim, there is no as such a counterclaim, but in the nature of an averment, in the paragraph 12 in the written statement, it has been specifically averred that out of 4 lakhs was the consideration amount, out of some amount has been paid to the plaintiff, and receipt to the extent of 89,000 was sought to be brought into record by way of an application under Order 6 Rule 17. The learned trial court dismissed my application under Order 6 Rule 17 being related because the evidence of the plaintiff evidence has been closed in the suit. If my lord may kindly turns to the amendment portion at page 26, rather at 27, last 3 lines. 27 last 3 lines, if my lord may kindly turns to. May I please?
Yes, yes.
এই বিবাদী গত ইংরেজি 27/1/2016 তারিখে তাহার এসবি অ্যাকাউন্টে হইতে চেক নাম্বার সাচের মাধ্যমে 89,000 টাকা বিক্রেতার স্বামীর ব্যাংক অ্যাকাউন্টে বরাবর জমা করিয়াছিলেন, উক্ত মর্মে এসবিআই হইতে স্টেটমেন্ট প্রাপ্ত হইয়াছে।
When the agreement took place?
But the agreement took place somewhere in the year 2016. Specific
16.
date. Yes.
And this application was filed?
This application for amendment has been filed in the year 2026.
So ex parte barred by limitation, Mr. Basu.
সম্মতি প্রদান করিয়া আমরা উভয়গণ গোবিন্দরামপুর মৌজায় সাধু ক্রয় করিবার জন্য বাদীপক্ষকে এই বিবাদী 2,40,000 টাকা প্রদান করে এবং উভয়ের নামে বরাবর রেজিস্ট্রি হইবে বলিয়া চুক্তি সম্পাদিত হয়। বাদী এই বিবাদীকে প্রলোভন দেখিয়া বলিয়া সম্পত্তি ক্রয় করিবার জন্য আরো 4 লাখ টাকা লয়। এই বিবাদীকে উকিল নালিশি জমিয়ে তাকে সম্পত্তি রেজিস্ট্রি করিয়া দিবেন বলিয়া প্রতিশ্রুতি প্রদান করেন, কিন্তু এই বাদী পক্ষ বিবাদীকে সম্পূর্ণ অব্যাহত রাখিয়া নিজের নামে উক্ত সম্পত্তি রেজিস্ট্রি করিয়া বিবাদীকে নালিশি জমি হইতে বিমোচিত করার অভিপ্রায় উক্ত মোকদ্দমা দায়ী করিয়াছে। But this was the foundational statement that there is an agreement for sale pursuant to.
So your statement was 4 and 2.40. So there has been stated.
Yes, Mark. In connection to that, I could find out a bank account where from I have paid a part consideration to the extent of 89,000. But that is my connection.
That will be changing your entire defense, because your statement is that it was the consideration money was 6,40,000 you have paid. Now you are trying to improve upon your case.
No, may I just indicate to Lordship, my lord.
What was the total consideration according to you in the written statement? What
total
you have stated?
consideration in my is that 2 lakhs and 4 lakhs.
Yes. So 6,40,000 you have paid.
40 I paid. My
Yes.
connection
So
to
now
that
it's a different case which you are trying to make
no,
up.
so to show to your lordship, my lord, the receipt of 89,000 was made available. But balance receipt will be produced in evidence. But this I want to establish that indeed I have paid the money.
You can produce that. So if it is according to you, it was within that.
In my restitution submission, that will not change the nature and character.
What?
Nature and character.
Maybe you can produce that. So that's the documents and evidence. Evidence, Mr. Basu, evidence did not be pleaded. So foundational facts are there. You can always lead evidence in
But to
support
that
of your.
extent, my lord, only one document I want to show, bring on record.
That need not be pleaded. Evidence is to be pleaded, Mr. Basu.
Not required.
Then,
there is another.
so if there is a foundational statement, you produce that in the evidence.
One more statement I have made in the foregoing paragraph. You might let me kindly turn to page 26 once. Page 26, I made here.
Where is your explanation with regard to delay? Please show me that.
But that is not there. That is not. May I just indicate? May I just indicate, Lordship? But these by bringing this statement, mainly this statement, others are not required by electric connection or my consumer number. Those are not relevant for the purpose of showing that I am in possession. I am in prima facie possession of the case. Only to the extent that indeed I have paid some money. That only 3 lines is required to be gone into.
That has not been taken into account. On merits, but only on that, I have come a belated stage that has been dismissed. But that in my responsive submission will not change the nature and character of the plaintiff's case. Kindly consider this aspect.
Mr. Basu, then I have to comment on this statement. What is the effect of depositing an amount in the bank account of the vendor's husband? That's your statement.
Yes.
Vendor's husband.
Yes.
So vendor will be bound by that. So you want me to deal with that? If you want, I can deal with that.
Kindly keep it open for the same to be decided by the trial.
No. I'm deciding it here and now.
My lord will not make any observation.
Because whether it is necessary for the purpose of deciding the real controversies between the parties. So an amount deposited in the bank
of the
account.
amendment application. Only my lord, kindly permit me to amend it to that extent, to that limited extent of 89,000.
Mr. Basu, if that is so in the evidence, I've left you at that. Now, since you have pointed out that those 3 lines, now I have to comment on that. This application under Article 227 of Yes.
Lord, it's interesting.
Opposing.
No, Lord, proposing.
You have chosen the wrong side, Mr. Chatterjee.
ও বাবা, আবার সাইডেরও matter করে। I usually don't change sides. I usually don't change sides as it is very prevalent
Now
these days.
you have done.
Prevalent these days, because I don't know.
Yes, what is the order under challenge?
It's a little interesting. I tell you, Lordship, Lord. If to appear on behalf of the defendant, judgment debtor, opposite party,
Judgment debtor.
defendant, judgment debtor, opposite party in a miscase under mean profit, where my main contention is that there was never a degree of mean profit. Number one,
There was never.
never a degree of mean profit. So assessment of damages do not apply at all. Lord, mean profits and damages are different things altogether. They are not similar. This is my submission.
This case has been disposed of.
This case has been now filed after 11 years, praying for
Filed. Then what has been done?
we have prayed for we filed an application initially for Milord saying that it's barred by limitation. It is not barred by limitation. If it is Milord maintainable, it is not barred by limitation. But I am saying, Milord, it's not maintainable at all. That application I filed saying that this miscase is not maintainable after disposal of the suit from the Supreme
Hearing, it has been fixed. It was fixed for hearing on 28th of July.
Yes. Yes. I am saying, Milord, it's not maintainable at all. I am saying, Milord, the miscase which is filed is not maintainable.
Any caveat is there?
My learned friends, sir. Now, Milord, why I am saying it's not maintainable? The first thing is that the degree which was granted, Milord, is with respect to that you are entitled to future damages. Then there was.
Where is the degree?
I'll show you. I'll just bear with you for a minute. I'll come back to that.
Yes.
That wording is important. Then, Milord, this was carried in appeal before the Supreme Court, which attained finality. There was a compromise. I was given 6 months' time. I was asked to pay, Milord, that period of occupation. They accepted that. I left. That degree, which was even passed by the trial court, was modified by the Supreme Court, and the Supreme Court passed, Milord, a final direction in the entire list. I am saying, Milord, that the list comes to an end with the order of the Supreme Court. The Supreme Court did not give an order for mean profits. So even if you go back to the trial court wordings and say that is basically mean profits, then that merges with the order, Milord, of the Supreme Court. So this application which you file after 11 years of that Supreme Court degree is a non-starter. This is the crux of the matter before your Lordship. Milord, your Lordship needs to decide in my respectful submission whether they are entitled to, Milord, even file for mean profits on the teeth of the order of the Supreme
What is the period of limitation for filing a miscellaneous case under Order 20, Rule 12?
Milord, the farthest that we can go is 12 years. The farthest we can go for 12.
By applying which article?
It's in the, Milord, I forget the number of the article. It will be
12 years by.
I'm saying, Milord, execution of a degree maybe. Let's put in that.
No, it's not execution of a decree. It's a
not
separate
basic.
proceedings for determination. It's not execution.
At that point, I can't take before your Lordship now because there was a separate application on that and that was rejected. So I'm not on
Application for limitation.
Yes.
That was rejected. You have not challenged that.
That challenge is over. It's done.
Oh, that challenge has been negated.
So I did not open my mouth on that at all. I don't want to get into that part at all. The limitation.
In a roundabout way, you are trying to take that point.
No, I am saying you don't have a case to start at all. I am going
Please
to
show me the decree of the trial court.
Yes, absolutely. Page 43. Kindly turns to Milord, page 43. But your Lordship is only
Yes, Mr. Banerjee, this has to be hard.
52. Yes, Milord, it needs a little bit of time.
Won't take more than 2 minutes of my lord's time. Won't take more than 2 minutes of my lord's time. Yes, yes.
Mr. Chatterjee has by this time has taken 15 minutes.
There's nothing in the matter. Let him, Milord, show the decree.
Yes.
Milord, the only, Milord, submission made by Mr. Chatterjee today is, Milord, damages and mean profit are different.
My lord, I learned from Mr. Chatterjee something, my lord, else.
That Mr. Banerjee is.
You have taught you the wrong thing at that point of
Must
time.
compensate
You are
me,
assisting him at that in that matter.
Yes.
You have taught you at the wrong time.
My lord, we have always learned mean profit is nothing but damages.
No.
The Honorable Supreme Court has said so on so many occasions.
Where is the decree of the trial court?
Yes. 52. My lord is only interested in 52.
52. Page 52.
Yes. बाबू এদিকে আছো ऊपर কাছে যাইয়ে that the suit be
কবে একটা জজকে এসে বললো
contest with cost against the defendant who is giving time for 2 months to vacate the suit premises. In default, the plaintiffs would be at liberty to recover possession by executing the degree. Plaintiffs will also get damages, but at present, the amount will be confined on which court fees have been paid. Future damages would be assessed as provided under law. Now let us refresh our.
Now, where is the appeal court's judgment?
Supreme Court.
Appeal court affirmed this.
Yes, yes. Milord, finality comes
So
to the
only
Supreme
modification by the Supreme Court.
Court.
Where is
57.
that?
57.
77.
57.
57.
And sees the following effect. That the petitioner, your lordship, would be interested in the third one. Sees the wording. That the petitioner will pay to respondent future compensation for you future compensation. Marks it. Future compensation. Now this is what he gets. He can't go back to the trial court again.
Please give me a minute. I'm taking time to go through this.
Yes, I understand that, and I also understand why. Yes.
Yes.
But in my respectful submission, Milord, he doesn't.
The decree gets modified by this order. So after this, nothing remains. You cannot institute a proceedings for mean profits.
11 years you can't.
Yes, now you are placing something from order 20 to 12.
No, see subsection 12.
Definition.
Mean profits of property means those profits. This is where, Milord, there's a difference between damages and mean profits. It's qualified. Which the person in wrongful possession of such property actually received or might with ordinary diligence have received therefrom, together with interest of such profits, but shall not include profits due to improvements made by the person in wrongful possession. So it's not basically damages. Damages has a wider connotation. Mean profits, Milord, is restricted to 2 subsection 12. And you need to obtain a degree on mean profits. A degree on damages is much wider. But if you say that you want mean profits, you come within.
Does it include mean profits as well?
In my respect submission, no.
You have said wider.
No.
If it is a wider, the subset is it includes.
My respectful submission is that mean profits and damages are different. You might call it a form of damage, but mean profit is a very restricted definition, 2 to 12.
Yes,
It
so
can't-
damages is a larger part
Absolutely.
of which is a main profit,
No,
is one of that.
Respectfully submitting. Damages could be way beyond mean profits. Mean profits has a definition. Definition is that it has to be of property means those profits. It's not damages. It's a profit which I have earned while in possession. Wrongful possession. Wrongful possession. So my wrongful possession, Millard, is only defined, Millard, by the degree. The degree grants me time for 6 months.
Profits will be ascertained by what mode, Mr. Chatterjee?
So that mode is a different mode altogether. I am saying you have not got a degree for mean profits. It has to be said that Order 20 Rule 12 is allowed and you have been granted that right under Order 20 Rule 12. So the assessment is not with respect to the damages. The assessment is with respect to the profits that I have got from wrongful possession. So you have to come to a finding that I was in wrongful possession and the assessment will come later. The Supreme Court doesn't give him that. The Supreme Court only gives him, Lord, if your Lordship sees.
Please show me that you have raised that point.
I have.
Please show me that.
Lord,
That was your argument and how it was dealt with
It's
by
a
me.
question of law, Lord.
For
Completely.
this you have not argued. Then, Mr. Chatterjee, only one thing: the miscellaneous case is pending. I give you liberty to raise all points there.
Lord,
That's one
am
way.
saying
That's one way of putting at it.
that is a one way of saying shirking my responsibility, remanding it back. 33C
No,
comes in on
I'm not, Mr. Chatterjee, I'm not shirking my responsibility.
Yes.
I'm telling you, giving you a liberty. Now choice is yours.
I'm saying I
Now
want to argue
choice is,
before your Lordship.
yes.
I want to
All
argue
right.
here.
Yes.
This is the day.
That is why I told you, because that point has not been urged there.
Lord, it was in a lot of ways it was. It's not that it wasn't. It was urged. Because our application is that.
It's an interlocutory application in the miscellaneous case.
11. Basically.
Cannot be order 7 to 11.
Basically. I'm not saying, Milord.
No. Principles.
Yes.
Even if principles.
151, your Lordship, by order 7 to 11 finishes, 151 starts. So I am on that fundamental principle decides it. Let the court decide as a preliminary point. That also I'm fine with it. But the court hasn't decided anything.
Creamy points. What are the other points left,
Nothing.
Mr. Chatterjee? So that is why.
Then you go into the merits. Once the demurrer goes, of course, order 7 to 11 stage, it will obviously not carry forward to the final stage. Final stage again, I will have.
Mr. Chatterjee, because maintainability has to be decided fast.
Not deciding it as an issue. So it will not be a res judicata in the final hearing. I understand that.
Yes. So
But
that
if
is
you're-
what
if I can convince your Lordship.
all points you can raise.
Sir, if I can convince your Lordship here, then the future litigation comes to an end.
Not convincing, also future litigation comes to an end.
Not convincing, the future litigation will, if comes to an end, very well, they will go. I don't have a problem.
Future litigation comes to an end in which way?
That is a different thing.
But decided by a 5 judges bench of Supreme Court whether mean profit
So,
is
Mr.
damages.
Chatterjee, do you have anything?
I mean, I'll immediately show the judge.
You are not entitled to it.
Acha.
You are not entitled to it. I am
minutes
not
by that.
on that. I said so. Damages, but qualifying. 2-12.
2 minutes by the clock.
Anything more, Mr. Chatterjee?
I have to develop this.
You have to develop this. When you will develop?
Whenever your Lordship please.
How much time you need to develop this point?
It will take 15 to 20 minutes.
So, 4:30
tomorrow. Die each other.
4:30. When?
Whenever your Lordship. But he's the busiest lawyer in Calcutta High Court now, according to his convenience.
But they are cross-examining my client. They are cross-examining my
Let
client.
that proceedings continue because
Has
staying
has
no.
Has to.
Mr. Chatterjee, staying will not endure to benefit of anyone. So if I set aside it goes, let that happen.
See if it goes.
Let that happen. No, Mr. Chatterjee. Let that happen. Let proceedings continue. When is the next date fixed?
9th of September. Put up the code and
14th,
But
315,
They will not,
315.
they will not, my lord, give a put up and say that it will be happening before the 14th. So they are good, yeah, so. ঠিক আছে।
Heard Mr. Chatterjee, learned senior.
Morning, I was late for, train was late, my lord.
হ্যাঁ আপনি দিয়ে দিয়েছেন তো হয়ে যাবে
Yes, Mr. Chatterjee, come at 2 p.m. He is saying, please show it to him.
My lord,
Once. He is notifying you.
নোটিফাই করেন আমি দিয়েছি
না, ওনাকে সই করিয়ে নিন, সুবিধা হবে, সই
এই যে
করে
আমি দিয়ে দিয়েছি চিঠি দিয়ে করেছি হ্যাঁ
So this is not the time for mentioning. No, no. Yes, yes.
My
Mr.
lord,
Mukherjee.
your lordship,
It's not the time for mentioning.
my lord, your lordship possibly remember, my lord, that your lordship has taken, my lord,
Your item number is which item?
37, my lord, and my lord, I have come today to know
37.
37, my lord, and
All
my
right,
lord,
let
day
me
after tomorrow, my lord, that they will take.
Let me see if I cannot reach by 3:15. Please mention at 3:15. I will take up.
My lord, then my lord, the day after tomorrow, my lord, that the physical person will be.
3:15. I will be taking up. Please wait. If it is not reached by 3:15, please
Tomorrow I have
remind
to
me.
go to Fortis hospital for my, therefore 2 days.
Yes, Mr.
operation only, my lord, for operation.
No, sir, no. Yes, Mr. Mukherjee.
the judgment which my learned senior friend has relied upon 2000.
Sir, please don't, please maintain decorum. You cannot come at any sweet point of time at your wish and mention a matter. Many matters, many learned advocates came in the morning. This is not the time for mentioning, sir. Matters are moved. In the midst, you are handing over the slip.
I was late for 10 minutes.
Maybe. Yes.
He has relied upon 2016 Supreme Court cases online partner 824. But kindly see, but these the suit in respect of one is my lord probate suit, one is my lord partition suit.
Yes.
Now, my lord, in this judgment, the judgment of Justice Pal, my lord, has been relied upon. Now, my lord, the coordinate bench sitting in the now the Honorable Supreme Court judge sitting in Patna, but said that this
So
is
this is the decision of which court now?
at that point of Patna.
No, no.
Now Supreme
You are
Court.
relying upon now.
I am not relying. They are relying.
Yes, so they are relying. Any of the parties now?
But my lord, court said that that judgment is distinguishable. Kindly see paragraph.
All right, I will record your submission that you have put that.
বাকি তো গেল, এবার আমার পেছনে এখন অন্য করে
Yes, you are distinguishing by saying this
দরকার নেই কিছু করার, ডিসমিস করে দাও বাবা।
does not have any binding precedent.
আরে
I
উঠে
will
পড়ছি,
record that.
পাঁচবার জন্য তুমি উঠে পড়ছো।
Yes, 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 and
Paragraph 4, your lordship will find paragraph 4 and 6. This is not applicable in my
probate
case.
proceedings are summary in nature, whereas the partition suit is plenary in nature. Where the questions of unity of title in the said suit, the legality in a partition suit and probate proceedings are distinct.
And
Title
the
suit
honorable
cannot be
judge,
stayed, which are plenary in nature. Probate proceedings are summary in nature to be granted by a court of limited jurisdiction.
facts of my case, but I'm distinct. My submission is this is not applicable to my case because my lord, the court has not considered, my lord, whether in the present proceedings whether an application for section 10 or club of proceeding has been mentioned or not. Number one. Number two, but in my case, suit for partition, And my lord,
So your case is not
in my case, their suit is for eviction.
eviction. Say
Eviction, my
so.
lord.
You are saying partition, I am getting
No, no.
confused.
Eviction. No matter what will happen, both of them are claiming the title over the property.
Eviction of a licensee.
Licensing.
What will be decided here? What will be decided?
What will
For
be?
the purpose of deciding a suit for eviction of a licensee, what's the thing which is to be decided?
In eviction of licensee, my lord, not because my lord, they
What
have
is to be decided if a decree is to be passed? What are the issues to be considered?
issues whether there is a lease agreement or not, verbal or
Whether there was
licensee, they in the their plaint, what they have stated, if your lordship see, according to them, but they have been verbally permitted me. Although we don't have any relation, we don't know who is he at all.
and what is the basic thing which is to be decided in a suit for eviction of a
What is
licensee?
my status?
Nothing more.
No, obviously, whether he has the right over the property, whether he has right over the property.
Right means
right title over the property.
Title.
Title is the main
So
thing.
title is the main thing.
Now,
So title is to be decided.
absolutely.
That is what I wanted to know.
Title. Now, Marat, kindly see, but in his plaint, he could not produce anything.
Not on facts, on these judgments. Facts you have argued.
Then, Marat, the second judgment which my learned friend has relied upon is, Marat, the judgment of our coordinate bench, Marat, Justice Bhattacharya.
No, Justice Basu's judgment, what do you say to that?
That is not, that is no.
Yes, that is.
I'm coming.
Live streaming is going.
আরে কি হচ্ছেটা কি? আরে বন্ধ করুন না।
না লাইভ স্ট্রিম বন্ধ করবেন না।
কি বলছেন সাহেব? বন্ধ করতে বলছেন?
না ওর কথা শুনবেন না। Seen this.
So these judgment, it is in my favor. Why I'm telling? But kindly see, two suit. One, there are three proceedings. One is probate, one is suit for declaration injunction, one is eviction suit. Declaration
injunction. Distinguishable facts. You did not distinguish. But the other judgment of Justice Basu.
If your lordship consider it as a judgment, but
its judgment is
mere suppose in Supreme Court, SLP dismissed. But that we are not saying that it is decided.
This is not SLP dismissed. It's a binding judgment. Result of the probate proceeding will not affect the decision of the other suit. Here, what is the other suit?
But kindly see then. One is for declaration injunction, another is probate.
Yes.
If your lordship says
so, here also title has to be decided.
If I put this question to myself, where is the finding of the honorable judge that the learned trial judge has rejected the said application only on
what I shall say to this judgment? I'm recording. Yes, Mr. Mukherjee, please tell me. Yes. What is according to you this judgment? Has not decided any ratio.
If I put this question to myself, where is the ratio let down?
So no ratio let down. Please give the answer also. You are putting the question to you. Please give the answer to that.
To myself is no ratio has been let down.
This is Mr. Mukherjee. That is why I asked you. This is a judgment. I asked you to give reply. This is a judgment which is directly on this, and I am bound by that.
Then where is the judgment of Justice Tandon Marat? If your lordship says that judgment is not binding, let them say Marat kindly record that. Kindly see another judgment. 2004 voluntary Supreme Court cases, page 85. There are some before Justice Lahoti, but paragraph 9, the Supreme Court said that yes, the suit has to be stayed, but for ends of justice.
Ends of justice? 142. What I can do?
Paragraph 9.
Mr. Mukherjee, you are citing new decisions, consolidation.
That this judgment has been considered in earlier.
Yes, heard the learned advocates for
My application, my lord.
Yes.
Lord, a registered development agreement was,
What do you want?
my lord,
Expeditious hearing
expedite disposal, my lord.
of what?
Of, before the consumer forum, my lord. Registered development agreement was executed in the year 2016. Since then, no work has been progressed except several fillings and the
This application under Article none appears for the petitioner. Yes.
Number one is the petitioner before your lordship
Yes.
in a suit, my lord, initiated under section 44 of the Transfer of Property Act. My lord, taking that it's a unit of dwelling house, I am a third party stranger purchaser, so my lord, I should be restrained, my lord, from taking possession. Kindly takes up the plaint. I shall.
So what happened? What is the order impugned?
My lord, order impugned, my lord, by virtue of the trial judge, temporary injunction application has been disposed of, directing the parties to maintain status quo. The plaintiff is not aggrieved by the order. I, being the defendant number one, preferred an appeal before the miscellaneous.
You are the stranger purchaser.
Yes. According to the plaintiff, I am the stranger purchaser. Lord, being aggrieved by the order of status quo, I being the defendant number one preferred an appeal. The appellate court on my appeal restrained, Lord, modified the status quo order, restrained me, Lord, from getting into the property. The defendant number one. Kindly see, Lord,
Rightly so. You have taken the risk of preferring an appeal. What can be done, Mr. Mukherjee?
Lord, kindly see one of the paragraph of the Lord, both plaint as well as the injunction application. First plaint, if your lordship takes up, Lord, the plaint starts, Lord, from page 11. Kindly takes up paragraph 10 at page 15.
Paragraph 10 at page 15.
Fine. Vis-a-vis, Lord, I shall show before your lordship paragraph 11 of the injunction application.
He has transferred it to
Yes,
you.
to a stranger.
Yes.
He admitted that he himself, a part of the Lord, dwelling house as per him.
Oh, this is the earlier transfer.
Yes. He himself has transferred.
No,
to a
I
third
was
party.
under
No,
the
no, no.
impression he has transferred and he has again
No,
fine.
not
Yes. So this is the earlier transfer.
earlier transfer made by the plaintiff, admitted by the plaintiff to a stranger.
Then thereafter, who transferred in your favor?
Lord, one of the co-sharer transferred in my favor. And Lord, paragraph 11, Lord, similar at page 23 in the injunction application. And I shall show before your lordship the observation of the learned trial judge, why status quo. The learned judge has observed this only, that when you, by your own pleading, has admitted that there are already stranger purchasers who have stepped into this property, suit property, which according to the plaintiff is a dwelling house, then how I can directly pass an order of injunction restraining the present defendant number one. That's below the page 3 of the learned trial court order. Not the last annexure before your lordship. Has your lordship got it? Not page 3 of the trial court. Oh, sorry. Paragraph 11 is at page 23.
Where is the trial court order?
Yes, trial court order is the last certified copy. Order number 17 dated 30th July 2025.
It's not the certified copy.
He has not obtained the certified copy as yet. Applied for. So that's different.
Applied for before which court?
To the appellate court.
Appellate court for return.
For applied for certified copy. The records are there in the appellate court. Appellate
What
court.
is the procedure, Mr.
I thought not.
Can you get a certified copy from the appellate court of the trial court's decree?
No, the records are there. That's why might have been. I do not know.
Mr. Mukherjee, a certified copy from a certified copy can be issued. He is saying, and you are also submitting that. So how can a certified copy of a order sheet certified copy be issued by the appellate court? And you are submitting that.
Ought to have been for the trial.
But the easiest way is to take return from the appellate court.
Page 3, Milord, of the trial court order.
Yes.
The paragraph starts with, thus I am of the considered view. Has your lordship got it? Nearly bottom. Milord, thus I am considered view that the plaintiff might suffer irreparable loss if the relief of the injunction is not granted to the plaintiff. However, a total restraining order is not warranted at this stage since there are many other co-sharers in the suit plots and some of whom are not the family members of the plaintiff as stated by the plaintiff.
If primacy appears to this court,
revalidate the status quo order because
That means I am setting aside this without hearing the other side.
that's true. May I come back, Lord? It's from North 24 Parganas. It will not take much time.
Service motion September month list. Next.
I am for the opposite party.
My lord, my case is, my lord, the petitioner is a, my lord, defendant, my lord.
Please give me 1 minute.
When we file a
Please give me 1 minute.
happy, Miss
Monthly
Happy.
list.
Miss Happy has
Monthly
been
list, it's appearing.
against
Monthly
that,
list, which item? বার করে নিন তো।
against Miss Appeal, my lord, I challenge before this honorable court.
Give her a copy.
But I have served earlier.
The earlier copy.
This civil division application. Please serve a copy upon her. I'm taking it tomorrow along with that one.
What is the date for execution?
Madam, I will be evicted tomorrow.
Yes.
Mr. Chakraborty, only one thing, the CO is pending.
Already
It's
passed.
appearing in my list.
Sir, the CU number today itself. It is running in the list.
You will kind of
Very short code. Very short
All
code
right,
is
pass
involved.
over করুন। বার করুন ওটা দেখছি।
Not sure.
Pass over. Yes, next. 24.
24. I am the defendant.
Yes.
About the section 7(3) that has been
7(3) allowed.
Yes, by the
Yes.
learned court.
Yes.
However, sir, now in this matter, I am delaying by about 5 months from coming for a revision. Now the thing is, sir, I have
What is the infirmity in the impugned order?
sir, now one is that the limitation. The court is saying that submitting section 7(1) application does not come under the Limitation Act. And second is that court is saying that not knowing that you have to submit the deposit and application in the 7(1).
That you have not done within time limit.
Sir, I have the problem.
Yes or no? Have you filed? Then
Not filed, sir.
Then what can be done?
So now the thing is, sir, that so as far as the coming under the 7(1) coming under the limitation is that, sir, section 40 says about any proceeding or appeal in the Tenancy Act can come under the Limitation Act. Sir, and the definition.
Not come, sir. These points have been considered. I have delivered 2-3 judgments on that, considering section 14. Now there is a Supreme Court judgment.
Section 14 of limitation, you are saying.
Everything will not come in your aid.
So it's a genuine, if you just take a look at the condonation and which is attached.
Condonation, if there is no power to condone, section 7172. Up to Supreme Court, now it has been held.
So there are so many. I have also cited a few judgments in the application of 7.1. I've cited a few judgments.
Where is the judgment? Please show me one of the those.
Sorry, not sir. The order is there. Sorry, sir.
In the order, it has been referred to.
My application of 7.1, sir. It is there, sir.
What are the judgments? Please tell me which judgments.
Sir, the order. It is the case is running, sir. The next date is 18th September.
That's neither here nor there. Which judgments you have referred to?
Sir,
PP Khemka.
Sir, the judgments are.
PP Khemka is on 1956 Act. So this will not do. 87 Supreme Court 1010. No longer can apply in 1997 Act, sir.
1987.
1010.
Yes, sir. 1010.
Yes, yes. So those decisions have been considered. It has been held. It will not apply the 1997 Act. Mr. Chatterjee, give him the 7-day Adventist. He's appearing in person. Please give him that. 7-day Adventist, Devashish Pal. Those, and you have my judgment. I have considered this section 14. Your senior appeared. You have that because he is appearing. Please give it to him.
I will get the online. I will get it, sir. When
He is giving the reference.
Yes.
Please go through that since you are appearing in person.
I will take it, sir.
That is why.
I will take it. Sir, paragraph 11, sir, the same page, sir. Same page, sir. Paragraph 11, sir. This it's an old judgment, but sir, this.
Now it's well settled, sir. Cannot be done. 1997 Act, there is no scope. 56 Act, there were several judgments, and those were considered subsequently. These judgments said no, those will not apply in 1997 Act.
Paragraphs are same, sir, basically. Just that, meaning that
No.
controller, that paragraph.
Now I am bound by the Supreme Court judgment. Supreme Court judgment says you cannot condone the delay. I am helpless.
The paragraphs are basically they are same.
I cannot say that. Supreme Court has said no, paragraphs are not safe. If you want to come back, I can request Mr. Chatterjee to give you those references. You can come
I
back.
will be grateful.
When do you want?
Sir, tomorrow.
Tomorrow. What is the next date fixed?
Sir, 18th September, sir.
Of 2026, what is that?
That is for the condemnation period of chief petition, sir.
Yes, next. Nothing in it. Nothing in the matter. Your facial expression shows there is.
On a suit for declaration and my lord recovery of position, my lord.
Yes.
Two defendant is there, my lord. One defendant, my lord, accepted and my lord appearing.
What do you want?
My lord, defendant number expeditious hearing.
Expeditious hearing.
Defendant number 2 is my lord avoiding my lord. I also my lord.
So what can I do?
I have published this, my lord. Author 5 Rule 20, my lord. My lord, kindly direct them to direct my lord. Just
This application under Article 2.
Yeah, urgent matter বলে execution, বলার the court belief already বলার
Caveat, you are for the caveat.
Yes, yes,
Yes, what is this matter?
but this one is a mysterious application, but that matter may be after that.
After that means
Sir, item number 26 and 52 is analogous.
it's the same matter, same parties.
Same parties.
Item number 52. What is 52?
Only point বলার the
52
Lordship, in item number 26, they didn't serve the copy.
Yes, have you served a copy of in this application?
yeah, that application may be hard.
This application,
These application are hard ballot after.
then you have to take a chance in that. You will not solve a copy.
That court ballot, this is an urgent ballot.
All, please serve a copy upon him. Please serve a copy upon him. Let,
Lordship, I am praying for 2 days of accommodation.
for what?
For
This matter.
for
And
this
the other matter?
as well.
Why? What
Your
is
Lordship,
justice?
your Lordship, the
But I.
What is the order under challenge in that?
Challenge is not the that you should verify ballot the final degree and ballot the sketch map. What ballot I file an application before the court to supply the sketch map.
It's in 52 ta. Out. Yes, call the next matter. Yes.
Your Lordship takes up page 11.
Page 11. What is this one? Who are you?
I'm the judgment data. But here, admittedly, the order 21 rule 97 application admits that resistance were made sometime in 2009.
Limitation.
And the application has been filed in the year 2017. Admitted from their own application.
Don't resist, Mr. Mukherjee. Please give the position.
Article 120. And my case is only based on this.
The police will not go.
No,
Police will not go.
application itself is
The
not.
decree has not been set aside. So possession, again the bailiff will go. He will resist. Then they will file an application for police cell. Then the police will go. You have some respect in the locality, Mr.
That's the
You
Your
are
Lordship has
inviting
settled
that. Mr. Mukherjee, you are inviting that.
I'm not.
So police will go and it throw you out. You have some respect in the locality.
This I have been faced with one of the matters for Justice Mundo.
Justice
Mundo. He said, packet better, packet honor.
Yes, yes.
Now, kindly takes up page 11 once. Here, your Lordship will get the resistance. Kindly takes up page 16, paragraph 12.
Page
16, paragraph 12.
You have filed another suit. Degree holders, because of filing of another suit, title suit number 4 of 2010 in the Lanet Code in January 2010 for declaration and injunction.
That's not I don't have
You don't have that instruction, Mr. Mukherjee.
My case is simple, based on paragraph 12 and the application.
Yes, paragraph 12 contains those amendments. Another suit.
And this application is being filed in 2017.
They are staying that suit.
Resistance and filing of application cannot
If there is a stay of execution, it appears from the averments.
They have also not
Could not take steps.
They could not able to take.
Yes. because of this, suppressing, posing themselves as Shebayas, status quo in respect of the property till 9/2/2010. What are you saying?
Then also, my lord,
Till there was status quo. How can the possession be taken?
application is filed in 2017.
Has to be because that order of status quo was there. Mr.
2010.
Please bring those orders.
2010, and application is filed, my lord, 7 years thereafter.
Till how long that was there? Nobody knows how it was extended.
Execution বলছে না। Filing of application, that, my lord, the period of limitation has reckoned. If you have filed an application, make
Mr.
it
Mukherjee,
pending.
you have not raised this point at any point of time. This creates serious doubts.
But I say, my lord, the court, my lord, under section 3, it's the incumbent duty of the court.
No,
my lord,
no,
to
that
do
is
that's where I am.
that's very easy to say. Section 3, yes. And it does not say that you have to close your eyes and to sleep in slumber. And when the police help is allowed, then you come and take that.
Now,
When the suit was there, status quo order was there, then the order of temporary injunction was dismissed in 2013. Thereafter, a miscellaneous appeal. Several facts are there.
That event also,
Must
my
be.
lord, with the-
Please show me the initial order when the this is the ultimate order. In item number order dated 2nd of June. Please show me the when this application was filed. The first order of filing this application. Please show me that. Portions which are in favor of you or against you.
Yes, January 2010 is the date of resistance as per the application itself. And, my lord, this application is being filed in 2017.
When you are substituted, degree holders, they died. When they were substituted,
Yeah, but then your lordship knows that in execution case, substitution is not necessary. That's because I am not taking other issues. I say his own application demonstrate before the learned executing court that it's a time-barred application. Expressing. Sometimes the judgment makers are also entitled to take, you know, the legal benefit. That's why, you know, I know, you know, regarding merit, your lordship is absolutely right, but he has to file an application. You know, he has to, you know, file an application of
the High Court, you should not take technical pleas.
That's your lordship's court's judgment, because the lordship's court has interpreted Article 120.
In support of such yes.
This will not make a petitioner's application for seeking expeditious disposal of the suit
Dismissed.
But for the petitioner plaintiff. That's the
The
suit for
Chatterjee,
eviction of
please allow your juniors to move at least expeditious hearing matters.
this is a suit for eviction of trespasser.
Yes.
But on 30/3/2023, PW1 was closed.
On
30th of March 2023.
yes.
And it was fixed for DW.
Yes.
So till now, DW never started. And there are two
Order 22
applications.
Rule 3 application, what happened to that?
Right.
Order 39 Rule 7 application is also pending.
Yes, Milord. 151 application and one Order 39 Rule 7 application.
Those are pending.
Yes, Milord. And one for substitution, Milord, that was allowed.
Substitution allowed. So it was at the stage of the evidence of the defendants.
Yes, Milord. PW1 concluded.
This application under Article 227 of
and for the disposal of a title suit, my lord, is pending since 2016.
what is the stage?
Still now it is SR appearance, my lord.
Yes, sir. Sir, what can be done? This application under Article 220. Yes, what is the impugned order? Order 39 Rule 7 rejected. Order 39 rule 7 for what?
What's the actually there is a there was an identity of status quo. Taking advantage of the status quo, the defendant is allowing benefits of the after this pass an order CO 4180 kindly come to the page number 65 words.
Where is the plaint? What is the suit for? Where is the application under order 39 rule 7?
Nine.
69. Why you want? How these points are necessary for the purpose of deciding the suit? Whether there is any closed circuit camera, whether there is. Those are the points.
Actually, what happened? They are not allowing me to enter into my.
That cannot be a ground for applying for local inspection. That's another thing. If you are having an order of injunction in your favor, violation, that's another thing. These points, how it is relevant in this suit? Who is possessing? So you are trying to fish out evidence. Possession cannot be decided by way of local inspection. No, no, no. None of the points can be allowed. You want to decide the question of possession, how that can be done? By way of local inspection?
I have been ousted for my.
That's neither. That's a different thing altogether. So if you have been ousted, there's no necessity to decide who is in possession. Have you admitted anywhere that you have been ousted? Then, so how the possession? So it's admittedly in their possession. So why local inspection?
Ousted and I have previously I had filed one application under 151.
That's a different thing altogether. For that, why local inspection? If you are admitting that you are out of possession, then there is nothing to be decided by way of local inspection. You have only paid for in whose possession it's there. It's difficult. Ashun, this application under article. Sir, can a possession be decided by, do you have an authority on your support? Possession can be decided by way of local inspection. Which points you want, please tell me. Which points according to you can be decided by way of local inspection? Please tell me. So if you are not ready, I can adjourn this. You can come prepared. Which points according to you the local inspection can be held on this? All goes to possession. 1, 2. Present status. What is the status? What have you stated? Have they disputed the status?
Under I have already stated that I have been ousted.
So for that, local inspection is not necessary. Why local inspection? So if you have been ousted, you want to get back. There are other remedies. Sir, if you are not ready, you can come back better prepared. After some argument, the land. Next. Yes. Yes.
My lord, come to annexure B, my lord.
Yes, page.
Page starting at 27. That is
Yes.
certified copy page.
Yes.
To 28.
Page 28. Yes.
Shall I read, my lord, or you shall go through, my lord? Shall I read, my lord? What is put up today at the instance of
What is the impugned order which is under challenge?
just coming before the impugned order, I would just like to cite this order.
What is the order you are challenging? I will allow you to place this. What is the order under challenge?
That is under annexure A, my lord.
Page.
Page.
Certified copy.
Yes, my lord. Certified copy.
Order dated 30th of June 2026.
Yes,
That's the order under challenge.
Yes,
please give me a minute. Yes.
Kindly come to the annexure B, my lord.
Yes.
I'll just read the important portions, my lord. The second para, my lord. Sorry, I'm reading the first para. Learned advocate for the plaintiff by filing copy of the notice dated 19.
Don't read the entire order. Please show me the.
The thing is that, my lord, the thing is that I appeared on 20. I was the defendant in that suit. And after getting the notice on 20th of September 2025, within 4 days, that is on 24th of September 2025, I appeared on the day of injunction hearing. I filed my counterclaim and a discrete application for injunction. The learned trial court held an analogous hearing of both the injunction application, that is my injunction application as a defendant, and the injunction application that was filed by the plaintiff.
Yes.
Now,
then what happened? What happened to the
learned trial court gave a very good observation, my lord, with regards to the.
So the plaintiff's injunction prayer was rejected. Your injunction prayer was allowed.
Allowed on the grounds that the plaintiff has made.
Then what happened?
Made suppression of facts, and he was doing an unauthorized construction. Then, as per this order, my lord, come to the next page, my lord, the last portion. The date 20th of February 2026 was fixed for acceptance of WS along with counterclaim. Now come to, my lord, the next annexure, that is at page 30.
So your written statement was accepted?
No, my lord. It was just kept for acceptance. I was
all right.
I filed it within 4 days within the limitation, and my counterclaim also, along with the WS.
Yes.
The next date fixed was, my lord, come to the next page, my lord, 30th, annexure C, order number 4.
Annexure C, yes. Order number 4, yes.
Order number 4. This was the date, my lord, that is the 20th of February 26, the next date. But unfortunately, in my own diary, my lord, I have recorded this date as 24th of February, and I was not present on that date. But no prejudice has happened to the plaintiff, because the plaintiff.
But what happened then?
I'll read the order.
Suit was directed to proceed ex parte against you.
No, I was directed to show cause.
Yes, why the suit will not proceed ex parte?
And the plaintiff had also filed an adjournment on that day. So no prejudice happened.
Yes.
Now come to the next page, my lord. That is on 30th. The next order is 30th of March 2026.
Yes.
I filed my reply to show cause, and the plaintiff all of a sudden filed an withdrawal application. On that date, though the learned court heard the application of my show cause, but due to the since the order sheet of the record was not tagged, the court could not record the order.
and the again suit proceeded to the next date, that is for the 30th June of 2026, the date of impugned order. Now, the point of challenge, my lord, in the impugned order, there are 5 level points, my lord. Kindly
Yes.
come to page 10 of my 227 application, CO application.
This argue
Page 10, my lord, page 10.
page 10, yes.
Para 20.
Page 10, paragraph 20.
Para 20, my lord.
Yes.
That although the learned trial court recorded the petitioner defendant's contention regarding the failure of the respondent plaintiff to disclose any legally sustainable formal defect or other sufficient ground as contemplated under
So that withdrawal application was
allowed without granting liberty to them to file afresh any suit. But my lord, there are
challenging that order.
And not that portion, my lord. The other portions of the order, there are certain omissions in that order, madam, my lord.
So you are challenging the order by which the plaintiff was given liberty to withdraw that suit with liberty to file afresh.
No, yes, my lord, yes.
That order you are challenging.
Yes, my lord, but not that portion, my lord. That portion is correctly settled, my lord, by the learned court. That without the learned court has granted without liberty. But there are the counterclaim has not been accepted as per the order 8 rule 6D. Notwithstanding the plaintiff is withdrawing the suit, I am the defendant, my lord. I have already placed my counterclaim, so it will act as a cross suit. The learned court has kept silent on that, my lord.
If there is no suit, where is the question of cross suit?
Definitely, my lord. But there is a.
Since you have used the expression cross suit, that is what I am telling you.
But,
if there is no suit, where is the question of cross suit?
I'll take your lordship. Kindly come to.
I give you liberty to file a suit.
No,
that can be treated to be a suit.
Kindly come to order 8 rule 6D, my lord. It is clearly stating. I'll give you an authority, my lord.
Yes. Authority for what? Withdrawal of a suit.
No, I mean, I'll give you a judgment. I'm sorry.
Yes, for what?
It's clearly mentioning that notwithstanding the withdrawal of the suit, the counterclaim will subsist.
No qual to that proposition. Statute is clear.
Yes, my lord.
Yes.
Yes.
So you proceed with your counterclaim. Who stops it?
Counterclaim has been adjudicated only. Either it is accepted or rejected.
Has it been dismissed?
The suit has been dismissed.
That's what I'm telling you. Your counterclaim still remains.
But that the learned court has not done nothing with that, my lord. It has remained silent on that. And also it has not accepted or rejected my reply to show cause.
Petitioner appearing in person submits. Matter. What is the can for?
Madam, for that interim stay of that the impugned order, operation of the impugned order, my lord.
Yes, next, call the next matter. Yes.
Plaintiff opposite party lordship by alleging that the then petitioner is trying to making construction over the suit plot lordship filed a suit for eviction without implementing me as a party in that suit. Eviction suit was decreed.
Filed a suit for eviction.
Without implementing me as a party lordship. I filed an lordship order 97 rule 100
order 20 rule 97 to 100. Now, at the date, Lordship, when it was fixed for hearing of the stay application, learned trial court without hearing the missed case dismissed the suit. We prefer an revisional application. Liberty was granted to Lordship prefer an appeal because at this stage, this Honorable High Court Lordship was of the opinion the original remedy is lying with the appellate court. We prefer an appeal. Affiliate court reject the stay application on the ground that at this stage it is not possible because I have a knowledge that the decree was passed against me and the bailiff was sent. Kindly comes to Lordship the impugned order, Lordship.
No, stay, Mr. Sannal, how that order can be stayed? Because
Lordship, the
appeal was filed with section 5. If the appeal is filed with section 5,
Lordship, kindly
then
consider
unless
it.
section 5 is
Yeah.
allowed, how can an interim order stay be passed?
Because Lordship,
Order 41 rule 3 capital A, sub rule
capital
3.
But Lordship, considering the urgency, Lordship, learned appellate court can grant an order of stay because Lordship 28 is the date for Lordship giving the possession.
28th.
28th of this month. That was mentioned. The
Is directed to serve a copy. The petitioner, sorry, you are a senior advocate, the juniors are sitting there. What they will is submitting, the opposite party is jumping up. Yes, yes.
My lord, the fact remains that the original defendant of the instant suit was a ticket tenant under the erstwhile land.
Please show me your written statement. Have you taken that plea in the written statement?
That's why I am willing to amend this written statement.
Sir, you cannot do at this stage if there is no foundational basis. What was your written statement? Please show me that.
When this
Can you take a new line of defense by way of amendment?
is the fact that a notice has been issued by the ticket tenancy controller.
Sir, you are not understanding what I am saying. Can you take a new line of defense? One defense you have taken in the written statement. Can you take a new line of defense by way of amendment?
On several occasions, the defendant tried to amend his
That is the original written statement.
The statement has not been annexed in this application. The statement has not been annexed in this application.
Mr. Basu, do you have the original written statement with you?
No. Milord, may I only indicate, Milord, before that, on 31st October 2025, same line of defense sought to incorporate by weapon order 6 rule 18, Milord, that has been
Order
dismissed.
6 rule 18.
17.
Yes.
31st October 2025. Same line.
That was also
That was
also
rejected.
they did not challenge.
They did not challenge. Kindly cease.
1st October.
Yes.
Yes.
But if you have not challenged that, how can you take another same
this
plea by
This
filing?
notice has been issued on.
No, same
Sir,
point.
that's neither here nor there.
Not there.
That cannot give you a rise cause of action.
And
Are
then,
you,
my
you
lord,
are aware of this order?
Actually means that, my lord.
Sir, are you aware of this order?
Yes. For a moment. That originally the defendant
Then
herein
order
was a
7.
ticket tenant. He submitted return in form India 1983. India 1983. Thereafter,
Sir,
the
if you have not
property-
taken that plea, then you cannot change your line of defense. Where is your written statement? Where is your written statement?
Then value-
My lord, then
Well, not today.
it is not,
But,
subject to correction, it is not required.
Part by res
Yes.
judicata. Same,
Every stage
same
of
prayer
process.
for
It's not a same prayer.
Yes, kindly cease.
Not a same prayer.
On other hand, I am coming. From the certified copy of the order dated such and such,
I have a look to the order
but it is
amendment. What I am saying is
during the pendency of some facts have been cropped out and same are required to be incorporated in the written statement for a proper application. As such, played for amendment of written statement as per schedule of the amendment appended to the insert petition. On the other hand, though no written objection is filed by the plaintiff, it is submitted by the learned advocate for the plaintiff. The order has already been set aside by the Honorable High Court of Calcutta. This amendment has no leg to stand upon. Learned advocate plaintiff submits that the order was set aside, but matter has been remanded back to the Thika controller for reconsideration. But the fact that the LRTT has observed the property to be a Thika property needs to be brought on record so the para such and such may be allowed and such and such be rejected.
on the same factual aspect.
Yes,
That,
from the order dated
sir, where
7.
is the original written statement? Please bring the
No,
original.
Milord, this point was made available to him. He said just now, Milord, few minutes ago, from 83, Milord, he had returned. Suit is for 1991. Now, Milord, kindly says that this order that at this stage, now he says, Milord, in that order 6 rule 17, also, Milord, the plea of Thika tenancy was also there. WPLT is categorically, the point was made available to him. Number one. Number two, Milord, Justice, this court, Milord, kindly says, this is, Milord, the order 7, rule 11. He had filed. Your Lordship's court, Milord, by an order dated, Milord, 22nd April 2025. May I read for my lord or you hand over? This application under Article 227 of the Constitution of India is at the instance of the defendant and is directed against an order number such and such at Presidency Small Courts, Calcutta, such and such. By the impugned order, application under Order 711 stood rejected. The learned advocate appearing for the petitioner submits that the petitioner herein has been declared as a Thika tenant in respect of the suit property. He therefore submits the civil court does not have jurisdiction to decide the instant suit in view of the law provisions laid down in section 21 of the West Bengal Thika Tenancy Acquisition Regulation Act 2001. Mr. Roy, learned advocate appearing for opposite party submits that the issues
Where is the order dated 22nd of April 2025 passed in CO number 413.
This one, nothing remains. Nothing remains.
This application under article.
Nothing remains.
So this order was yes.
Fact number 34 is my application. I am for the opposite. But although there was no caveat, but since they requested us for a copy, we have supplied a copy.
Yes. Are you ready, Mr. Nag? You want to come back tomorrow?
Tomorrow is the matter fixed. Tomorrow, Milord, is the matter fixed before the estate officer.
Yes.
The issue is that, Milord, the estate officer had earlier initiated a proceeding under section 4 of the premises. Now, Milord, in that proceeding, on the second day, upon filing my written statement, the proceeding was closed and order was reserved. So, challenging that, we had come before your lordship. Lordship had been pleased to stay the proceeding, and stay the order, declaration of the order as well. Now what they have done, subsequently they have also appeared in the matter. Now matter is also appearing in today's list also it is there. Now what has now been done regarding the same issue between the same parties, the district officer regarding the same property has initiated a section 7 notice. Basically, it's a bypass. In order to bypass that proceeding which has been stayed, a new proceeding has been initiated seeking recovery of money. That was for eviction. This is for recovery because I am not leaving the property. I am challenging that notification. Lordship would come with the. I have already filed my written statement, not considered, and I was before your Lordship. Lordship has been pleased to stay the proceeding. Lordship would
Where is
find
that matter?
that is not the application is annexed at page 162, and Lordship's order is at page 190.
Mr. Nag, I am keeping these two matters tomorrow.
201.
Please don't proceed with that. I'm not passing any formal.
One thing.
I'm not passing any formal order of stay. Otherwise, I will be passing a formal order of stay if you are inclined to proceed with that.
I just want to spell out one thing.
I'm keeping it tomorrow. Heavens will not fall. List this matter. You are appearing.
But kindly record that I don't need to appear because otherwise they will again.
Learned advocate appearing for the petition.
He is not there.
Yes, call the next matter.
He has arrived.
No, Mr. Chatterjee.
আমি তো আগে এসেছি
Yes.
I'm for the opposite party.
Yes.
I'm for the opposite party.
Who is for the petitioner?
No, Priyaji.
Otherwise, not they will proceedings.
Yes. The next matter, yes. Who is appearing?
There is a caveat.
Chatterjee, you are appearing.
There is a caveat.
What is this?
There is a caveat.
Mr. Chatterjee, there is a caveat. Please give him a copy. Why have you not given copy?
No, there is a problem because it was posted on Friday. It's come up today. I'm not.
Nowadays, you are serving copy to the learned advocate also by post.
No. It was this matter was supposed to come up on Friday.
Yes.
That's what I'm told.
Supposed to come up on Friday. This see, 10th of today is not 10th of August.
Same thing.
Today is not 10th of August, Mr. Chatterjee.
No, my lord, it's my mistake. My mistake. I'll rectify it. Kalki.
Yes, next.
No, carry direction. Direction.
Not me.
Mr. Basu Lanes, When?
Tagged with 88. Whenever 88 is taken.
Yes, I think two matters have to be hard analyzed.
226.
This matter along with
27.
you are the court trust. You are appearing in both matters.
Yes. No, in that matter, yes.
I think Mr. Nag appeared. Where is Mr. Nag?
I'll take it.
List this matter along with CO number. Please give me that.
Item number 88 today.
Item number 88 is CO number টা লিখে দিন।
The court that your lordship has fixed it along with it.
Wednesday, Thursday, which day? Thursday?
Thursday week.
Thursday করে দিন।
Thursday week.
কোন দিন কম?
Thursday week করে দাও।
Thursday week?
হ্যাঁ।
Thursday week তাহলে
This
করে
week,
দিন।
my lord, I will be in a little bit of a.
All right, Thursday week করে দিন। Thursday week date করে দিন। Yes, call the next matter.
তাড়াহুড়ো করছে কেন?
But I will be candid, my lord. I am not on caveat. But if your lordship kindly directs me to serve a copy, my lord, I can come back tomorrow.
Very short matter. In a sense, my lord, the certified copy of the deposition, I tell your lordship what happened. The petitioner husband have deposed cross-examination through Skype. And my lord, it was recorded in a CD, my lord, which was my lord, led by the advocate commissioner who has.
What happened today? What happened today?
My written notes of arguments have been directly to be filed. The proceedings have itself been closed. Only the BNA has to be filed, my lord. The date has been given today. The matter was
Hearing
fixed.
closed.
Yes.
Hearing
The
argument-
BNA had to be submitted, my lord. The date
Well,
aside.
we have also inclined to do it only, my lord. We have prayed, my lord, that the CD and all those things to be given and 3 days times to be.
What CD?
My lord, I tell your lordship, the cross-examination was recorded through Skype, Skype, and that was recorded in the CD and a pen drive was submitted by the advocate commissioner who have taken the cross-examination. Without considering that, my lord, this is only, my lord, the learned judge granted us time, but the documents and the certified copy we have applied. Certified copy, some of the depositions were handed over to us, but with regards to the only, my lord,
Matrimonial suit, evidence closed, argument closed.
Yes.
What remains?
written argument.
I think it's better you can take this point in the appeal. Otherwise it will be a difficult thing. I think that's better.
Your lordship knows until and unless we are considering the evidences, lordship, it's not in a.
Sir, everything is closed now. What will be done?
We have to file our written arguments. And my learned friend who is not averse to it, he is also.
Oral arguments over.
Oral argument is over.
Yes, my lord. The proceedings have been closed.
You have to file written arguments on the basis of your oral argument. What remains there?
Exactly.
Over. Now there is nothing left. I was giving you that choice. You could have the order dated this matter, Mr. Odhikari, you are mentioning before 3:15.
Your lordship is.
Yes.
Order, my lord.
Yes. Any caveat? No caveat. Yes. What is this matter?
My lord. Matter, my lord, kindly have a look, my lord. Page number 111.
Page number 100.
111.
111.
My lord, Annexure J. My lord, I should not openly speak it, but kindly go through.
What is this matter, Mr. Odhikari?
My lord.
Please give me a brief background of this.
Just, my lord, that they are going to take possession.
No. What is the order under challenge?
The order under challenge is, my lord, your lordship will kindly see page number 111 is the order under challenge.
Then please give me a minute. Please give me a minute.
Only fourth line starts. Fourth line. Fourth line is the vital one.
Yes. What can be done, Mr. Odhikari? You have taken various adjournments.
No.
That is the
It is
finding.
not. Your lordship will kindly see that if there is such, I am giving this undertaking that only on.
What is the
Your
application
lordship
form?
kindly see.
What is the application? What is the application? What is the application which you have filed?
My lord, the application is, my lord, beforehand we will have to go to, my lord, that the honorable, there was a revisional application before the honorable High Court. And my lord, it is vital page.
No, Order 21, Rule 97 was for what?
Yes, Order 21, Rule 97 means it's a third party interest.
You are the third party.
Yes, we are, my lord, that when I have purchased the property, it means I've got the by gift it, my lord. Then there was an order, and by
What was the decree for?
Decree for there was an ex-party decree.
For what? What is the nature of the decree?
The nature of the decree is ejectment decree.
Ejectment degree against you.
And no, against me, not. I am the third party.
Yes.
And thereafter, my lord, that is what happened when I have come to know that the entire property is under my gift, and my lord, that at that point of time, I protested, and my lord, there was an order of Honorable High Court. Your lordship will kindly see. That is the order at page number 99. It is onwards. There it has been stated clearly that this is the matter will be taken up in this way and manner. Now, violating all these, para 16 is the impugned order at page 107. That is the, my lord, that the Honorable High Court's order.
Order 9, Rule 13.
Yes, my lord. Therefore, your lordship kindly see, having considered the aforesaid facts and circumstances of the case, the present application being is disposed of with a direction upon the court below to dispose of the application under Order 9, Rule 13 of the CPC being miss case number 185 of 2023, preferably within a period of 3 months from the date of communication of the order. The impugned order dated 19/7/2024 so far it relates to the payment of occupational charge by the petitioner in favor of the opposite parties is a state till disposal of the aforesaid miss case being miss case number 185 of 2023 by the court below. Now, if your lordship will kindly see, there your lordship will find that here there is already existence of the miss case. That means the third party intervention is there. When I am the third party and when there is such, then
No, this miss case, Order 9, Rule 13 was filed by whom?
If your lordship will kindly see this.
No, filed by whom? Order 9, Rule 13 filed by whom? Order 9, Rule 13 was not in your instance.
My lord, your lordship kindly see first 110. Page 110. Your lordship kindly see. Then it.
Yes.
Kindly see. Today is fixed for awaiting order of miss case number 196 of 2023. Both parties filed their respective steps. As miss case number 196/2023 has already been disposed of by this court, by order on number such and such, date 5/8/2020, same day, when the senior advocate could not remain present. Advocate. As such, I find no impediment to proceed with the instant execution case. So hastily, he has decided to 7/8 for office report regarding police cost. And police cost has been deposited, and it is going to be, my lord, that I will be disposed that everything, my property will go. The question remains here. That means that when it has been hastily, my lord, that it is going on. My one thing is that if maybe for any reason whatsoever, for the advocate's presence or non-presence, the matter could not be taken up. And on the same day, you will also kindly see order number 112 dated 5/8/2026, and on the same day order number 113 5/8/2026. Now, what happens? Therefore, on the day when the learned lawyer is not being able at least to remain present for having at least that he say, therefore, principle of natural justice, that means audio order and patent, it is not so hasty. Means justice, it means justice buried. Make haste, but not in a hurry. Now, here in this case, the hereditary decision has been taken on the same day, and the police force will go there for no reason whatsoever. For the absence of the particular advocate who is the leading advocate and who is to move it, and he is because of his sudden illness and he had to go to Fortis hospital at least for his checkup. That is the most question to be considered, only that part. And therefore, my lord, I am saying that let the police, my lord, that the stay of the execution, at least for the limited purpose, but it is a checkered history, it has already gone through. my lord, that it means it is a basic voluminous order which we have, my lord, that after covering all the sites, my lord, that the Honorable High Court, my lord, this Honorable Court has passed the order and favoring everything. So, my lord, what was that? Hurry, why it is? Wholesome blanket order is not the Periamols issue. Periamols, my lord, that the here, my lord, Honorable Justice Pankaj Mithal, my lord, that while sitting with the senior judge, Honorable Justice Pardiwala, my lord, that it has been seen that there is a fabulous one, means that when the fraudulent one, then in that case it is not. Therefore, my lord, when there is a clear finding of this Honorable High Court very recently, then on the basis whether the learned lower court has proceeded with it in this way and manner.
Mr. Udhikari, who has filed this application under Order 9 Rule 13?
My lord,
Who has filed?
your lordship will kindly see.
Who has filed Order 9 Rule 13?
And then it is by the actual judgment letter. It is one part. And my lord, the fraudulent activities, where is your lordship?
Where is your Order 21 Rule 101 application?
Yes.
Where is that?
My lord, that your lordship. My lord, I am giving a very short history when your lordship.
No, please show me that. Where is that application?
My lord, that is near about 2.5 crore property on the means near the Mirza Gali state. And my lord, that by way of deed of gift, I have got the property. And my lord, that when I have got that property, my lord, I have come to know in peaceful way, means these very particular.
When is the date fixed for eviction?
12th, my lord, that yes, that means with police force.
12th.
Not 12th, with police force, we will be ousted. Then, my lord, my right, what has been, my lord, that is seen after 3 days hearing, my lord, that is honorable court. Means that this honorable court was pleased that well, in this way it will be done, but it has not been done. It is very funny thing, my lord, that therefore I am not at this juncture, my lord. We have to stop it here in this juncture, at least for stay for the time being, my lord. I am here because with the honorable court order we are, and we have to express it before the learned court.
Mr. Udhikari, learned advocate, appealing All further proceedings, it has to be by police help.
I'm deeply obliged.
Yes. I think Ms. Chakraborty was appearing. In this one, Ms. Chakraborty was appearing. Where is she? Yes. Where is the other matter? Dekhi.
The other matter, my lord. 4267.
4267 এটা?
67 of 25.
হ্যাঁ, এটার সঙ্গে
I challenge before your lordship, before this honorable court, my lord, against the order of the district judge. Rejection of the order, my lord. So 5 and happy. Then, my lord, the honorable court, my order, take my lord. Order page, my lord.
Yes. What is wrong in this order? What is wrong in this order? In
My lord, order already, my lord, dismissed, my lord.
yes. What is infirmity in this order?
Then yes.
4267. CO 4267.
Yes.
Yes.
The other side also appearing, my lord, in this matter.
Lordships, I am led by Shoni Chakraborty. I am seeking for not today, Lordships.
Not today. Then what can be done? Tomorrow is the date.
I am seeking the short passover, Your Lordships. I am just
3:30.
just short passover, Your Lordships.
You remain. Yes. You are the advocate on record.
No, Your Lordships. I am not.
Who is the advocate on? You are Raj Junior.
I know.
You remain. Yes, yes.
Next week, my lord, your lordship, next week.
Yes. What is wrong in this order? Please tell me.
You can see the order.
Yes.
First, my lord, 930 rejected. Page 70.
Yes.
Order was passed by the ex party, and my evidence is that someone was not served. It's ICTC's office, center, my lord. I the ICTC of center. Order 913 I have it. Page 17, my
The factual adjudication, both courts. How can then, if there is no infirmity, how can I interfere with the under Article 227?
What is the order 930? Someone was not served. That was not decided by the.
Sir, your knowledge, please see this. You are present at the time of inspection, everything. Please see the trial court's order.
Yes.
So everything was recorded.
Order 913, my lord, your lordship, you can see.
That's your contention. That is your contention. Please see the
Page 30. Trial court order. Degree was passed, ex parte.
that I have followed. Please show me what's wrong in this order.
My degree has been passed in ex parte. Passed the ex parte. Against the ex parte order, my lord, I prepared application. He said. My lord, delay was, my lord, 808 days.
This is the eviction of a school, ICTS center. So that has to be served on that ICTS. It has been received by the person.
Appointed appear Mr. Moloy Raj. He has been the bank fees assets. Moloy Raj. Some of the responding.
Some of the other opposite parties, let them appear, but it's the plaintiff who is concerned. It's the ex parte decree.
Dependent.
Yes.
Six Logical ECB order, 6 and 5. Is 30.
Yes, an accommodation has been sought for on the ground of tomorrow is the date. There shall be an order. Yes.
Your Lordship, Your Lordship, in item number 26, I am praying for 2 days accommodation in item number 26. 26.
Today, already 5 bigas of land. Total 40 to 50 bigas land. This is a partition suit. Kindly paying.
What will happen if it is taken up day after tomorrow?
But they take all this land without verifying the documents.
What is the date fixed before the court below?
But each already issued. We're taking possession and submit a report on 29th August. Submit a report. Possession already started. Today, they started 5 bigas of the land up to 40 bigas.
Well, I'm keeping tomorrow.
Your Lordship,
Tomorrow.
Your Lordship, kindly, because Mr. Chakraborty is out of station. Sukanta Chakraborty.
Mr. Chakraborty.
Sukanta Chakraborty, sir.
Call it. Just started, nothing will happen. Yes. Next.
In item number 26 and 52 as well, Your Lordship. In item number 26 and 52 as well. And in item number
both matters, it will appear.
And they have served the copy.
You serve a copy in 26?
They have served.
Yes.
As the matter was before the tribunal today, it has been adjourned, my lords, to 3rd of September 2026.
When it has been fixed?
3rd of September 2026.
3rd of September.
Lord, Mr. Joy Shah is also online. My lord, I didn't have the privilege of, my lord, hearing him, my lord, when he was. My lord, can you give me the?
কাজ করছে না?
My lord, when he was. ঠিক আছে, on আছে? কাজ করছে না। My lord, I'll use this one.
What happened to your voice?
My lord, I have something called Renke's edema. That means talking too much. Vocal cords are flooded. And I have not really been good with my voice therapy. So on and off. I'm supposed to drink a lot of water. That's what it is.
And you have to give rest to your throat.
Yes, I'm giving
That's
rest. my
what
lord,
you
now.
will not be doing. Yes, yes, Mr. Mukherjee.
Yes,
You wanted to say something through that system so that Mr.
Yes,
Shah
my
can-
lord, I wanted to say only one thing. My lord, Mr. Joy Shah had appeared before the tribunal today, and he can narrate for 2 minutes the reaction of the bench when your lordship's order was shown.
My lord, before that, my lord, with Mr. Mukherjee's leave, may I just indicate, my lord, there are two applications, my lord, that have been filed, my lord, before the learned tribunal. One is, my lord, for contempt, and the other is, my lord, for execution of the order of which contempt is alleged. So, my lord, against the same order, one execution petition, one contempt petition. Now, my lord, we had filed an application, two applications for demurrer, saying number one is contempt says pay money. There can be no contempt for payment of money. And my lord, the second is, my lord, if you've already filed an execution petition, then how can you again file a contempt? My lord, these, whatever, my lord, we had filed two applications for demurrer. My lord, when the time comes to move the application for demurrer, my lord, the court directs us to withdraw it. So I will not hear your application for demurrer. When I refuse to do that, my lord, there is an order which has been passed by the court, to which, my lord, I'm sure Mr. Mukherjee will draw your lordship's kind attention, which says, please take instructions whether you will withdraw. And, my lord, the matter is adjourned. On the next day, my lord, I go back. I say that I've taken instructions. My instructions are not to withdraw. All that is recorded, and then, my lord, thereafter, my lord, the petitioner, my lord, Mr. Vadera's client, my lord, asks for adjournment. The adjournment is given. My lord, today, my lord, when your lordship's order of 7th, my lord, August, my lord, is pointed out, then, my lord, a comment was made by the court, my lord, saying that you all are filing petitions here, filing in the NCLAT, filing in the High Court. Does the High Court know what you're doing? So, my lord, to that I responded that, my lord, even if the High Court does not know what I'm doing, even if you assume that I am concealing and hiding things from the High Court, the other side is there. They will point it out what I'm concealing. So, my lord, with some difficulty, my lord, it was kept, my lord. We had said that the NCLAT date is, my lord, on 25th September. Keep it after 25th September. To which the other side objected. It was kept on 3rd, and, my lord, we were directed to file an affidavit. What affidavit, what application you filed before NCLT, what application you filed before High Court, please produce all that.
So it has been now on 3rd of September.
My lord, I just wanted to, my lord, narrate this aspect of the matter. My lord, because my learned friend was there. Now, my lord, the most important thing is, my lord, he wasn't a party, my lord, before, my lord, the.
Mr. Sen, please let me hear.
No. Yes.
I will hear you. Please.
My lord, may I, my lord, indicate?
Facts, what is
Yes.
there because.
Yes. Now, my lord, this was a company which was the subject matter of, my lord.
Give a short background.
Yes, short background.
Entire scope of
yes.
this.
Now, my lord, Hindustan National Glass, my lord, is one of the leading, my lord, glass bottle manufacturers, my lord, in India. My lord, for several purposes. My lord, for water or, my lord, for beverage. My lord, it was one of the leading manufacturers. Now, my lord, unfortunately, my lord, it fell into difficult times. So, my lord, there was, my lord, an initiation of a corporate insolvency resolution process. My lord, several, my lord, resolution applicants applied for takeover. My lord, at the end of the day, my lord, an entity known as Independent Sugar, my lord, became the successful resolution applicant. My lord, the order holding, my lord, that, my lord, the resolution plan was sanctioned is still pending, my lord, before, my lord, in appeal before the National Company Law Appellate Tribunal. This is, my lord. Now, my lord, my clients were, my lord, the erstwhile promoters, my lord, of the company, my lord, the Somanis. My lord, there are several branches of the family, this particular branch. And, my lord, they were part of, my lord, the suspended board of directors who could attend, my lord, committee of creditors meetings, my lord, for the where, my lord, resolution plans, etc., were being placed. Now, my lord, what is important is, while this proceeding was going on, my lord, there was an application under Section 66 of the Insolvency and Bankruptcy Code. My lord, popularly, my lord, or in common parlance, referred to, my lord, as a PUFE application. My lord, these are, my lord, where, my lord, there are fraud, etc. My lord, there can be directions given to, if any loss has been caused to the corporate debtor, for the money to come in. Now, my lord, by challenging, my lord, certain transactions. Now, my lord, in this matter, my lord, in the PUFE application, my lord, an order was passed on 12th of September 2025. In that, my lord, there was a big claim of close to 70 crores, my lord, made against, my lord, my clients that we need to put it in. And, my lord, including, my lord, 3 third parties. My lord, for 2 of the third parties, my lord, National Company Law Tribunal or the adjudicating authority, my lord, held no case had been made out. In respect of one of them, my lord, it held that no documents, etc., were produced, though, my lord, several documents were on record, and the resolution professional, my lord, in spite of having records, had not produced it. The result was, my lord, third party, my lord, nothing was really said, my lord, against, my lord, the third party, but a direction was given against the erstwhile promoters, that's my clients, to put in, my lord, 44 crores. And, my lord, there was also a direction that, my lord, criminal prosecution should be, my lord, initiated. Now, my lord, this was challenged in appeal. My lord, when the challenge was made, the immediate urgency, my lord, was that of the criminal prosecution. And, my lord, the court granted a stay, the appellate authority, with regard to the criminal. Now, my lord, there was no, my lord, stay, my lord, with regard to any further proceedings that could be initiated. Now, significantly, my lord, the order provided that if I do not pay this money, my lord, then, my lord, steps could be taken for attachment of our properties. A specific provision in the order.
That order is the parent order by NCLT.
Correct. That was not touched because now, my lord, what happens after this order is passed, 2 applications are made. One for contempt for not making payment as per this order, though there is specific provision, my lord, that, my lord, there had to be, my lord, one could proceed against my properties.
Execution.
Correct.
Is execution.
Correct. And second, my lord, was, my lord, an execution. Now, my lord, both these, my lord, applications were filed by the resolution professional. Now, my lord, the resolution professional, after, my lord, the approval of, my lord, the resolution plan, my lord, is, my lord, really, my lord, functus officio, has no further role to play.
So, according to you, you are challenging the locus of
Correct.
the resolution.
So, my lord, first is the contempt proceeding itself, my lord, that is without jurisdiction.
According to you, whether contempt and execution can both lie at the same
My lord,
time?
not just that, contempt cannot lie at all. Cannot lie at all for 2 reasons. My lord, there's a Supreme Court judgment now, my lord, which says that if it's for payment of money, my lord, arising out of a decree, then, my lord, it should, my lord, not be the subject matter of contempt, whether Order 39 Rule 2A or, my lord, by way of contempt. My lord, there's, my lord, a judgment to that effect. And second, my lord, which is very important, my lord, is, my lord, it's at the instance of the resolution professional, my lord, who is not, my lord, the decree holder. And similarly, my lord, as far as, my lord, the execution is concerned, it can only be, my lord, by the decree holder, because the provisions, my lord, which have been invoked, as well as the rules, my lord, of, my lord, the NCLT are similar to our Order 21 Rule 11 and, my lord, definition, my lord, of, my lord, decree holder. holder of the decree, my lord, is the one, my lord, who can, my lord, file the execution. So, my lord, our demurrer was.
So according to you, the orders in whose favor the direction
Correct.
to pay
Correct.
money was passed, he or she could have.
Correct, but not, my lord, which is why, my lord, my learned friend has come and made the intervention application. Because, my lord, if at all it's in favor.
He is the decree
Yes,
holder.
yes. Yes, but he has not filed an execution. No. 1 minute. It's fairly serious. Now, my lord, third thing, my lord.
Mr. Shen, please apply your mind before applying for intervention after
Yes.
hearing this.
Yes. Well,
After hearing his submission.
Yes.
Everything goes back there.
Now, my lord, third thing which is important is these actions, my lord, were taken after, my lord, the interim order, my lord, by the appellate tribunal. Now, my lord.
But the interim order, Mr. Mukherjee, according to you, was staying one
Correct.
portion of
Correct. My lord, I'm not. Now, my lord, why did we, my lord, if your lordship reads that order, your lordship will find that our immediate concern at that point of time, my lord, was, my lord, the criminal, because that could be, there was no execution at that time. Now, my lord, yes, my lord, your lordship will also find, my lord, from, my lord, that order, that, my lord, the appellate tribunal held, my lord, that there were interesting questions, my lord, which had, my lord, come up, which needed to be decided after hearing, my lord, the other side. My lord, after, my lord, exchange of pleadings, etc. And, my lord, fixed an early date for hearing of the matter. Now, my lord, as luck would have it, my lord, before, my lord, it could be heard, my lord, Justice Ashok Bhushan, my lord, was heading, my lord, the National Company Law Appellate Tribunal. My lord, he was, my lord, his tenure, my lord, was about to expire. It got extended, but, my lord, it could not be taken up because, my lord, all matters where, my lord, the hearing had happened to a substantial extent, my lord, he was, my lord, disposing of those matters first. So, my lord, through no fault of ours, it couldn't be taken up on time. Then, my lord, what happens, my lord, on the 16th of April, my lord, of this year, my lord, itself, the my lord, tribunal before whom the execution and contempt was, my lord, pending, my lord, apart from, my lord, asking, my lord, Mr. Shah's client to take instructions as to whether demurrer would be, my lord, withdrawn or not. Also, my lord, said that, my lord, because, my lord, the appeal, my lord, was pending, my lord, that it would, my lord, adjourn it to a date after, my lord, the date fixed for hearing of the appeal. It was pointed out, my lord, because there's really a short point involved here.
Without interrupting you, before the appellate NCLAT, it's the main appeal against the order of the NCLT. But with regard to the stay application,
yes,
so that has been disposed of.
No, my lord, the immediate stay, my lord, was, my lord.
Yes, what happened to the stay application? Because one part was stayed.
Yes.
But what happens to the other part?
My lord, it's, my lord, filed along with the appeal. So, my lord, that it's a petition form, my lord, there.
Yes, but it's taken up at the final hearing. So, this prayer might have been taken up before because it's an interim prayer.
So, my lord, I'll proceed on the basis that, my lord, what? Yes, now, my lord, the matter, my lord, has, my lord, been kept for admission. So, my lord, the issue of stay is still alive.
So there is also a procedure for after admission. Then
correct.
But the first part has been stayed.
First part even before admission, my lord, because there was
been done. That's one part.
Yes.
If that is so,
yes,
the other part also stay prayer
has been refused. It could have been taken up. It was not entertained because there was no immediate urgency. Your lordship will find that from the order.
Yes,
my lord. But be that as it may, my lord, first time round, exercise of discretion was we'll await the hearing of the appeal because there was a few days, my lord, between when the matter came up, my lord, before, my lord, the, my lord, adjudicating authority and, my lord, the matter fixed, my lord, before the appellate tribunal. My lord, then, my lord, second time around. So, my lord, what we did, my lord, was, my lord, we made an application also again, my lord, to, my lord, the appellate tribunal, saying, my lord, now that everything is ripe for hearing and there is and the appeal has been appearing regularly in the list and we are willing to, my lord, it was appearing at 2 p.m. every day, but not being taken up. My lord, our request was that till you take up, you kindly grant a stay. That application was pending as well. My lord, that application is still there. Now, my lord, it got notified on a particular day. My lord, after Justice Bhushan, my lord, retired. My lord, it was before the officiating chairman. My lord, he didn't sit. And my lord, the matter got, my lord, re-notified to the 25th of September from, my lord, the 4th of August. This is what has happened. Now, my lord, we pointed all this out. So there were really three grounds, my lord, which were there. First is you have to hear demurrer first. Without deciding on the issue of maintainability, you should not go into it. And my lord, maintainability was filed even before directions for affidavits were given in the contempt as well as, my lord, in, my lord, the execution. Second, my lord, ground, my lord, was, look, you yourself have exercised the discretion not to hear it till appeal is taken up in the first instance, 16th of April. You are now refusing on 10th of June. You ought not to have done it. My lord, that is one ground which is under challenge here. And third, my lord, in any event, we have an application, my lord, for, my lord, stay of, my lord, further hearing on, my lord, this matter. And therefore,
before the NCLT.
NCLAT.
Or before the NCLAT.
Second application for stay. Because the order was.
What happened to that application?
Pending. Not taken up because bench is not sitting.
But Mr. Mukherjee, only on one aspect, the directions for payment of money. So it's more or less like a money taking.
Correct, correct.
So for stay, are you not required to secure that amount?
Yes, court can put me on terms for, my lord, a stay.
If that is
done, no, but there's already a remedy. No, but what about contempt?
No, contempt, I think if the amount is secured, will they then be pressing with the contempt?
No, my lord.
That I do
yes,
not know.
So, now,
are you willing to secure that amount?
No, because, my lord, the person who has filed, my lord, has no locus. He's not a decree holder. He's not a decree holder.
And he's functus official.
My lord, all that we are saying.
There are two ways.
Yes.
One is, before the appellate court, you can file an application for stay of operation of the judgment and decree.
Yes.
So that's
that we have done.
Part. That's one part. Another is for stay of all further proceedings of the execution case.
Yes.
In stay of further proceedings of the execution case, you may have a point that the person who has put the decree into execution or the order into execution do not have locus standi. But insofar as the stay of operation of the judgment and decree.
My lord, I'm not asking for that here. My demurrer is exactly that he has no locus. That's, my lord, before, my lord, the adjudicating authority itself. All that I'm, my lord, your lordship asked me on the last occasion. Am I willing, my lord, if, my lord, the demurrers are taken up first? My lord, I'm happy. I'm happy with that. Let them be taken up first.
Yes, what? Yes, what do you say? The demurrer applications, good, bad, indifferent, that may be something worth not consideration. But since it has been filed.
To that extent, I do not have any objection because the demurrer application have to be taken first in order of priority.
Yes, because once with regard to any proceedings, if the maintainability is challenged, good, bad, indifferent, that might be on the face of it, it might appear that there is nothing on the objection as to the maintainability. Since an application has been filed, it has to be taken up.
Let the tribunal consider the demurrer application first. There is no objection to that.
Kindly let them decide that first and then proceed. No, they are forcing us to withdraw. That's exactly, my lord.
Because they have
Mr. Sen, let us not enter into that. So Mr. Shah has said something with regard to certain observations. Let us not enter into that. So let us not enter into that. Since the demurrer application has been filed, good, bad, indifferent, you might be saying that there is nothing. Mr. Mukherjee is saying, I have on the basis of this demurrer application. Might be you are opposing, you might say, Mr. Mukherjee is saying that there is something which says, so they have taken out an application. Let that be decided. After the demurrer application is taken up, is considered, and if it is rejected, then the question. If it is allowed, then everything
That's the end
goes.
of the matter, my lord. That has to
Then
be
everything
decided
goes.
first.
Does not say at all that the demurrer application shall not be taken up. In fact, the order which they have come up against, order fixing the matter today for hearing. without any discussion at all as to whether the main matter will be considered, demurrer will not be considered, nothing. Only thing I'm violently saying, let us not go into that matter. The lordship is saying
That can be clarified.
you can of course, but this should not open the gateway for a 227 from a adjudicating authority's order. This your lordship will take it.
So once
There are every order which is going to be passed, you will come up here by way of
My lord, my lord, if I have a constitutional right, my lord, that can't be taken away.
limited sphere we will.
Correct.
Within the limited sphere we will.
Yes.
Plus, one small clarification, the reason why the tribunal had insisted that they withdraw the demurrer is because they had filed a reply to my contempt and my execution. It was essentially the same pleadings.
My demurrer was first in point of time.
One is on the merits.
Which they refused to withdraw, which is all right.
Yeah, so one is on the merits. One may at times we are also saying that if you have taken this point of objection in the main, why piecemeal? Let it be decided once for all.
That is recorded
But
in the order.
that's one thing. But if it goes to the root of the jurisdiction,
Grateful.
so if it goes to the root of the jurisdiction, then it is to be taken up at the threshold.
Correct.
So if there is a disputed question of fact and law, yes, you may say it has to be taken up at the time of final hearing. Let both these be taken up. At times we are saying that this issue with regard to the mentality has to be taken up first, decided,
My
then
lord,
decide
and
the other
both
issues.
points, my lord, both cases contempt
With Mr. Mukherjee's leave,
the root of
Yes,
the
Mr.
matter.
Mukherjee has raised, according to him, it goes to the root of the jurisdiction that, according to him, the person who has taken out this application two folds. One, he says contempt application is not maintainable from the nature of the order from which the contempt application has been filed. That's one with regard to the jurisdiction. Second, he says that the resolution professional after now do not have
He's not the decree holder. It's admitted, my lord.
yes,
My lord,
do not have locus to file
he's
that.
not the holder of the decree.
So let those points be decided.
We will oppose.
my lord, as a matter of fact, I'm sorry to interrupt my friends. My lord, Mr. Vadera will bear me out. My lord, when my demurrer petitions were taken up for hearing, Mr. Vadera, my lord, appears and asks for direction to file affidavit to my demurrer petition. The court says, what is the use of doing that? Why? We'll hear it all together. No need to file
So,
affidavits.
Mr. Shah, only one thing, they are entitled to file an objection to the demurrer.
We have no
My lord,
problem.
he wanted to do
bench
that. The
doesn't
court
want
said
to
it's not
file.
required.
Mr.
He
Shah,
wanted to, Mr.
let's not go
Vadera.
into that because
Very
your
well.
other side adversary, he is also not opposing to
Yes,
the
your
taking up
lordship
of
can
the
finish it here, my lord. The demurrers to be decided first, my lord. After
so it's fixed on second,
third.
So you take out your file your objections, if any, in the meantime.
Very well. We shall do that.
And so what are fixed?
My lord, four things are fixed, my lord. Contempt, demurrer against contempt.
Where do
My
I
lord,
find? Which
execution.
paragraph of that impugned order do I find all?
My lord, your lordship kindly comes to, my lord, the impugned order, the page 401, my lord, if your lordship kindly takes.
Page 401.
Yes, my lord.
Yes, first volume, first page, first volume, last page. Mr. Mukherjee, at the beginning I have the order. Can you mention the paragraph or the internal page number of that order?
My lord, my lord, kindly have a look, my lord, at para 2 at 402.
Para 2, yes.
Counsel for reiterated same arguments during so and so, so and so. Counsel submits there another so and so.
Resolution professional has no locus standi to file
such an application. Submits there another IA so and so and IA so and so filed under so and so have been filed on behalf of the respondent, challenging the maintainability of this contempt application and seeking its dismissal. My lord, heading has the other matter, my lord.
All right.
Contempt A IBC 6, IA IBC 204. My lord, this is my lord execution.
Correct me if I am wrong, I am dictating.
Yes, my lord, the heading has two. The lordship sees order, there are two, and there are two down here, my lord, in para 2.
All right.
The headings are mine.
Yes, correct.
The
others are the maintainable.
Order of the bench 2. Kolkata
Unfortunately,
bench,
it's
Special bench.
special Kolkata bench, my lord. For
special
once,
Kolkata bench will do.
special bench, my lord, off, my lord, the Kolkata bench.
Special bench Acha, we can't out disposed of.
Yes. My lord, in view of this order, nothing is, my lord.
In view of the first your order, nothing remains to be.
Lord, presence of Mr. Sen is recorded.
Yes, that's important. Yes, call the other matter.
Mr. Ray's one of the urgent matter, the urgency.
Sorry, Mr. Mitro, Mr. Banerjee, Mr. Ray.
No, no, no.
Some delay because. Yes, how long it will take?
20-25 minutes.
Can I take 5 minutes of your time?
Motions will be taken up tomorrow. Upgraded motions will be taken up tomorrow.
Upgraded. After this, if you are here, I can take up. To Dakota. Because long sitting, it's a problem.
No, no, my lord.
Yes.
কোথায় লোক কোথায়?
In the meantime, let them come.
Yes. Only one submission, my lord. Then your lordship takes it up tomorrow, but my lord, before 4 months. Because today I was supposed to go, my lord, I did not because of this matter.
Please start. You can start.
Yes.
Because Mr. Rai, it's difficult because discussions are there. That is why I'm trying to keep this hotly contested matters after some small matters are taken up.
My lord, on the last occasion, my lord, I had made my submissions, my lord. After the fact, my lord, because your lordship was more minded to hear on what the urgency was. Delay. Now, my lord, the delay part is already there, my lord.
Yes.
And I've given more or less the facts to the extent of the urgency I've given you, Lordship. But Malad, may I just first point out a few very basic things. Malad, today we are here, Malad, from an ad interim order refusal of stay at the ad interim stage in an appeal from an ad interim order. So today, Malad, the impugned order before your Lordship is that order of the trial of the appellate court refusing to stay and saying that I will hear it on affidavits. One. Second, Malad kindly sees what my learned friends are today wanting is basically a reversal of the first order before your Lordship of the trial court. That the injunction should be vacated.
Or in a way, stay of that.
That is why I'm giving your Lordship there. But if it's a stay, Malad, it tantamounts to allowing the appeal. Malad has also followed those judgments. Malad, I've got all of them, Malad, with me, Malad. So that, Malad, that is a settled law of your Lordship's court. But if that is otherwise, Malad, I would obviously consider that. But on that only, Malad, your Lordship will kindly remember, Malad, I've shown your Lordship the judgment of the appellate court. Appellate court found that there is no perversity. Even taking into account, Malad, I'll show all these judgments, Malad. Yes, the Choksi judgment, your Lordship is well aware, Malad. Now, at that point of time, perversity is what is required to be seen. So we cannot say that the appellate court has faulted in passing an unreasoned order. One. Second, Malad, your Lordship kindly appreciates, just keeping aside the delay part. Let us just keep aside the delay part for a moment. Because on facts, Malad, I can show, Malad, that there is no delay, Malad. I can show that evidently, Malad. Malad, even the facts here are glaring. Malad, I have heard a lot of things from them, Malad. But what is the real case, Malad? On the face of it, your Lordship, if your Lordship just sees, it will turn around. Just make 2 sentences for that, but that's later. Now, Malad kindly appreciates the judge proceeds on the basis of obviously knowing that at that ad interim stage, the appeal is allowed. So he doesn't do that. What does he do? He said, file your objection. I'll hear it. Now, from this point of view, Malad, with humility, I say, Malad, if your Lordship looks at it as the impugned order, Malad, I first submit, Malad, there is nothing wrong with this order, which is a perversity, or where 227 jurisdiction is to be, Malad, invoked. It can be invoked, but order should not be passed. Because then in all matters of miscellaneous appeal, there is no stay, your Lordship will have to intervene. And say, yes, why not? So, Malad, today the entire matter on merits is pending there. The day is fixed on 12th. That's day after tomorrow, I believe, before the appellate court. In the trial court, they don't file a written objection. Malad, they are not worried about disposing of the main matter. So they have come before your Lordship asking for stay and if not, reversal of the injunction order on the ground of delay. Now, Malad, next thing Malad kindly appreciates. Let us understand what is the urgency, Malad. I'm only on the urgency, the factual part. Malad, first I have heard 44 years of delay. So that's what I'm being told, Malad. Malad, from
initially 60.
60, 55, 50, I think 48, then 40.
Yes.
If I go by that, Malad, there is no delay.
All before we were born.
It's all up new.
All before we were born.
No problem. No problem. Now, thank God I wasn't born then. Now, Malad, let us understand. What are these documents? Are these documents proving that there is a violation of the rights? No. These are all supplementary trust deeds. What is my learned friend saying? 44 years ago, that is what I'm asking for an performance. That trust deed is what I'm looking for. How can it be a delay? Now let us fast forward it to the delay part. They say in July 2025, I was away. I really don't know how I was away. I knew that there's some transaction going on. I write to them In December 2025, they write to KMC that they want to mutate. I again write to them in April, saying that you give us this disclose. What are the conventions? What are the modes you have undertaken? They don't. And then we come to court with the apprehension that look, this is happening and this will continue to happen. Well, continuing to happen is something which is urgency, which is continuing as a cause of action. Kindly appreciate, Malad. Today, Malad, there are two documents I have shown your Lordship the other day, Malad. What are these documents? Unregistered documents. They are trying to get it registered. So, Malad, the mischief which I am complaining about is not complete. So I can also say that this is not complete, it's still continuing. So therefore, stop it. Even other than that, my Lord will kindly consider that. I'm saying that this is before the trial appeal court. But again, I'm before your Lordship, as an appeal, I'm submitting, my Lord. This creates an apprehension in my mind that they are again going to do it. So can I not come to your Lordship? And that is what the trial court as well as the appellate court has held, that they might again transfer. But I really don't understand, my Lord. Is it such a case where, my Lord, a plausible, my Lord, reasoning has not been given? Does it not, my Lord, overcome the reasonable man's approach? My Lord, that is the test of perversity. Your Lordship knows better than me. A person who is a trustee, no dispute about that, my Lord. A trustee with whom these persons have had a supplemental agreement of trust, admitted position. What is the complaint of the trustee? That you are now transferring contrary to what was being done. And I say as the trustee that this is what the trustee required. And when I find it, and they're still continuing with a violation, well, that will not be an urgency. And that will be a delay. And I will wait and watch and they will go on transferring. Well, if that is, well, if that was the case, well, that's why I told, well, if your Lordship sends it back, let them not, at the moment, let them not do anything. Let me heard of. No, they are going to oppose that. Then your Lordship said lease pendants. Well, lease pendants again, my Lord, now, my Lord, Ambala Choksi is very clear on that. My Lord, it may not give me the full protection. So, is there the impugned order before your Lordship suffering from perversity? Your Lordship is being told that there is delay. A pure question of fact. Pure question of fact. Whether there is a pleading, I've shown there is a pleading. Malad, how good, how bad the pleading is, Malad, is something which, again, Malad, it fell before the two other courts, Malad, they found that it is enough. It might be that your Lordship might find that it is not enough. But Malad, there is a consideration. A 227 court, with humility, I say, Malad, will try and keep them all in order. But that does not mean, Malad, that their finding is always wrong. Then, Malad, there is no reason for an appeal. We can straight away come up before your Lordship. No requirement. Now, another thing may I just point out, Malad. Malad, I don't know whether your Lordship has gone through. Obviously, your Lordship can't. This is such a volume.
What?
Malad, in their pleading, Malad, before this court, Malad, they are now saying they have transferred most of the flats. Earlier done. There's a list given. There's a list given.
In the civil division application?
Am I in the appeal there?
In the appeal.
In the appeal. In the appeal. I will just show those. These are very important. And I will show 1 minute of a meeting of this syndicate who Mr. Mitro is representing, where they say.
Sir Rai, was it considered by the trial court?
How can you document? Their document. That's what I said. Now, when you want to oppose this prayer, you can rely on that document. And when I rely on it, no, that has not been considered. I'm not saying it's been considered. Sorry, it's been considered. My submission is otherwise.
No, was that document referred to by Mr. Banerjee or Mr. Mitro?
My lord, what I'm trying,
Mr. Rai, there might be
my
at
lord, if
times.
your lordship is today seeing that, if your lordship
No,
is
only
today-
one thing,
My lord,
because yes, there is a contra view also. One is if an appeal is from an ad interim order of injunction, we should restrict ourselves to the documents and the materials
I also-
which were before the trial court
absolutely.
only, no other
My
documents.
lord,
Contra view is there if there is gross suppression.
my lord,
By
that has been
that,
referred. That has been referred.
yes. So
That
is what
judgment has been referred now. Bengal Club has been referred.
but referred, but it has not been.
No, not yet decided.
So
So
there's
there are two views.
So there are
Now, my lord,
contra view.
my lord,
also.
I'm not on that. If they are allowed to rely on that,
So if there is suppression, by way of suppression, they have obtained something. So at appellate stage, there is a view which
lord,
you
that is
can
what I'm
rely
saying.
upon. But here, subject to correction,
it is there, it is not my document.
no, they have annexed. Maybe they have annexed some documents,
In the
but
appeal.
they in the
Appeal.
in the appeal.
Yes.
But was it considered by the appellate court? So if it had not been considered, don't rely on those, because let us not go
Your
into that.
lordship is today on a question of fact.
Yes.
Humility, I say, man. Your lordship is considering urgency. Delay.
So please restrict yourself.
Your lordship, well, kindly allows me 1 minute, man. Your lordship is looking into the factual aspect right at this moment. And if it's a factual aspect, my lord, and if it appears from your lordship's record, my lord cannot keep the eyes.
227.
My lord, again, that is why I say, my lord, 227, the fact shouldn't be.
So that is why, Mr. Rai, I have to consider the documents which were part of the records before the trial court. If you can show that no, the appellate court has considered something more than, so don't go into other documents.
On a different point altogether, my lord, kindly appreciate. Today, my learned friends are inviting your lordship to look into the factual aspect of whether delay, how it has been explained.
On the basis of your own averment, on the basis of the documents which you have relied upon. I will not look into any more documents which they may have relied upon to destroy your case of urgency and other things.
No, that is, my lord, I'm not on that. It's not destroying my urgency.
Yes.
What I'm saying, my lord, today, my lord, what has the trial court said? What is the urgency for? So that there cannot be further such transactions. My lord, they have shown documents, minutes, where they are saying that
It
they
has
should
been transferred.
No. That, my lord, they should adhere to the supplementary deed of trust. And I have agreed to that as a trustee. This is in the records of this court. It is their document. My lord, that is why I'm saying, my lord, if it appears to your lordship that yes, this is the case, my lord, we cannot, my lord, I do appreciate, my lord. My lord, we are first turning away from this Gautam Hara, my lord, lines of judgment. We are trying to go into it that yes, delay has not been shown, therefore there can be a stay. We are looking into that. My lord, then, my lord, the entire thing must be before your lordship. Your lordship is deciding on that. That is what I am on, my lord. Because, my lord, I could have just said that my lord will kindly follow Gautam Hara and my lord kindly refer it, it's pending, let it be done. And also the balance, my lord,
is pending.
The appeal is pending.
Oh, appeal is pending. No,
That's right, my lord.
I thought Gautam Hara is.
No, of course, my lord, is not. My lord, that is only if your lordship refers. My lord, I'm not on that. What I'm submitting, my lord. Today, my lord, the judge is proceeding on the basis of whatever your lordships regularly send back to them, my lord. They are quite well aware, and that is what they have done. I could have just stopped saying that this is the law. There is nothing wrong with it. But your lordship, with humility, I say, your lord, my lord, I'm not trying to restrict your lordship. My lord, your lordship has open powers under 227. But if your lordship is going to look into that, the question of delay, then, my lord, I must also be given a chance to explain that to your lordship. And in that event, my lord, if there are documents which has been brought on record, not by me, by the person who's proposing, then, my lord, will kindly have a look. I'm only on that. Your lordship, I do understand. That's the principle we follow. That no, Jitesh Pandey, my lord, we follow that. We don't look into it. I accept it. But my lord, we are again going into the merits of the case, my lord, on the point of deal. It's not that with humility, again I say, my lord, both the orders talk about the urgency part. There's no dispute about that. Now the question which is being asked for your lordship to decide is whether that is enough vis-a-vis my pleading. That's a question of fact. Your lordship is being now told, look, this is what has happened. Your lordship has first been told 44 years, then told that July 2025.
That you have explained. That
now I am saying there are further documents of 2026. Now from those documents, well, let us understand. If he goes there, Malad, and he again, Malad, if the other side goes to the appeal court.
So you are coming here.
No, I'm not on that. If he goes there, Malad, I can rely on these documents. I will rely on these documents. They're going to rely on their appeal. Then that court will also have the liberty of looking into these documents, which your lordship is not minded. And
after affidavits, Mr. Rai,
that is what I'm on.
Because that can be
that
decided.
is what I'm on today. Today the point is if I can show that there are other things which are there on record. One of the last letter which I've written to them is April 2026. Your lordship has not been shown that. There's an answer from them. In July 2020.
Was it part of the pleadings before
Yes,
the trial court? You show me that.
Show me that. I'm sorry, man. I've shown it on the last occasion. I'll again show.
Yes.
Just gives you. That day we were trying to concise the matter, Malad. I was also playing along, Malad, whatever your lordship. So I took your lordship to only paragraph 61. There are other paragraphs, Malad. Kindly allow me.
You show me that, yes, from the pleadings, other paragraphs with regard to the
sorry. Malad, I shouldn't have used that term. I think that was a wrong term.
What?
I was playing along with the code. I think that was a wrong term, Malad. I accept.
Yes. Yes. Page.
This is volume. Page 425, Malad.
No, your plaint is, I think, page 152. 152 is the plaint. 152 is the continuation of the plaint.
386, Malad, I'll take your lordship. 156. What was the petition?
152 is what?
That is the petition. Just give me a moment.
The injunction application.
And I just give you a moment. No, Malad, that's also a part of the
plaint. Yes.
Malad will kindly take.
So averments will be the same, I think.
Yes,
Averments. Only paragraphs may.
Only those urgency paragraphs are there. That one was.
Urgency paragraphs in the injunction. Yes,
injunction, that is para 61 I have shown. Now
yes. Yes. No, you wanted to show that pleadings with regard to April. Yes. Which paragraph?
We got a separate paragraph and a separate page number. I'm trying to get your lordship's page number.
All right, tell me that which page? Which page? The only difficulty is same document is being annexed 2-3 times.
Yes.
Why are you doing this?
Kindly see page para 43 of the plain. Whichever your lordship wants.
Paragraph 43. Because this
makes is the injunction application, I think.
Yes, so that will be the
just gives you a moment.
Paragraph 43, yes.
Just gives you a moment. Just gives you a moment. Yes, para 38.
38.
Yes. Page 137 on. One of the principles of section 17 of the Limitation Act may also be drawn in here. They were concealing the documents from their letter of 10th July 2025. Your lordship will find that they did not produce the documents also. On 37, they do not make the disclosure. I write to them again in April 2026 to furnish the copies of all instruments. They don't do that. And in May, I file this suit. In April, I file the suit. And what am I trying to prevent? A mischief by my learned friend's client. And my lord, in the document has been considered in the impugned order also by referring to the annexure as well as the paragraph.
Yes.
It is there, my lord. In the impugned order, my lord, also your lordship will find this letter has been considered. Now, my lord, I am
April letter, April 2026.
Yes. My lord, today, my lord, kindly appreciates. My lord, no dispute about the factum that these documents, even except the two which I have been able to find, my lord, from the register of companies while they're trying to get that done in the corporation, there are other documents. They themselves have said before your lordship that sold off. I do not get these documents instead of writing to them. My lord, then I won't have an urgency. And now, my lord, kindly notes what is the scope of those two agreements which I have got. And I've shown your lordship that each of those talks about car parking, which is admittedly not a beneficial property being dealt with. Even that talks about the supplemental deed of trust. Where am I in that conveyance, Manu? Manu, do these things not create that urgency which the learned trial court has, the appellate court has come to? Is it such a perversity? It is not that these documents were available with me. Manu, they suddenly come up. But the first day submission was, what kind of a trustee is this? That is what I heard. But if I've been a bad trustee, you have not taken any steps against me. The Trust Act provides for it. Now, when I take the proper step, then you say, what kind of a bad trustee is he? Because, my lord, on the face of these two documents, they are dealing with a property which is not the beneficial ownership. What else do I need to show the urgency, my lord? Therefore, my lord, I was referring to these documents, my lord, because of this purpose. And again, it is being perpetuated. They have given a list. Other flats are also being transferred. So, my lord, kindly appreciate this part. On this urgency part, my lord, what does the balance require? My lord, they are very well aware. If they can show that what they have done is proper at the final hearing, this will go. The order will go. But, my lord, today, if your lordship stays that order, they appeal, whatever it goes, goes. Well, they will be in a position. So the question of prima facie case now comes up. Now, when I'm in a prima facie case, Malad, kindly consider the documents.
So, Mahato, you are waiting for.
দাদা 5টা নাগাদ ইয়ে আছে তো
Yes.
Urgency দেখাচ্ছে Malad kindly takes up the judgments now, Malad. If that is, Malad, they have objection for everything. They have taken more than 20 minutes, they say, Malad. And what can I do, Malad, if the facts were so concise for them, but it was not for my client, Malad.
No,
It took 44 years of Malad. The thing.
So Mitra does not want
No,
to go
Mr.
into.
Mitra is not the petitioner here.
I am not here.
Does not.
He is not the petitioner here.
Yes.
No, no, it's always a pleasure to hear my learn.
Yes.
And that is his blessings, Malad.
Yes.
So, Malad, first, Malad, the judgment. Malad, Malad, on the proposition, Malad, just to make it complete, Malad, if your lordship 227, as your lordship are well aware, it's not a court of appeal. So, Malad, the fact.
Powers under Article 227.
Yes. Malad, this is Sadhana Lodh, Malad, your lordship is well aware. 2003, 3 Supreme Court cases. এগুলো কেন লাগিয়ে দিয়েছো? কি হচ্ছে? Supreme Court cases 524 দিচ্ছে। আপনাকে তো দেবো না পিটিশন So, Malad, this is Malad paragraph 7, your lordship can see. The supervisory jurisdiction confined on the High Courts under Article 227 is confined only to whether an inferior court tribunal has proceeded within its parameter and not to correct an error apparent on the face of the record, much less of an error of law. And it does not act as an appellate court. Malad, here again, Malad, that is what my learned friends are trying to ask your lordship to do. Reassess the question of urgency and dealing. That is what is being attempted. Malad, on a similar line, Malad.
Need not multiply on this.
I don't need it, yes, Malad. Malad kindly then takes Malad. Malad, this I'll have to refer, Malad. This is the Choksi judgment, Malad, 2024, 11 Supreme Court cases, 351. Though, Malad,
yes.
Malad will kindly see, Malad. Here I'll have two propositions to show here, Malad. One, Malad, kindly comes to paragraph 36, Malad.
Yes.
37. 36 is perversity, Malad.
Yes.
Meanings of perversity, Malad. 37. The wrong finding, Malad, it's at page 20 of
yes,
this.
I've got it.
The wrong finding, Malad, I know this is from an appeal, Malad. Appeal, the scope is wider than 227. I may humbly submit this, Malad. The wrong finding should stem out on a complete misreading of evidence, or it should be based only on conjectures and surmises. Safest approach and perversity is a classic approach on the reasonable man's inference on the facts. To him, if the conclusion of facts in evidence by the court below is possible, there is no perversity. If not, the finding is perverse. Inadequacy of evidence or different reading of evidence is not perverse. I am humbly submitting, Malad. There has been a finding by two courts. And Malad, this judgment, as a matter of fact, was also considered in the impugned judgment, Malad. Malad, since I'm on this judgment, may I show also a few more paragraphs? Kindly takes Malad para 45. Choksi, sir. Choksi.
Yes.
Malad, this is on the point of Malad, for the completeness, Malad. Yes. Pendants, Malad. Malad, don't take me as whatever
yes, yes.
Malad, I need to, Malad. Malad, yes. Quite often, in these types of litigation, sought to be argued that an injunction restricting the defendant from transferring the suit property is absolutely unnecessary, as no post-suit transfer of the defendant can adversely affect the result of the suit because of the provisions of section 52 of the TPA. Malad, may I just pause here for a moment? Malad, this list is a specific performance. There's a specific performance suit. And I say this at a higher level, this one, because Malad, this is a trustee suing to protect the trust property. So the question of list pendants, and it's a multiplicity of proceedings. Now kindly see, where under all such transfers cannot but abide by the result of the suit. It is true that the doctrine of list pendants as enunciated in section 52 of the TPA Act takes care of all pending transfers, but it may not always be good enough to take fullest care of the plaintiff's interest vis-a-vis such a transfer. And in illustration was given of the specific performance. But what I'm...
Because the defense of bona fide purchaser for value without notice.
Yes.
That's the ground on which section 52, because the third party purchaser can come and take the plea of bona fide purchaser for transfer.
Absolutely, Malad. Here what can happen, let us understand that, Malad. Here there are people who are not beneficiaries, admittedly under any of the trustees. Admittedly. So it is going to change hands. I don't know to what extent. They are trying to change it. Third party, Malad, there is one.
He may come up and say, I'm a bona fide purchaser. I did not knew about this. It's your internal disputes and
Yes,
problems.
Yes. So the test will remain the same. So, my lord, this was on the question of, my lord, what is perversity? Your lordships also regularly has held 227 perversity. Wrong appreciation may not be at least not at the ad interim stage, my lord. That is what I'm on. Then, my lord, kindly. My lord, this is a judgment, and I know it, I might be frowned upon, but this is on the principle of, my lord, as I was saying, my lord will kindly appreciate the principles of section 17 of the Limitation Act, which, my lord, extends the period for a suit or a plaint, my lord.
Discovery of fraud.
Yes. My lord, there it is very clear, and that is what I'm trying to imbibe here, my lord. That's what I'm saying. Even on 9th April, and it's not that they have not transferred. They have not disclosed. My lord, I could have only got notice of this if another supplementary registered deed was made, which they have not made. Therefore, my lord, I say, my lord, this is a case where, my lord, they are actively participating in the delay, if any. Then they cannot come and say there is delay. I should have noticed. But if they have noticed, they immediately transfer. Every day they are trying to transfer. My lord, kindly one judgment on this, my lord. Yes. My lord, 2001 7 Supreme Court cases 549. Which is it? Anyway. My lord, the paragraph is para 18 and sorry, para 46 and 48. 46 to 48. My lord. Well, 47.
Yes.
My lord, sets out the principle of section 17. My lord, I say, my lord, kindly appreciates what they are trying to say is, my lord, it is one step lower than dismissal of the suit on the ground of limitation. Basically, that's what they're saying. That I've delayed, therefore no ex parte ad interim injunction. But the principles will remain the same. They had not disclosed. 10 July 2025, they only give some particulars. We say disclose. No disclosure. Well, then I'm being told you have delayed, you have not challenged. I could have challenged it. That's why prayer also. They show, give me other documents. Disclose them. So, my lord, it's a continuing wrong. It's a continuing cause of action. It's not that they would have stopped if I could have stopped. But I was not having the particulars. Then, my lord, kindly sees. My lord, there is a list. My lord, this your lordship will kindly consider. But this is in the appeal. They have given this.
Any other decision you want to cite?
Yes, my lord, I will. May I can complete the decision?
Yes.
My lord, now, my lord, those of just of Gautam Hada and a couple of them, my lord, may I just hand them over? Hada, no, Hada. My lord, I think I'm right.
In re Gautam Kumar. In re
Hada.
Gautam Kumar Hada.
Hada na Hada.
HADA.
But that's English. I don't know what is it. It is in Bengali. I knew it's a surname, my lord.
ILR. 1972
And I've got the
Calcutta.
Monupatsu, but I'm sorry, my lord, I did not have
Monupatsu.
Yes, my lord.
But Monupatsu, have you checked up? Because at times there are.
My lord, may I hand over by the end of this, my lord, from the ILR, my lord?
Yes. Because at times there are certain misprints, some sentences, words. Because there are vital words used in that judgment. One or two expressions. You can place, if it comes to my mind, some of the expressions which are there.
My lord. My lord, may I just rely upon paragraph
10.
8 to 10? Let's say, my lord, paragraph 9 onwards.
Yes.
Moreover-
10 is the ultimate.
Yes.
9 and 10 is
9 and 10. Moreover, even if ad interim injunction is granted ex parte after the other side shows cause pursuant to the notice served upon in the matter, the court may revise under reconsideration whether temporary injunction should be granted till the result of the suit has been held by the division bench of this honorable court in Mukta Keshido. Then, my lord, Mukta Keshi has been set out, my lord. My lord, there your lordship will find. My lord, just and when so taken, the second sentence, the allegation of, in our view, make out a case for ad interim injunction. As and when such show cause will be filed by the defendant and the plaintiff's application for injunction be taken up for final hearing, the learned trial judge would obviously consider such show cause and also it would then be available to him come to his own findings whether a case for temporary injunction till the disposal suit has not been made.
Paragraph 10 is what should be done in
Now,
a miscellaneous.
10. Further, the scope of granting temporary ad interim injunction or stay in a suit or in a regular appeal is quite wider than that in a miscellaneous appeal, arising out of an order granting or refusing any ad interim injunction in the suit. Scope of the miscellaneous appeal before the lower appellate in the present case is whether the order granting ad interim injunction passed by the trial court is legal or not. Such appeal should be heard expeditiously by the lower appellate court, but ordinarily, the lower appellate court should not pass any ad interim order, resulting practically allowing the appeal itself at the initial stage without hearing the other side. So, my lord, today, my lord, if that ad interim order was stayed, well, it would tantamount to disposal of the appeal. And I am also saying the appeal is ready for hearing. So that is what I am saying. Now, my lord, this has been followed. My lord, these decisions, my lord, I will be referring to, my lord. ঠিক আমি যতটুকু ইংরেজি বুঝি রে না না ঠিক ঠিক বলছিস বলছে পাশ থেকে মানে দিস ইজ নাও মানে দিস ইজ মুবাসসার হোসেন.
Justice Mukherjee relied upon this.
But I have a few others, but I'll just point that out. And then your lordship will consider.
Mubassar Hossain mainly follows that.
Follows.
Don't refer to that Hada, but the principle that
The
has
principle is followed, my lord.
Yes.
And therefore, my lord, there it was set aside and it was again, my lord, stay was granted. And my lord, thereafter, my lord, the appeal was ready to be heard out expeditiously. My lord, para 2.
Yes.
I therefore said, para 3, I therefore said as the order.
That's the ultimate. So paragraph 2 is that observation that normally stay should not be granted.
Appeal court had stayed, which has was
that was set aside by.
Yes. Then, my lord, এইটাতে একটু আছে কয়েকখানে এটা আমার কয়েক দেখা না আর কয়েক না না এটা লস্ট আচ্ছা একটু পড়ি my lord, this is the same principle followed by Justice Tandon, my lord.
All following that.
Yes, my lord, because I need to make this, my lord, this is my argument, one of my main arguments before your lordship, my lord.
If a process is being followed consistently, whether should be deviated.
That is what my submission would have been after showing all the judgments, my lord. But I'm not reading them all, my lord, they all rely. My lord, this is ওটা কোনটা গেল
সুমন বিশ্বাস সরোজ বিশ্বাস
স্যার একটু নেবেন প্লিজ
আমি চাইনি চাইছি
নেই রে বাবা না এটা সুমন বিশ্বাস নয় মানে নেক্সট ইজ মানে রেখা বিত্তর হাজরা. This is by Justice Shampadatta Pal, my lord, where, my lord, the impugned order was passed by the appellate court's team, which was reversed and sent back, relying on this judgment, my lord. এটাই তো এই নিন স্যার. And last, my lord, আর দরকার নেই. This is Anindo Lahiri, my lord. Aniruddha Lahiri, my lord. Sorry, sorry. ওর নামটাই হট করে চলে আসলো, very sorry. This is Aniruddha Lahiri, my lord.
Yes.
My lord, your lordship will find Mubassar Hossain was relied on this, and your lordship has followed that. My lord, second paragraph, your lordship kindly sees.
Yes.
Normally, stay of operation of the order granting should not be passed adequate amount to allowing the appeal at the initial stage and reject the prayer for stay of operation of the order of injunction. The court does not find any infirmity in the impugned order. This court finds that hearing of the appeal was fixed on 7th August. Then the submits on the date took an adjournment. And then, my lord, your lordship finds, just in the bottom, in view thereof, this court is considered that the ends of justice would be made if a direction for expeditious hearing of the appeal is passed. But I have also said that I am ready for the appeal, my lord.
Yes.
So, my lord, this is on the point of, my lord, whether your lordship will exercise jurisdiction in the misappeal
Against an order of stay.
Against an order of stay. Not granting stay.
Yes. Refusal to pass an order.
One step further, my lord. So, therefore, my lord, this is what I was referring to. Then, my lord.
So, in a way, according to you, if stay would have been passed, this would be in violation of the settled proposition or the...
Now, my lord, kindly, and I shouldn't be saying this, but if we place ourselves in the position of the learned district judge, who is the appellate court, and who may be aware of this law, my lord, then can we hold that this is a perversity? Can we hold that? I'm only on that point, my lord.
So, according to you, there were two options. One is to stay, the other is not to stay. So, according to you, the appellate court has refused to pass an order of stay, keeping in mind this long line of decisions.
This is the law.
So, he has taken a view.
Yes.
So, it was possible.
Yes.
So, according...
And, sorry, my lord. And in the impugned order, he has also assessed whether there is any perversity in the order.
Yes.
That has been assessed.
So, that is going a step further.
Step further. And what has he done? He said, file your objections. I'm ready to hear them. And I'm saying it's fixed on the 12th. So that is what I'm on. On a pure question that this is the law which has been set forth. And again, I say, my lord, if your lordship is going to decide on the point of delay, my lord, and hold, let's say, contrary to what the two other courts have held, my lord, then, my lord, it becomes a question of fact before the lordship. It's a pure question of fact. Then, my lord, all the documents have to be shown because your lordship, this cannot be done in such a manner because that will be on a question of evidence. So we'll have to see that. Only thing which your lordship, my lord, I humbly beseech, my lord, whether there is a reasoning, whether there is a finding of urgency. I say, my lord, it is there. And the reason is also given, which I was trying to take your lordship there. Your lordship is not minded to. But in the appeal, it is evident now that they are trying to dispose them of. What else remains, my lord, if there is something which is being done contrary to some contract? Delay will defeat it, my lord. This is what I'm on. That is what I'm on. I could have understood it's a case where nothing is there on record. I am showing two documents where they are trying to deal with.
Only you are right, Mr. Rai, that if something is done, delay cannot cure that. But the question is, there are some decisions of the Honorable Supreme Court which says ad interim on this ad interim order of injunction.
That is why.
So unless urgency is satisfied, so
that is what I'm on again, Madam.
So
urgency has been satisfied by the two courts.
So only because of
so
that,
your lordship only has to see the perversity part.
Because you know what prompted in 1993 and 1994 these two decisions to take that view was that merely at the mere asking ad interim orders were passed without. So that is why reasons are to be.
I only say this. What has been submitted by Mr. Banerjee, I join issue with him on that part. That there is no reasoning or there is no finding on urgency, my lord. I join issue, my lord. I have shown both the orders. And, my lord, again I say, my lord, if it's only the impugned order, that will tantamount to, my lord, reversal and allowance of the appeal means setting aside of the interim order
হয়ে গেছে তো?
without appeal being heard.
Anything more, Mr. Rai?
Malad, only one thing, Malad, which I was coming to an end, Malad. Malad, kindly keeps note. Malad 2, para Malad paragraph
Plaint.
appeal.
Appeal, page.
And just listen. But also in your lordship CO, Malad, in the civil division also your lordship, para
Yes.
3.
Oh, in the civil division application.
Yes, yes.
So please take me to the appeal. I think that's better because
No, no, it's appeal.
in the appeal they have stated anything.
Yes, yes. It's true. As per list of current documents produced in appeal. It's true. In the misappeal. Where in the misappeal? Just to point it out. And I'll just give the page number, Malad, where they have said now the number of flats which were there in the supplementary deed, that has changed.
So they have stated here also. Where is
And in para 3, they have stated in the civil division, and I'm just giving your lordship the appeal state petition.
This is better because this is not an original
No, no,
pleading
I understand.
civil division application.
State petition is a way to go. No. Page 644. Yes, it's the same paragraph. That's what I said. In the state
644.
petition.
644.
Para 3. And same as paragraph 3 of the civil divisional application.
Oh. Cut, copy, paste.
Yes. Well,
Copy
that,
paste.
that we cannot hold ourselves liable for that. That everyone is doing, Malad.
Yes.
Malad, I know it's pretty late, but I can only remember one thing, Malad. There was a cut, copy, paste before Justice Shonji Banerjee, Malad. I drafted the plaint at 2 o'clock in the afternoon to be moved at 4 o'clock. So when the petition was moved, the order was just being passed. Malad, the prayer contained, please cut and copy the prayers from the plaint in the petition without perpetual. And my lord could believe Justice Banerjee, my lord, but it was a surprise. He said, please amend it. I'm passing the order. I thought I would be finished that day, but that was there, my lord. So cut, copy, paste plays a very...
Must have been satisfied with the merits of your case.
Very bad case, my lord. It was so urgent, my lord. I started drafting in the afternoon and moved it. It was a very bad case. Yes, my lord. So, my lord, on the judgments, I have shown your lordship the judgments. And, my lord, these are more or less my submissions. When if they show any judgments, then I must have the.
I'm not going to show any.
Well, I'm grateful. I'm very grateful.
I'm just going to point out some of the perversity. On the issue of perversity, I'm just going to make my submission, nothing more. Lordship will please to come to
facts.
Come to the plain.
It
Plain
facts.
petition, the same thing. This is, my lord, your lordship will please to get
grants me 1 minute of
page, one second volume. Kindly come to page 155. Let us see their case.
155.
155. Paragraph 61. This is the foundation of their case.
Yes.
The plaintiff submits that it will suffer irreparable injury if an ad interim and temporary injunction is not granted. Why? The reason is the suit property comprises of 34 flats of substantial commercial value in a prime location. Each addition, dealing, subletting, encumbering, or creating a third-party right in respect of any flat will give rise to further complications, including further unregistered agreements, further sub-transfer, further use, etc. Now, on the basis of this, the trial court passed the order. Kindly, my lord, take the The trial court order will, your lordship will please to find at volume 5, page 683. Kindly, my lord, take volume 5.
Yes.
Volume 5, page 683 is the order.
Yes.
Well, I take your lordship straight to the end of the order, the ordering portion. And this has been confirmed by the appeal court. Sorry, na appeal court. আমি appeal court order চাইছি। Trial court impugned order হচ্ছে volume order of the district judge Alipur. Now this is the trial court order, isn't it? Trial court. Your lordship is page 459.
Yes.
Volume 4. My lord, kindly come to the end of it.
Yes.
Order the defendant number 1 to 8 and their men and agents and their respective servants, agents, assigns, etc., under hereby restrained from in any manner transferring, encumbering, alienating, subletting. Exactly, paragraph 61 has been quoted. This time in so and so schedule B. So, my lord, the entire question which had been agitated by the plaintiff and accepted by the both the, my lord, the trial court as also the appeal court is with regard to the transfer of the flats. What they are saying is this, that since 1962, the flats are being transferred without a registered deed and without consulting us. So please stop this, because otherwise it will lead to multiplicity of proceedings. Therefore, my lord, one has to establish that they have got the right in the flats. They've got the right to stop the flats. That is the, I am showing your lordship the perversity. The basic fact which, my lord, both the trial court as also the first appellate court had mistakenly proceeded on the basis that so far as the trustees are concerned, the flats belong to them. Or, my lord, the trustees had a right in respect of the flat. My lord, I answered this issue on the basis of, my lord, the evidence which was before the court. My lord, kindly take page 467. 467, it is volume 4.
467.
467.
Yes.
Document was not before the trial court. Document.
So, Mitra, was this document before the trial court?
This particular document, to which, my lord, the Dalhousie Properties Holding Limited is a party, they suppress this particular document. Why they? I shall tell you, lordship. I'm telling you, lordship, why. My lord, kindly come to page 468.
Indulgence, my lord. I have an
So, if
application that
this
should
was
be heard
not
of first.
ad interim, this was not before the trial court.
Very well, my lord. Your lordship did not look into it. Very well. Your lordship kindly keep it for the timing away. Your lordship kindly
Then
comes to page
affidavits
51.
have to be called for before the trial court or the appellate court. It has to be decided.
That this cannot
Please
be brought on
concentrate on the documents which were before the trial court.
Very well, but I shall go. But I am going to show to you, I am going to make this submission to your lordship after I have shown your lordship that so far the flats are concerned, they don't have any right. This is the first document to which they were party. The trustees were
only one thing, Mr. Mitra, if you can, by taking the aid of Bengal Club, if according to you they have, by way of suppression of certain documents, they have obtained an order of injunction, you can take. Then they have to be given an opportunity to deal with that.
But
So,
let them produce the original.
Very well,
This is
but I am
something
not-
which is showing HD, and I've made an application. I should be expunging this.
Very well. চাচাস না বাবা, তুই যদি বারণ করছিস না দেখাতে, আমি দেখাবো না। Kindly come to page 516.
516.
This was before the court.
Yes.
Your Lordship kindly comes to page 518. 518. The trustee, paragraph 1.
Yes.
In the middle.
Yes, you have placed that. I have marked this. At the time,
Trustee, their beneficial owner, and
each syndicate member shall have exclusive possession of the flat.
And my lord, kindly come to page 519.
519.
41. The syndicate,
41.
yes. 41. Each syndicate member and all person authorized by such member shall have full and free right and liberty at all times and for all purposes of domestic use and convenience incident to the occupation of the said flat or flats, etc., allocated to them. My lord, what happened was this. The flats were, my lord, in so far the flats, this particular building was constructed with the money of the members of the syndicate. And my lord, the trustee agreed that since you have constructed this building, you will have the full rights in respect of the, and we won't have any right in respect of the flats. We will have right only in respect of the common areas, garage, lawn, etc. But so far the flats are concerned, you will have no right. Now, my lord, keeping that in mind, when your lordship looks into paragraph 61, what are they saying? They are saying that, look, in so far as the flats are concerned, they are being transferred by. Why is it, my lord? I asked this question to myself, and this is a question, my lord, I am sure your lordship will be pleased to put to my learned
But
friend.
I'll answer.
Oh, why is it? Why is it that, my lord, for the last 40, 50, 60 years, they never bothered about as to whom these flats were transferred? Why is it in 2025 for the first time they came up and my lord wrote letter to us saying that why are you transferring this? The my lord, you answer when your turn comes. Now you please sit down. No, I had been. At your to answer this question. My question is this: why is it for 40 years, 50 years, 60 years you did not raise any objection? When this, you are a trustee, you say that I am the owner of the property. You say I am the owner of the entire property, including the flats. These flats are being transferred for 60 years and you won't bother about it. Why? Reason is this. You knew fully well that so far the flats are concerned, it is the flat owner, it is the syndicate members who are entitled to deal with them. Now, my learned friend says, what happens if it is transferred without the registered document? That's between the purchaser and the buyer and the seller. Plus, if I sell a property to a buyer without a registered deed, it is
He
the
will not
buyer
get anything.
Yes.
He will not get any title.
Yeah, that's right. He will not get any title. Nothing turns on that insofar as my learned friend is concerned. He has got nothing to say with regard to that. And that is the reason why they did. But this is the perversity. The perversity is this, clear perversity is this, that a particular fact which is writ large, my lord, had been totally ignored both by the trial court as also by the appeal court. And ultimately, my lord, when the order was passed, they completely overlooked that insofar as these flats are concerned, the trustee had no right to say anything at all. Because the trustee did not have any right, that is why the trustee did not say. This is a very simple thing. On the basis of this, I am submitting to your lordship. On the basis of this, my lord, this particular the interim order is liable to be vacated. My lord, these are my submissions. And I did not show to your lordship. Well, your lordship did not want to see this. Of course, I shall bring it before the court, trial court. This particular document,
Mr. Mitra,
to which 1961 document. 1961.
Either before the trial court or before the appellate court, because the documents which you want to bring, they have to be given a chance to controvert.
No, very well. Very well. That's why I did not any further. I did not any further insist on that.
What more, Mr. Banerjee?
Well, I just want to answer Mullah, on the main Mullah, with regard to Mullah, the legal issues. Mullah.
Legal issues.
Legal issues which were
How much time you will take?
5 minutes, 10 minutes. Not
My lord, I will also give a small answer to Mr. Mitsu. My lord, I was answering on urgency only.
No, you answered a
No,
fact,
no, no,
sir.
sorry.
You tried
Sorry.
to prejudice
Malad,
the
I have
court
not.
with a lot of things, other things as well. No. So they don't.
Malad, he's not here to dictate, Malad. I'm
I'm not
requesting a
dictating,
lordship.
that's
Yes,
submission.
yes, Mr. Banerjee
That's
just
my
said no,
submission.
Mr. Ray.
No,
Malad, kindly
you
appreciate.
want to give reply to Mr. Mitros that,
Yes, that's
all right, all right.
yes. I was
Yes.
allowed for the urgency part.
Petition. Well, his cases, he has come with his knowledge.
Mr. Banerjee, can you come this side
Yes,
so that not to disturb Mr. Mitro, because
sorry.
otherwise
But,
displacing.
with your lordship's leave, my lord,
Oh.
may I leave? I am supposed to be an arbitrator in a matter, and 5 o'clock the arbitration has started. I don't know who is doing what.
Yes.
With your lordship's leave. my lord.
Yes.
Lord, we were really on the question of urgency. Lord, we also did not address on merits. We have a lot to say on merits. Whether a trustee can file or not file, that's a different issue. On the question of limited on the question of urgency, will find in his petition, his case is that his cause of action arose on 10th July when he had knowledge. There is no question of now referring to other letters. It depends on when you have knowledge according to your averment which you have made. If kindly comes to that paragraph.
According to you, July 2025 was the knowledge and they approached in April 2026.
Yes, that's his case. Because we are only going on his case now. So, Order 39, Rule 3 requires. Otherwise, why have Order 39 Rule 3 at all, in the books? It requires that normally, all injunctions are granted, with
Exceptional circumstances.
Exceptional circumstances. So, you have to make out the exceptional circumstances. Nothing, in law says that after you give me notice and after we are heard, you will not get the injunction again. Quite possible. But the question is whether, on the face of it, the court had jurisdiction on that day, to pass an ex parte order on the basis of the pleadings which were made. That is what the question one has to look at. And with great respect, the appellate court did not address itself on that issue at all. Then today we have to also say that ex parte ad interim orders can never be stayed. With great respect, that can't be the law. What my learned friend says, that when you go up in appeal, it's really a mere formality. You go up in appeal, you ask for an ex parte, you ask for an ad interim stay, not ex parte, and that's what the judgment says. You ask for an ad interim stay of the impugned order, the court will say, oh, sorry, I'm powerless. That's his submission. Why is it with great respect, that he will enjoy the illegal order? And then he will tell me that if there is a ad interim stay in the appeal will really tantamount to appeal being allowed. No. No.
But that is the consistent view, Mr.
Malad, with great respect, Malad, kindly look at the judgments. Otherwise, Malad, there was no question of asking for any ad interim stay. Malad, it is down now. Even Malad, we have that Supreme Court judgment, times. Where Malad in a 227, the High Court set aside the ex parte order of injunction. Malad, if an ex parte order of injunction, ex parte ad interim order of injunction is wrong, on the face of it wrong, Malad, with great respect, Malad, why should the court Malad at all accept it?
Please show me the judgment.
Malad, in 227, Malad, this was the time to other side. আছে তো হ্যাঁ তো আছে সবই তো জানো তুমি
Which paragraph?
Paragraph 1 will see petition arises from the order passed by the High Court of Judicature Allahabad. Writ petition filed by someone herein came to be allowed, thereby setting aside the order passed by civil judge granting ex parte injunction. So this specially was from the order of the High Court, and this was under 227. Then page 2 the order is recorded. Then paragraph 2. The respondents herein, original defendants being dissatisfied with the order passed by the trial court referred to above, invoke the supervisory jurisdiction of the High Court under Article 227 of the Constitution and challenge the same. High Court, in exercise of its supervisory jurisdiction under Article 227 of the Constitution, thought fit to interfere with the order passed by the trial court and set aside the same. Findings recorded by the High Court in its impugned order read thus. Then, that is it is recorded. this was all of the question, my lord, whether, my lord, the compliance, my lord, was done, my lord, about, with regard to, my lord, Order 39, Rule 3 or not. And then, my lord, kindly look at paragraph 6. Chadda is referred to. We also have Chadda, my lord. Or paragraph 5 also, my lord, can have a look, my lord.
Yes. It's Chadda, those
Chadda and Morgan Stanley,
yes,
my lord,
because it has to be, reasons are to be recorded. Non-recording of reasons is itself a ground.
Correct.
So, to
Correct.
vacate that.
So here, my lord, has to see, my lord, whether, my lord, the first court has, my lord, recorded, my lord, the reasons as to why, my lord, where is the urgency? Why should notice not be given? And that's the first thing, my lord, which, my lord, looked at, my lord, page 633, when, my lord, looked at, my lord, the impugned judgment.
Yes.
In, my lord, the petition, my lord, page 633, my lord, was the order.
Trial court's order.
Yes.
Yes. According to you, there's no finding on the urgency.
No finding on the urgency, and, my lord, admitted cases, my lord, that they were, my lord, they were aware of it. My lord, that is, my lord, page 156. I thought, my lord, with great respect, my lord, that was.
Yes, in July 2025.
Yes, my lord, kindly look at, my lord, that averment, very important. Page 1. Kindly look at, my lord, page 152, paragraph 53.
Yes, you can take from the trial courts that's recording.
Yes, it is
First
recorded.
became aware, page 636.
Yes, ma'am.
First became aware of the full extent of the
Absolutely, yes.
receipt of the letter
Correct.
dated.
637, my lord, has seen, my lord. No,
636.
636, yes. Plaintiff has become aware, correct.
Yes.
Aware of
trial
the
courts recording that they became aware
full
of.
extent of the authorized, unauthorized transfers according to them. Full extent of the unauthorized transfer upon receipt of the reply dated 10 July 25, refer number 1, which for the first being entered into 7 unregistered agreements.
Yes.
Now, my lord, with great respect, my lord, we did not address on merits, my lord, because we were at that stage not called on. My lord, section 14 and section 58 of the Trust Act clearly stays in the face. Trustee, my lord, cannot have an independent right.
At the administrative stage, let us not go into that
Lord,
part.
that's why, my lord, we wanted to show, my lord, the perversity, my lord, of the impugned order in, my lord, restricting, my lord, all the beneficiaries. And not only that, my lord, the transferees have not been made parties. My lord, we showed, my lord, the deed which they challenge of 2008 and, my lord, 2015. Prayer F, my lord, the deed which they challenge is of 2008 and 2015. And last, my lord, according to them, supplementary deed was 1982. They have also not been made parties. So, my lord, these facts, my lord, would have to be. It's not a question of, my lord, obtaining an ex parte ad interim order and then coming to court and saying you don't have the power. Court had power to pass an ex parte ad interim order, but court does not have power then to stay the ex parte ad interim order if it was wrongly obtained. So this is the argument. My lord, with great respect, my lord, there are cases and cases. My lord, even the appellate court should have looked at the order and, my lord, looking at, my lord, what the facts are, should have stated. We have come up in, my lord, Article 227 challenging, my lord, that order, that the appellate court has failed to exercise its jurisdiction in, my lord, staying, my lord, the impugned order.
Yes.
And my lord, sorry, my lord, yes, my lord, Choksi, my lord, is, my lord, on a different, my lord, issue with regard to, my lord, the transfer. Just short put judgment. My lord, just 1 more minute, my lord.
Yes.
My lord, the first, my lord, that set of judgments, my lord, from Justice Mitra's time, my lord, Hada.
It says that the best thing is that you have to decide the appeal. If you stay, it would amount to allowing the appeal at the time of admission. That's the logic of.
My lord, this is the language, my lord, this is, my lord, the ratio which, my lord, it appears to be. Further, paragraph 10, scope of granting temporary ad interim injunction or stay in a suit or in regular appeal is quite wider than miscellaneous appeal arising out of the order granting or refusing an ad interim in a suit. Scope of the miscellaneous appeal before the lower appellate court in the present case is whether the order granting ad interim injunction passed by the trial court is legal or not.
Yes.
So that's one of the question. Such appeal should be heard expeditiously by the lower appellate, but ordinarily, lower appellate court should not pass any ad interim order, resulting practically allowing the appeal itself at the initial stage without hearing the other side. Without hearing the other side. We are both there.
No, in the appellate court.
Yes. Appellate court, whatever is before the first court is what is to be considered in the appellate court.
Both parties were heard before the appellate court.
Yes. And ad interim order was refused to me. That is what I'm aggrieved by. In the appellate court, from the ad interim stage, again, you cannot improve your case. What is, as they say, sauce for me is also sauce for you. So if you cannot improve your case, the appellate court heard both of us. Question is whether that ad interim order should have been passed or not. That was the issue before the appellate court as well. And it only says without hearing the other side. And we both heard before the appellate. I prayed for ad interim order. Otherwise, what my learned friend submission, I find this with great respect. The submission is made when we are on the other side, saying that the appeal will be allowed. When is the question of appeal being allowed? If it stayed, it stayed. You come back and argue and get your order. The issue is whether ex parte ad interim order should have been passed. All these judgments, I find, are on the same, it uses the same
parent judgment is Gautam Kumar Hada. So
that's right. Justice Mukherjee also uses that. Justice Tandon also uses the same thing without hearing the other side. And I'm not saying in every case, we do not ask for saying in 227 should interfere. Many cases, doesn't interfere. Many cases. And it is nothing new. It only says, but ordinarily the lower appellate court should not. Correct.
So according to you, if both the parties are heard at the appellate stage, it can be stayed.
Yes. There's no, it can't be a legal bar. It's a question of the court.
The expression is ordinarily in Justice Mitro's judgment and in Justice Mukherjee's judgment, it's normally.
With great respect, even the High Court, intra-court appeal, can we say that when an order is part ex parte, the appellate court never stays it? Can a submission be made like that? If the first original side passes an order, an ex parte ad interim order, is it a legal principle that when we go to the first appellate court, in that sense, that will be the first appellate court? It will never stay the order.
Yes.
That law, I don't see, that is one of the
one is,
law, which is there.
Mr. Mitro has been referring to that trustee ballot.
Yes.
The Lordship sees the trustee ballot, only keeps note of the fifth supplementary request. That provides for what the suit is asking. So to say that the trustee is not required, that is not correct. But because kindly in their in their petition, they have said this, that in the minutes of the meeting, they also said the trustee is required under the fifth supplementary. There is no explanation for that. Not a single explanation. Whatever they are now trying to say, delay and then again they are going back. But where from did they get the corporate case? I'm asking. Why have they not been able to register at this moment? Because they don't have the legal title. The legal title is with the trustee. Section 14, Section 58, these are subject to the contract.
That will be decided, Mr.
Now, only on this point, what Mr. Banerjee has sought to say, that only if it is both sides are not heard, it kindly takes your Lordship's order of Honorable Thola. Both sides were there on one date, kindly sees learned advocate, just
no, both sides were there before the appellate court. Yes, show me.
The
second paragraph, then third paragraph. Does not find any impunity. Now, learned advocate, as the petition submits. And then on the date, the petitioners took an adjournment on the ground that the petitioner is contemplating filing of the revisional application. The parties were there, here I was served at 2 p.m. the matter was moved.
Right.
That cannot be the today, what is the proposition which has come down from your Lordship's manner? Even Justice Pal, Justice Shampal of the Pal is also
again more judgments.
No, my lord, Mr. Banerjee was not here. I've given those judgments.
No,
Mr.
Justice
Banerjee.
Datpal's all following the same
See this
principle of
Hada, my lord, I have explained
My lord, Hada,
in my
Hada only says
it's the parent judgment that
normal
that
circumstances.
yes.
But what is abnormal is the purpose. Where is the perversity?
No,
Is
that
it plausible view or not? My lord, he cannot say. First submission, my lord, that he is saying that it has not been considered in the impugned order. And first of all, he shouldn't be allowed to go to the parent order. He has to show from the impugned order.
I have to show to
Ashun,
So
parent
impugned
order.
order specifically mentioned.
uh,
Is it not there?
heard the Thank you.
Sorry, my lord.
No, I should be saying sorry to you because I have held up. All of you are busy.
No, my lord, we have a matters. Grateful.
Because only one thing, this contested matters, if it is taken up
No, my lord, this is very
within.
important, my lord, because if this falls, then my lord, we can come before the lordship in other matters.
No,
No, I'm sure you can come other. Kindly see. Now also submission. Now also submission.
Why not? I am very happy. I have other matters also.
অন্য করবে না